Morning, everyone, and welcome to Legal Voices, where equity, diversity, and inclusion for us represent the future of law in our legal industry. My name is Tanya DeMello, and I go by Tony, and I'm the proud Assistant Dean of Student Programming, Development, and Equity at the Lincoln Alexander School of Law. Many of you know me as a human rights lawyer who's worked on issues of discrimination, harassment, and sexual violence over the last few decades. I also work with organizations and businesses across Canada, and I focus on the legal industry to support them in making their workplaces more equitable and inclusive, not just for the people working there, but for the clients that we serve and the communities in which we work. I'm really proud to introduce my colleague and co-MC, Sean Richard. He is a creative, forward-thinking and solutions-oriented litigator and partner at Lankinsky, Carr and Richards LLP. Sean's the past president of the Canadian Association of Black Lawyers, which we know as CABLE, where he represented the organization before standing committees and members of provincial and federal parliament to address issues of anti-Black racism and human rights. He's focused and taught trial advocacy at the University of Toronto's Faculty of Law, and he's a published author as well as presenter, which you'll get to see today. He's also been teaching at the Lincoln Alexander School of Law since our inception, and I can tell you I've heard rave reviews from the students. I'm proud to say he's also been a long-standing supporter of the Lincoln Alexander School of Law. He was one of the first founding visionaries behind our EDI conference that was hosted in the law school in 2019. So I'm so happy to be here with him today.
Thanks, Tony, for that warm introduction. I don't know about visionary, but I was part of a partnership between representatives of equity-seeking groups and the Court of Appeal that worked towards achieving the goal of an EDI conference. The first conference now feels so long ago, probably because of this pandemic, but we're all thrilled to see the conference return. And Tony and I are thrilled to be your hosts today. The program is jam-packed, and I know we're all eager to hear our keynote speaker. But first, a word about accreditation and logistics. Okay, so the first thing is today's EDI-focused conference has been accredited for just over 6 hours of professionalism content by the Law Society of Ontario. Please consult the conference website for more details. Second, don't forget to share your questions with our speakers throughout the day using the Q&A box located at the right-hand side of your screen. And you can join the conversation on Twitter using the hashtag LegalVoices and tagging us at Ryerson U Law. This conference would not have been possible without our generous sponsors, BLG, Lankinsky, Carr and Richard, McCarthy Tetro, Blake's, Osler, Manulife, and TD. We thank you all for all of your support and for partnering with us for the Legal Voices Conference. Before we hear from our keynote speaker, we're going to hear from three remarkable speakers who will help set the stage for what promises to be a thought-provoking, insightful conference. The first speaker is Dean Donna Young. Dean Young is the founding dean of the Lincoln Alexander School of Law. Before assuming her deanship, she was the President William McKinley Distinguished Professor of Law and Public Policy at the Albany Law School and a joint faculty member at the University of Albany's Department of Women's Gender and Sexuality Studies. Dean Young has taught courses in criminal law, employment law, U.S. federal civil procedure, gender and work, and race, rape, culture, and law. Earlier this year, Dean Young was recognized as the Canadian Law Awards Female Trailblazer of the Year and as a Top 25 Women of Influence Award recipient. Off to you, Dean Young.
Thank you, Sean. Thank you, Sean. Good morning and a warm welcome to all of you joining us from across the country. Again, my name is Donna Young, and I am the founding dean of the Lincoln Alexander School of Law. We're thrilled to host the Legal Voices Conference, which is focused on advancing action on equity, diversity, and inclusion in our legal profession and justice system. We're so pleased that you've chosen to spend your Saturday with us. With more than 1,000 participants registered for this conference, it's heartening to know that in attendance there are law students, lawyers, judges, members of the broader legal community and beyond, who are committed to spending time today to engage with us and to exchange ideas to discuss equity, diversity, and inclusion. Before we continue, it's important that we recognize the land on which the Lincoln Alexander School of Law operates. Toronto is in the Dish with One Spoon territory. The Dish with One Spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. We know that the oppression of Indigenous peoples is not an issue of the past. It remains ongoing today and is deeply entrenched within our legal system and our other state-run institutions. This land acknowledgement is one small way to pay our respects to the contributions and sacrifices of Indigenous peoples and to raise awareness of the continuation of systemic disruptions, discrimination, and inequities experienced by Indigenous communities. It is also a call for unity. As most of us participating in this conference are members of the legal community, let's take this moment to consider how we can commit to sharing, reflecting, and exploring the ways in which we can participate in reconciliation and advance justice with and for Indigenous communities and transform our legal system. At the Lincoln Alexander School of Law, our aim is to reimagine legal education and help drive innovation in the legal profession. Since our inception, we have been thoughtful in our approach to diversity, equity, and inclusion. Our Legal Voices conference is an important moment for us. The first EDI conference at the law school took place just before my formal arrival at Ryerson as the law school's dean. When I learned of the conference and I was considering the deanship, I knew I had to be part of this law school. Even before the law school had officially opened its doors, before it had hired its first cohort of faculty members, before it had admitted its inaugural class, and before it had hired its first dean, it pulled together an incredibly talented group of lawyers, judges, and academics to dedicate its first ever conference to the topic of equity, diversity, and inclusion. That was pretty bold. And ever since the fall of 2019, it has been abundantly clear to me that our commitment to equity, diversity, and inclusion goes well beyond today's event. I'm proud to share that our law school has recently launched a racial justice initiative, which will bring together a diverse range of voices with both subject matter expertise and lived experience to help transform the legal system and to critically examine the law's role in both perpetuating and addressing discrimination. And through the leadership of our wonderful faculty, we are undertaking an integration of Indigenous legal perspectives into our curriculum. And through our recruitment and admissions process, we are committed to bringing in students who will help diversify the legal profession, because we know that to be truly effective, the legal profession must reflect the diversity of the populations it serves. Today, I welcome all of you to today's conference and encourage you to challenge perceptions, to learn from each other, and to put words into action. At this time, it is my absolute pleasure to introduce to you our conference chair, the Honorable Dr. Chile Ebo Osuji. Dr. Ebo Osuji recently joined the law school as our distinguished international jurist and special advisor to the president. Dr. Ebo Osuji recently completed his term as president of the International Criminal Court, the ICC, in The Hague. He was also concurrently serving as a senior judge in the appeals division of the ICC from 2018 to 2021. Prior to joining the ICC, Dr. Ebo Osuji served as the legal advisor to the United Nations Commissioner for Human Rights in Geneva. And before joining the International Public Service, Dr. Ebo Osuji practiced law as a courtroom advocate before courts in both Canada and Nigeria. Justice Ebo Osuji is also the Paul Martin Professor in Political Science, International Relations, and Law at the University of Windsor, a visiting professor at Stanford University Law School, and a senior fellow both at Cambridge University and at the Kennedy School of Government at Harvard University. At the Lincoln Alexander School of Law, Dr. Ebo Osuji has been sharing with us his extensive knowledge of the international human rights regime, the international humanitarian law regime, the role of international courts, tribunals, and the workings of the international systems, including the UN and its agencies, as well as the International Criminal Court. It is my absolute pleasure to welcome you, Dr. Ebo Osuji, and all of you, please join me in welcoming him. Thank you.
Thank you very much, Dean Young. Any conference whose purpose is to brainstorm the path to greater ethos of equity, diversity, and inclusion is by definition not a festive occasion, yet it is a great honor and privilege for me to be here today in your company. I recently returned to Canada, to Ryerson University, whose name we now know will change because that name no longer sits well with the ideals of a university that has stressed EDI perhaps more than most. When I left Toronto in 1997 to start a new career in the practice of international law, one of the last cases that I litigated in the courtrooms of Toronto had to do with the struggle for EDI. I found myself in 1995 leading a constitutional challenge founded on Section 15 of the Charter against the government of the day's repeal of the Ontario Employment Equity Act, which the previous government had introduced in 1993. In court, we had to deal with the consternation about an unprecedented use of Section 15 of the Charter. The provision, we were constantly reminded, deals with situations where something is put in place that allegedly causes or exacerbates discrimination. The provision had never been used to complain about a repeal, that is, the removal of something. Now, I thought that our problem was easy enough to see. The Employment Equity Act was something of a protective barrier against the forces of discrimination that were systemically and systematically visited upon Canadians with disability, Canadian women, Aboriginal Canadians, and non-white Canadians, to the extent then that the Employment Equity Act was a barrier against discrimination. To remove that barrier was to re-expose the protected groups to the forces of discrimination. So repealing the act did not just remove something, it removed a protective barrier, much like removing someone's coat during a Canadian winter can cause them a very real harm. Though the Employment Equity Act repeal challenge was unsuccessful and was done largely on a pro bono basis, I had to content myself with the consolatory feeling that the case remains one of the most rewarding work that I ever did as a barrister. That was one of my last cases before leaving Toronto. When Dean Young and I were discussing about the possibility of my joining the Lincoln Alexander School of Law at the conclusion of my service at the ICC early on this year, she told me that the law school would be organizing an EDI conference and she would like me to serve as the conference chair. It was, of course, a conference that I must do, though the dean didn't know about my history with the Employment Equity Act litigation in the late 1990s. Now, concerned that the need for EDI means that nothing had changed since the day I litigated the Employment Equity Act case, I thought I was coming back to pick up the EDI struggle where I had left it 24 years before. But I'm happy to see that some gradual changes, some gradual progress has been made. For one thing, as I was about to fly back, I got news that we now have, for the first time, a non-white Canadian on the Supreme Court of Canada, Mr. Justice Mahmoud Jamal, someone I was in school with at McGill. I also heard that Ms. Evie Go, a Canadian woman of Chinese origins had now been appointed to the federal court bench, Madam Justice Go and I were teammates in that constitutional challenge against the repeal of the Employment Equity Act. We have also other non-white Canadians appointed to the courts of superior jurisdiction in Canada by the current government. For that, we must commend the current Prime Minister, who had the moral courage to plainly say that there is discrimination, systemic discrimination in Canada that needed tackling. And more importantly, we see the real effort he's making to make a difference. There remains a long way to go before we see real far-reaching EDI in the Canadian judiciary and elsewhere. But it is right to acknowledge progress, however small and wherever we see it. But now I must introduce a man who has been very supportive of the Lincoln Alexander School of Law and our determination to encourage EDI in greater measures in Ontario. Mr. Justice George Strathey, Ontario's preeminent jurist. He has served as the Chief Justice of Ontario and as the President of the Court of Appeal for Ontario since 2014. Chief Justice Strathey previously served as a judge of the Superior Court of Justice in the Toronto region for 5 years. Prior to joining the bench, he was a civil litigator with renowned expertise in maritime and transportation law. Consummate jurist in his field, he has authored books on maritime law and numerous scholarly papers. With that academic pedigree, there should be a place for him on our faculty as a full-time professor whenever he's done serving on the bench, and I promise to plead that case to our dean when the time comes. The Chief Justice Strathey is a dear friend of the Lincoln Alexander School of Law, and in fact was one of the pivotal forces behind our first EDI conference since 2019, at a time when the law school was being conceived but had not yet been launched. I now welcome Chief Justice Strathey to share a few words and to introduce our keynote speaker. Chief Justice Strathey, over to you. Welcome.
Thank you so much, Dr. Ebo Asuji, and thank you, Dean Young. I'm particularly grateful for the offer of employment, which has been an issue that's been troubling me for some time, and I'm honored by that offer. Before introducing our distinguished guest speaker, I'd like to add a little bit to what has already been said about the origins of this conference. 3 years ago, back in 2018, Sean Richard and I, and as you know, Sean Richard was then the president of Cable, we started talking about issues of race and discrimination, issues of unconscious bias, judicial education in relation to racial issues, marginalization of racialized lawyers, mentorship, and the need to address issues of racial discrimination throughout the law school curriculum. We soon added to our discussion some judges of the Court of Appeal and members of the bar, as well as representatives from various diversity associations. 3 members of our working group, Sean, Faisal Mirza, and Michael Doy, now Justice Doy, began approaching law schools to see whether they would sponsor a conference with the themes of equity and diversity in the legal profession. As you know by now, Ryerson University, which then did not have a law school, sprung to the front and willingly and enthusiastically embraced the idea, recognizing that the conference of this kind would align with the objectives of the law school that was very much in the planning stages. Anver Salucci, who was then at the time the acting dean of the nascent faculty, embraced the concept and put the university's resources behind the idea. And in November of 2019, the university sponsored the first conference on legal practice and equity. The conference was an enormous success in allowing the exchange of rich and provocative views amongst law students, lawyers, academics, and judges. And now here we are, 2 years later, about to embark on a second conference. I don't need to tell you that it's been a tumultuous and difficult 2 years, a time when issues of discrimination and racial inequality have come to the very forefront of public discussion. Events in the United States and in Canada over the past 2 years have sparked global movements demanding equity, racial justice, and reconciliation. And this conference then takes place in that context, the context of our previous discussions and the context of the tumultuous times in which we found ourselves. I must say, I think we can all be proud of the progress that has been made, but there is still greater progress to be made. In that context, then, I'm just delighted to introduce your guest speaker, my former friend and colleague, the Honorable Mahmoud Jamal, who is, as you well know, the newest member of the Supreme Court of Canada. Justice Jamal was appointed to that court, fittingly, I think, on Canada Day of this year. Prior to that time, he was a deeply respected and admired colleague of mine on the Court of Appeal for Ontario, where he had served since 2019. Before his appointment as a judge, he served as a litigator at the firm of Osler, Hoskin and Harcourt, and had the distinction, I think, of appearing in trials and appellate courts all across Canada, including 7 provinces of Canada, and he had 35 appearances at the Supreme Court of Canada. He practiced law in appellate litigation, constitutional and public law, class actions, and commercial litigation. He chaired his firm's national pro bono program and was the director of the Canadian Civil Liberties Association, the Advocate Society, and the Osgood Society for Canadian Legal History. He also taught constitutional law at McGill and administrative law at Osgood Hall Law School and published widely on a variety of subjects. Justice Jamal was born in Kenya and raised in England before moving to Canada as a teenager. He received his law degree from McGill and a Master of Laws from Yale University, and served as a law clerk both on the Court of Appeal of Quebec and the Supreme Court of Canada. As has already been observed, Justice Jamal is the first non-white person to serve on the Supreme Court of Canada. If you've watched anything going on at the Supreme Court recently, you will know that he's an extraordinarily insightful, wise, attentive, and talented judge. In the words of his Chief Justice Wagner, he is simply a natural for this position. There is no better person to set the stage for today's conference than Justice Mahmoud Jamal, and it is my great pleasure to welcome him on your behalf.
I would like to begin by thanking Chief Justice Strathy for his very kind introduction. In this profession, each of us needs a mentor at every stage of our career. I am lucky and proud that Chief Justice Strathy was one of my mentors when I was a justice at the Court of Appeal for Ontario. He's still my mentor and stands as an exemplar of everything I aspire to be as a judge. I'm also very honored to share the virtual stage with the Honorable Dr. Chile Ebo Osuji, the former president of the International Criminal Court and now the distinguished international jurist at the Lincoln Alexander School of Law. Few have done as much as Dr. Ebo Osuji to uphold the rule of law on a global basis. I know that this university and Canadians across the country are honored and grateful that after a career a distinguished career in international public service, Dr. Ebo Osuji returned to Canada to share his deep wisdom and experience with the next generation of Canadian law students and lawyers. My topic today is diversity in Canada's judiciary. Now, you may be thinking, why another talk on the importance of diversity? Well, my answer is simple. Although there may be an emerging public consensus on the importance of diversity in Canada's judiciary, I share the view of those who say that we must keep talking about this issue. We must keep making the case until the judiciary and the legal profession appropriately reflect the diversity of the Canadians they serve. I also agree with those who say that talk alone is not enough. We must take concrete action institutionally and individually to make diversity a reality in our profession. In my remarks, I will explore the three main rationale for diversity in the Canadian judiciary. In doing so, I'll draw on the published reflections of the first three female justices of the Supreme Court of Canada, Justice Bertha Wilson, Justice Claire Leroux-Dubé, and Chief Justice Beverley McLachlin. I'll also review some of the progress made in enhancing diversity on the federal bench. So let me begin with the rationale for enhancing diversity in Canada's judiciary. Judges of the Supreme Court of Canada have been supporting greater diversity in the judiciary for over 30 years and have sometimes stoked controversy doing so. Justice Bertha Wilson famously made the case for greater gender diversity, calling for more women on the bench in her Betjeman lecture at Osgoode Hall Law School in February 1990, during her last full year on the court. In the title of her speech, Justice Wilson asked what was then considered a provocative question: will women judges really make a difference? Many of us have read that speech at some point, but it is worth rereading it today. The speech largely consisted of a review of the scholarly literature and the perspectives that women bring to the role of judging, the role of identity in judicial decision-making, and how women's perspectives and identity fit with the traditional idea of judicial independence and impartiality. For the most part, Justice Wilson was careful not to venture any opinion. She raised questions instead of answers, although there is little doubt about her views or intended message. Rereading the speech today, like others, I am struck by how moderate her observations were. She articulated what many today would consider essential truths and unquestioned orthodoxy. Some scholars have noted that the most provocative dimension of the article might well be the title. Yet at the time, the speech set off a firestorm of controversy, and the press erupted into a furor, according to Justice Wilson's biographer, Ellen Anderson. Within a week, a complaint was lodged with the Canadian Judicial Council seeking Justice Wilson's removal from the bench for allegedly expressing feminist views and violating her judicial oath of impartiality. Anderson notes that Justice Wilson's speech took courage because of the potential redefinition of the traditional value of judicial objectivity and neutrality which the feminist stance entailed, even though Justice Wilson herself had insisted that she did not know if women judges would make a difference. She was merely willing to raise the question. Later, justices of the Supreme Court have continued to call for greater judicial diversity, including, among others, former Justice Claire Leroux-Dubé, former Chief Justice Beverley McLachlin, and the current Chief Justice Wagner. Judges at all levels of court across Canada have echoed their calls to action, including Chief Justice Strathy. In essence, there have been three main arguments for greater diversity in Canada's judiciary. First, judicial diversity enhances the judiciary's institutional legitimacy. Second, judicial diversity improves the quality of decision-making. And third, judicial diversity is important because public institutions must be open and must be seen to be open to all Canadians, and especially to young Canadians. I'll say a few words about each argument. Many eminent Canadian judges have endorsed the first argument for judicial diversity, that judicial diversity improves the judiciary's institutional legitimacy by enhancing public trust and confidence in the justice system. One of the first to do so was Justice Wilson herself. In her famous paper, she cited the American judge Gladys Kessler to the effect that the ultimate justification for deliberately seeking judges of both sexes and all colors and backgrounds is to keep the public's trust. The public must perceive its judges as fair, impartial, and representative of the diversity of those who are being judged. Justice Wilson also noted Justice Patricia Wall's view that women judges are indispensable to the public's confidence in the ability of the courts to respond to the legal problems of all classes of citizens. Over 20 years later, Chief Justice McLaughlin said that there is value in people seeing a bench that includes at least some people like them. She noted that representativeness in this sense is about ensuring that the public sees itself reflected in the judiciary. It is about legitimacy and public confidence. Chief Justice McLaughlin acknowledged, in her words, that many people, particularly women and visible minorities, may have less than complete trust in a system composed exclusively or predominantly of middle-aged white men in pinstripe trousers. They will question whether such a court can reflect the various viewpoints and values of an increasingly pluralistic society. She also accepted that while it may be impossible to have a bench that perfectly mirrors society in all its diversity, nevertheless, if great segments of the population are excluded or represented only by the occasional token judge, public confidence in the administration of justice may suffer. In her view, therefore, diversity on the bench can only enhance the credibility of our justice systems and the repute of the administration of justice. Chief Justice McLaughlin elaborated on this view in her memoir, Truth Be Told. There she said that the courts belong to the people and should reflect the people. No one should be obliged to go before a court that seems distant and alien, a truth that applies not only to women as judges, but also to minorities, including Indigenous peoples who have felt that the courts are not theirs, that they don't represent them or understand them. She urged that what we need now is a diverse representation on the bench. She said it may take time, but we should do all we can to get there. Chief Justice Richard Wagner has echoed this view. In 2020, he stated that all Canadians should be able to see themselves reflected in their justice system, that justice should not make a person feel like an outsider or an other when they confront it. He repeated this message earlier this year, emphasizing that when judges reflect the makeup of society, this builds public confidence in the justice system. Why is it so important to have public confidence in the justice system? Let me cite two responses, both of which hold that public confidence is the ultimate repository for the authority and the legitimacy of the judiciary and the law. A first response is provided by Chief Justice McLaughlin. She cited US Supreme Court Justice Stephen Breyer, who argued that the public ultimately accepts and follows the decisions of the judiciary, a body he described as inoffensive, technical, and comparatively powerless because of public confidence in the judiciary as an institution. A second response is provided by Chief Justice George Strathey just a few weeks ago in marking the opening of the courts of Ontario for 2021. In addressing the role of public confidence in maintaining the rule of law, Chief Justice Strathey cited the 2019 Wreath Lecture Series of former UK Supreme Court Judge, Lord Jonathan Sumption. Lord Sumption argued that people obey the law partly, but not even mainly, because of the fear of punishment, but rather because they acknowledge the legitimacy of the law. He defined legitimacy of the law as a collective instinct that we owe it to each other to accept the authority of our institutions, even if we don't like what they are doing. It depends on an unspoken sense that we are in it together, Judicial diversity thus enhances the judiciary's institutional legitimacy by ensuring that those who judge Canadians reflect and represent those who are judged. By doing so, judicial diversity builds public confidence in the justice system. It helps cement the sense that we are all in this together. That constitutional democracy is a collective enterprise in which there is room for everyone at the table. Canadians willingly accept the decisions of those who judge them, even if they do not always agree with particular decisions. They do so because they respect the institution of a diverse and representative judiciary. A second rationale for judicial diversity is that it leads to better and more informed judicial decisions. In a word, to better justice. Some may view this claim as difficult, if not impossible, to establish empirically, given the principle of deliberative secrecy. But it is noteworthy, I think, that each of the first 3 women justices appointed to the Supreme Court embraced it wholeheartedly. For them, gender diversity on the bench undeniably enhances the quality of justice by bringing different perspectives to the task of judging. So in her Betjeman lecture, Justice Wilson mused that women judges and lawyers might make a difference by drawing on their different perspectives on life to bring, quote, a new humanity to bear on the decision-making process. She said that in this way, they might succeed in infusing the law with an understanding of what it means to be fully human. Justice Wilson did so herself in many cases, including famously in the Queen and Lavallee, a few months after her lecture, by allowing evidence of battered woman syndrome to be relevant to self-defense in criminal law. She drew on what Professor Colleen Shepherd has called abused women's experiential knowledge. Justice Wilson had also done so 2 years earlier in the Queen and Morgentaler, involving the unconstitutionality of Canada's former criminal law restricting access to abortion. And there she said that it was probably impossible for a man to respond, even imaginatively, to the dilemma a woman faces in deciding whether to terminate a pregnancy, because it is outside the realm of his personal experience, and because a man can relate to the decision only by objectifying it, thereby eliminating the subjective elements of the female psyche which are at the heart of the dilemma. For Justice Wilson, the lived experience of a woman judge is a unique and essential reservoir of perspectives to draw on when judging. Just over 7 years after Justice Wilson's Betjeman lecture, the second woman to sit on the Supreme Court of Canada, Justice Claire Leroux-Dubé, made similar observations. She said that women's diverse experiences have been sadly lacking in many areas of the law and highlighted the need to incorporate them in our judicial decisions. She did so herself in many areas, ranging from taxation to criminal law. She also explicitly broadened the range of relevant diversity, stating that in making a difference, judges cannot only be concerned about women's reality, but also about the varying and diverse experiences of children, men, people with disabilities, people of color, people who are poor, members of Canada's First Nations, and all other types of human experience which may form the background against which the law is applied. The third woman to sit on the Supreme Court of Canada, Chief Justice Beverly McLaughlin, concurred. In 2012, she remarked that diversity on the bench is a useful way to bring different and important points of view and perspectives to judging. Diverse perspectives, she noted, enrich the judging process and may lead to better decisions. She described how she had seen deliberations take on a new turn because of the perspective brought by a woman to an issue involving a woman. She had also seen court culture change as the number of women on the Supreme Court of Canada had increased. Chief Justice McLaughlin developed some of these ideas in her memoir. She said there that perspectives matter. In describing some of the lessons she had learned from the case of Tremblay versus Daigle, involving whether a father could obtain an injunction to prevent a mother from having an abortion, she noted that judges of different backgrounds and genders ensure a deep and full discussion that gives due weight to the concerns of each party. She warned that one of the dangers judges face is that they may overlook or treat too lightly a particular fact or situation. A balanced bench, she said, guards against the problem of missing perspectives. I think the nature of the judicial function also helps explain why judicial diversity enhances the quality of judicial decision-making. To quote Justice Wilson again, a judge's role involves an exercise of judicial empathy. In her view, a judge must enter the skin of a litigant and make his or her experience part of your experience, and only when you've done that to judge. Chief Justice McLaughlin gave this exercise of judicial empathy a name. She called it conscious objectivity. She described it as an act of the imagination that involves a judge putting themselves in the shoes of the different parties and thinking about how the issue looks from their perspective. Not surprisingly, there are different views on whether a lived experience of diversity is essential to undertake this act of the imagination required by conscious objectivity. Justice Wilson's comments in Morgenthaler to the effect that it's probably impossible for a man to respond even imaginatively to the dilemma a woman faces in making decisions about her reproductive life because it's outside the realm of his personal experience suggests that a lived experience may be essential in at least some cases. By contrast, Justice Laura Dubé highlighted that neither men nor women form a monolithic or homogeneous group, and that different women judges have approached the concerns of women in different ways. She also described how some male judges, such as Chief Justice Brian Dixon and Justice Jean Betts, were extremely gender sensitive and deeply understood the issues women face. For her, the import of this is that everyone who is in a position of power is bound to make a difference. We all have a shared responsibility to understand the perspectives which differ from our own and to reflect these in the law, particularly where these have been met in the past with dismissive or stereotype-driven responses or simply with silence. Justice Laura Dubé therefore emphasized that what we must seek is to develop an increased sensitivity on the part of all judges to the diverse human experiences which are presented to the court on a daily basis. At a time when our courts are increasingly confronted with concerns of systemic racism, racial profiling, stereotyping, unconscious bias, and other forms of discrimination, it is all the more important that judges reflect the diversity of the affected Canadians who are raising these important legal issues before the courts. As judges, we are also responsible for becoming and remaining more culturally competent. Any judge who has been a member of an appellate or collegial court, where judges decide in panels or groups of 3 or more judges, will tell you that they make better decisions when they are informed by the diverse perspectives and life experiences of their colleagues, whether they be women, Indigenous or racialized persons, or members of other diverse groups. This takes me to the third rationale for judicial diversity, which is that it allows Canadians, and especially young Canadians, to see that public institutions are open to them and that they too can aspire to hold important positions of public office. Although, of course, this promotes the institutional legitimacy of the courts, I think it is a sufficiently important and distinct consideration to warrant separate mention. This point was emphasized by former Ontario Chief Justice Roy McMurtry in a speech he gave in 2007. He explained that a diverse bench allows society, and especially young people, to see minorities excelling in every area of important human endeavor. Or, in the powerful words of children's rights advocate Marian Wright Edelman, you can't be what you can't see. There is perhaps no better example of this than the appointment of Beverley McLachlin as the first female Chief Justice of Canada. In her memoir, Chief Justice McLachlin chronicled her life from modest beginnings in rural Pincher Creek, Alberta, to law school in Edmonton, to law teaching in Vancouver, and ultimately to the office of the Chief Justice of Canada. As the third woman ever to sit on the Supreme Court, she deeply understood the significance of her nomination to women and to girls. On the day of her swearing in as a judge of the Supreme Court, she reflected on how her nomination was a moment of pride, tempered only by the thought of how many women in decades past had been denied the immense privilege of sitting on the country's highest court. Then, about halfway into her first decade as Chief Justice, she described how she had a eureka moment. She realized that being chief wasn't just about the Supreme Court of Canada, however important that was. The people of Canada viewed the Chief Justice as their Chief Justice. She recounted a story that she would often hear at the court's open house, at public events, or even at the grocery store checkout line. A father would take his daughter's hand and say, "See, that's the Chief Justice. You can do that too." She said she would look into the daughter's shining eyes and realize that just my being there, a woman in the third highest position in the land, was of huge importance. She said, "I came to see that perhaps the most important takeaway from my time as Chief Justice would be that I, a woman, had been there and had spoken out for the values I cherished." Chief Justice McLachlin candidly acknowledged the challenge of being a symbol and source of inspiration to many. She said that being the first can sometimes be daunting, that everyone is waiting and watching, some rooting for you and some secretly hoping you'll fail. And the future of those who follow rests on how you fare. To sum up, in Canada today, a diverse judiciary is essential. Diversity improves the judiciary's institutional legitimacy, it enhances the quality of judicial decision-making, and it conveys to all Canadians, and especially to young Canadians, that public institutions are open to them and that they can and should aspire to judicial office, including the highest judicial office in the land. These claims have implications for the relationship between judicial diversity and merit. Merit is not evaluated first, separate and apart from judicial diversity, with diversity coming into play in judicial selection only as a tiebreaker once there is a short list of people of merit. Rather, diversity in all its forms is itself a component of merit. In the words of Chief Justice McLachlin, we should only appoint people of merit. We must never compromise on the quality of judges that we appoint, but she was quick to add, merit must be understood in the sense of ability to do the job and in full appreciation of the diverse perspectives and legitimacy that judges from diverse backgrounds bring to the bench. When we understand merit in this way, she said, we open the door to appointing women and minorities and to building a judiciary that is a more accurate reflection of the society it serves. So where are we today regarding judicial diversity in Canada? Significant progress has been made in the last 30 years. In 1990, when Justice Wilson gave her famous speech, just over 9% of federally appointed judges were women. By 1997, 7 years later, Justice Laura Dubé noted that the number had risen to 12%, with the proportion of women represented in new judicial appointments growing at a higher rate than ever before. Neither Justice Wilson nor Justice Laura Dubé cited data on the proportion of Indigenous or racialized judges, though the numbers were no doubt small. By 2012, another 15 years later, Chief Justice McLaughlin noted that the number of women judges had now risen to about 32%, with 4 women on the Supreme Court of Canada. Chief Justice McLaughlin herself, Justice Marie Deschamps, Justice Rosalie Abella, and Justice Andromache Karakatsanis. She remarked, however, that while Canadian judges belong to various religious and linguistic groups, we are very largely Caucasian. Today, according to data published by the Office of the Commissioner for Federal Judicial Affairs Canada, that's current as of November the 1st, 2021, about 44% of the federally appointed judges across Canada are women. Of the 1,198 federally appointed judges, 526 are women, with 37 current vacancies. Canada is finally on the cusp of gender parity on the federal bench. According to the Commissioner's data, in 2016 and 2017, a majority of both new appointments and elevations to courts of appeal were women. Women now form a majority of the appellate judges on the courts of appeal of Alberta, Manitoba, and Newfoundland and Labrador. More judges are also being appointed who are Indigenous, racialized, LGBTQ2, or who identify as having a disability. Because I've not seen aggregate data in these categories, it's hard to evaluate how Canada is faring nationally, although the proportion of Indigenous and racialized judges still lag the proportion in the general population. Although we're still a distance from having a judiciary that appropriately reflects the diversity of all Canadians, I think it's fair to note, as Chief Justice Wagner did in his end-of-year news conference in June 2021, that across Canada, our courts are more diverse than ever. In closing, I again wish to quote Justice Wilson's famous speech. She stressed that bringing about change is the shared obligation of everyone in the legal profession. She emphasized that it would be a Pyrrhic victory for women and for the justice system as a whole if changes in the law come only through the efforts of women lawyers and women judges. Justice Laura Dubé echoed this concern. She said that it is the responsibility of the entire legal profession to develop the awareness needed to listen to and understand those voices which are different from our own, whether of judges or those who come before us seeking justice. In her words, we cannot place solely on women judges and others belonging to groups which are underrepresented in the judiciary the burden of understanding and responding to the concerns of those who have met with insensitivity in the law. Reflecting and understanding the rich diversity of Canadians is thus the responsibility of us all. The project will only succeed if we each do our part. It's been a great privilege to speak to you today. I would like to thank the Lincoln Alexander School of Law for inviting me. Thank you all for listening.
Thank you very much, Justice Jamal. That was a truly magnificent speech, very well done. And on behalf of the conference, in my capacity as the conference chair, I say we are truly grateful to you for coming and really delivering that very hopeful speech. Now, as I mentioned earlier, Justice Jamal and I were at McGill at the same time, and it was truly something to behold his formal swearing in about 3 weeks ago, I think it was. It was a true carnival of encomia, all very well deserved. When he was appointed, I in the rhapsody of the moment, I tweeted out saying, look, it is impossible to find a Canadian lawyer of any race who's better qualified for that appointment. As I said, it was in a moment of rhapsody. Had I reflected more carefully, the tweet would have been, it would have been impossible to find a Canadian lawyer of any race in any era who would have been more qualified for that appointment. Now, we know him. His first name is Mahmoud M, but that M would also stand for modesty. He will tell you, don't mind Chile. But before he does, I'll tell you, don't mind him. But we're going to leave it at that and open, take your questions as they come. Please, we know that you can ask me anything you want. I'm no longer a judge on the bench, so I'm now an academic. I can speak freely, but Mr. Justice Jamal is still a court sitting in the highest court of our country. So we will keep that in mind as we direct questions at him and us. Let me now, it's my job to chair this section. The first question we have is this: is given the importance of diversity in Canada's judiciary, what do you say about the absence of Indigenous judges on Canada's Court of Appeal, only one judge, or the Supreme Court of Canada? That's the first question.
Well, of course, I have called for diversity in all its forms, and that includes obviously Indigenous judges on courts at all levels in Canada. That's an extraordinarily important perspective to have on the bench. The government has obviously stated that that's a priority that it shares, and the chair of the Independent Advisory Board, the Right Honourable Kim Campbell, has also stated that that's a priority, and that they've encouraged, the board has encouraged Indigenous applicants. So obviously the selection of a particular Indigenous individual to any particular position is an issue for the government in terms of who should be appointed. But certainly, I think as a priority, I like all Canadians, I think share that priority, and would welcome the perspectives that an Indigenous judges bring to the bench. So I certainly share that concern and that priority, and would welcome it.
Thank you. The second question we have, and I think I can take a crack at this, and then Justice Jamal can come in as well. The second question is, how can we help by being just members of society and not being in the legal field? That's the question. Let me go first on this one. When the question says just members of society, perhaps it's important to stress that Canadian citizens are not just members of society. The legal profession does not belong, or the legal field, as the question is stated, does not belong to lawyers and judges alone, belongs to all Canadians. After all, the law is meant to regulate the affairs of society. So to say that the Canadian citizen has a stake in the shape of our society, how we want it to be. If we want more diversity, we have a stake in making that happen. And there are different ways of doing that. I do not have all the answers, but I do know that citizens speaking up on issues of importance to them and staying with it, staying at it, speaking up until corrections are made, to help in the end to make the needed corrections. So people should not feel that, well, because we are not members of the legal profession, we haven't got a role to play, or our voices wouldn't matter. No, they do. Judges and lawyers do listen to the feelings of Canadians and match them against what we know. That would be my take on that, and I'll leave it to you, Justice Jamal.
Well, I think there are many things that we can do. Those of us that are parents can talk with our children about these issues, about about the importance of diversity, about discrimination. Unhappily, there have been many occasions over the last few years, many years, but particularly over the last couple of years, to talk about these issues with our children and to educate them about discrimination, the history of discrimination, what unconscious bias is, what systemic discrimination is. These are all topics that we can talk with our children about so that they gain a deeper understanding. That's certainly something that I've done and my wife has done with our children. And I think it's extremely important because that is, people have to grow up with an understanding and combating. There are many ways to combat discrimination, but one of them is education. And I think educating our children appropriately is enormously important.
Thank you very much. That will be all we have for this. We are pressed for time, and there's a day packed full of programs. So I'm now going to hand it back to the MC, Tony, Professor De Mello, if you can take it back, please. Thank you very much, everyone. It's been an honor to be with you.
Thank you.
Thank you so much, Honorable Aibo Suji. We were filled with so much joy when we learned that you were going to come and be joining our faculty, and it's been such an honor to have you here. Justice Jamal, we are so incredibly grateful for your time and your perspective. I can tell you that the fact that you started by saying talk is not enough and showed us historically how the entrance of women into our most senior judiciary in this country has had such a lasting and important impact on the lives of so many people. I will tell you as well that as we watch your work, we are rooting for you. We are watching and we're waiting and we are rooting for you. And I think the hope of most people is what you described, that a balanced bench will guard against the problem of missing perspectives, and that you will bring a perspective, not just because of your identity, but because of all of the experiences that you've come to understand through your work of racialized Black and Indigenous people, that it will not just be your presence, but the experiences of and agendas of these people that you will push forward so that it can be heard in the Supreme Court. And I thought, as you were talking about women in the judiciary, about how interesting it was that as we reflect historically, we see that what is now to us very moderate requests, demands, pleas, was seen as so radical in that time and caused so much controversy. And I think more locally about the statement of principles and what came out of that, such a simple, bland statement in my mind about supporting equity in a community and what outcrop that had. And so we look eagerly and keenly to see all that you do, and we really are rooting for you. Thank you for coming today. So we're also going to take a short 10-minute break now. And so it's about 7 minutes. So folks can be back at 10:10. We're going to be showing a video, but please have a coffee, beverage, and we will head into our first plenary for the day. Thank you.
I think innovating the legal profession is really just about making sure that the legal profession looks like the rest of the world. For a very long time, lawyers did not look how I look. There's been a global reckoning that things need to be different, and there is a whole new generation of future lawyers, of link lawyers, who are ready to take the steps to do that. And I mean, we'll put in the work and you can follow our path. I hope to change the way that we think about the law, and it's not just a case file, it's a human being behind that. And when you have a bit of humanity and you can understand that, even without the lived experience, I think that that's important.
There needs to be more trust. There needs to be more trust in the legal system, because right now there isn't. For too many years, the law has worked against Indigenous peoples. It's worked against minorities more than it has worked for them. If we're really going to see innovation in the legal system, it starts by breaking down these existing barriers that have been in place for so long. It can't just be a singular effort. It requires multiple lawyers to carry on this vision and turn it into actual change. My fellow students and cohorts, they all share that same vision too. One person can make change, but to make meaningful change, it requires a more group team effort.
Importance of redefining normal in a post-pandemic world. Moderating this important conversation is Lincoln Alexander Law's Professor Jennifer Orange. Before joining the law school, she was a postdoctoral fellow at the University of Toronto, a member of the Human Rights Tribunal of Ontario, and a litigator at Tories. Professor Orange's expertise includes human rights, international law, and social legal studies, and she is a part-time member of the Canadian Human Rights Tribunal. And now, Professor Orange will introduce the panelists and kick off this discussion.
Good morning, everyone, and welcome. Thank you so much, Sean. We are so grateful for the opportunity to meet today in Dish with One Spoon territory, and I am honored to moderate this session on redefining normal in a post-pandemic world. At the outset, I want to note that as we talk about life after the pandemic, we sit here still in its midst. We are making excellent progress, but we are not there yet. So please follow the public health guidelines, get vaccinated if you are able, be kind to yourselves and to those who take care of our health and provide us with basic services. Throughout the pandemic, I have heard friends, family members, colleagues, and students all say, I just can't wait until we get back to normal. It is natural to miss the opportunity to gather in person, to share a meal at a small table, and to be together without masks. We crave the ability to live without fear. But as Dion Brand wrote in the Toronto Star in July 2020, what if fear was entrenched in your life before the pandemic? What if, for example, racism pervaded your day-to-day experiences? Why would you want to return to that normal? In addition to the fears and inequities people experienced before the pandemic, just surviving the pandemic has deepened inequities from which there is no off switch. For example, women have had their lives and very beings disrupted in ways that will require substantial support in order to recover, in particular if they are the parents of school-age children. The Center for Addiction and Mental Health's COVID-19 study has consistently found that women are more likely to experience anxiety, depression, and loneliness than men, although men are also suffering during the pandemic. The precarious nature of women's work and extra burden of child and elder care speak to gender inequalities that existed before the pandemic and were exacerbated by the eruption of the virus. You do not have to look far to find a female law student, law clerk, lawyer, or judge who will tell you about the extra burdens they have borne this past 18 months. Yet, some may also add that working from home reduced commute times and allowed them to spend more time with their families or taking care of themselves. As we look to emerge post-pandemic, how do we retain the advances made for some while rejecting the past experiences of quote-unquote normal that marginalize so many? How do we move to reset practices within our legal community and support recovery? Fortunately, today we have an incredible group of panelists to help us work through the experiences of a wide range of diverse communities in an effort to imagine a post-pandemic society that experiences fewer barriers to access and less fear in their day-to-day lives. The full biographies of our speakers are found on the conference website, and in the interest of time, I will introduce them briefly now. To begin, Julia Shindoy is General Counsel, Secretary of the Board of Governors, and University Privacy Officer of Ryerson University. Julia is also a founder and past president of the Federation of Asian Canadian Lawyers and a founding member of the Korean Canadian Lawyers Association. She co-founded the Roundtable of Diversity Associations, which brings together diverse professional associations, and founded the Women's General Counsel chapter of the Women's Law Association of Ontario and Women General Counsel Canada to support senior women in law. Next, we have Khalid Jan Mohammed. He is the inaugural Director, Legal Clinic Programs at the Lincoln Alexander School of Law. Khalid is an experienced lawyer with a professional history in both the Ontario legal clinic system and litigation firms, and a past life in computer engineering. Khalid joined the Lincoln Alexander School of Law from the HIV/AIDS Legal Clinic Ontario, HALCO, where he was Director of Litigation Services and a staff lawyer. During his time at HALCO, Khalid served legal aid clients across most areas of legal clinic law and led HALCO's law reform efforts. Next, we have Dr. Laverne Jacobs, a professor of law at Windsor Law and a former associate dean, research and graduate studies. Dr. Jacobs researches and teaches in the areas of law and disability, human rights, access to administrative justice and administrative law and theory. Dr. Jacobs is the founding director of the Law, Disability, and Social Change Project, which is housed at Windsor Law. She is also the co-director of the Disability Rights Working Group at the Berkeley Center on Comparative Equality and Anti-Discrimination Law. In June 2021, Dr. Jacobs was named Canada's nominee for the UN Committee on the Rights of Persons with Disabilities. Ms. Lauren McDonald is a human rights lawyer and founder of HearView, a social enterprise encouraging communication inclusion at in-person and online events and digital content via captioning and subtitles. Lauren's decades-long leadership, passion, and commitment to accessibility and inclusion are informed by her lived experience as a woman born with profound hearing loss. As one of Canada's top voices in accessibility and disability issues, her approach is grounded in evidence-based research and recognizes the role of intersectionality in people's lives. This year, Canadian Lawyer magazine named Lauren one of its top 25 most influential lawyers in the human rights category. And the Women's Executive Network recognized her in the top 100 of Canada's most powerful women, honoring her with an Inclusion Vanguard Award. Dr. Ronaldo Walcott is professor of Black Diaspora Cultural Studies in the Women and Gender Studies Institute and a member of the graduate program at the Institute of Cinema Studies at the University of Toronto. From 2002 to 2007, Ronaldo held the Canada Research Chair of Social Justice and Cultural Studies at the Institute for Studies in Education. Ronaldo's teaching and research is in the area of Black diaspora cultural studies and post-colonial studies with an emphasis on questions of sexuality, gender, nation, citizenship, and multiculturalism. He is the author of Black Like Who, Writing Black Canada, Long Emancipation, Moving Towards Black Freedom, and his most recent book, On Property, which was shortlisted for the Toronto Book Award. To begin our session, each of our incredible panelists will provide brief opening remarks. We will then have a discussion between the panelists and ensure at the end that we leave time for questions from the audience. Please enter your questions in the Q&A box and we will get through as many as possible. I will now hand it over to our first speaker today, Julia Shindoy.
Thanks so much, Jennifer. Canadians of Asian descent have made significant contributions to our country since the 18th century. My family, which is of Korean descent, has been in Canada since the 1960s. And my partner's family, which is of Japanese descent, has been in Canada since the early 1900s. Our children are fourth generation Canadians. Unfortunately, despite the length of time and generations that Asians have been in Canada, we still deal with racial discrimination. Some have experienced violent attacks, while others have dealt with racist incidents and hurtful microaggressions. The pandemic has brought the ugliness of racism to the forefront. As lawyers, law students, and professionals, I believe we have the power, privilege, and influence to affect social change so that we can combat racism and redefine normal in a post-pandemic world. What can you do? Mobilize, advocate, be an ally. Everyone has a role to play. Picture concentric circles or ripples in a body of water. As a lawyer, law student, and legal professional, your sphere of influence begins at the center, you. Then your workplace, your organization, the legal profession, your community, and the community at large. You can mobilize, advocate, and be an ally in each of those areas, in each of those circles. For example, at Ryerson, we created an advisory committee against anti-Asian racism. An Asian staff and faculty network published the Responding to Hate Toolkit, which is on our website, and organized seminars and conferences like this to bring awareness to anti-Asian racism. In the community, I've worked with other volunteer lawyers on the operation of the Korean Legal Clinic, a grassroots initiative to improve access to justice for the Korean Canadian community through summary legal advice, education, and referrals. Nationally, I, along with 12 other GCs, have established the National GC Network, which is a coalition of senior racialized legal leaders across Canada who are committed to advancing equity, diversity, and inclusion in the legal profession and in our organizations. We have published key questions to ask law firms and suppliers, EDI considerations for board strategies, EDI survey for external counsel, and you can find all this material at nationalgcnetwork.ca. I've also been involved with the National Coalition of Canadians Against Anti-Asian Racism, which is led by Ryerson's Chancellor, Janice Fukakusa. The group produced the amazing video, Eyes Open, an Anti-Asian Racism PSA. And if you haven't seen it, it's available on YouTube. I encourage you to watch it because it covers the history and experience of Asian Canadians and takes a strong stand against racism. All these initiatives have depended on many, including the work of lawyers. Lawyers have provided legal advice, drafted documents, and donated critically needed funds. And law students have also played a strong role in assisting the operation of the Korean Legal Clinic, volunteering with the National GC Network. We've depended on the legal sector. If we mobilize, act, and become allies, we can combat racism, racism against anti-Asian, racism against Asians, and all people of color. And we can redefine what is normal in the post-pandemic world. Thank you.
Thank you so much, Julia. We'll now turn to Khalid Mohammed.
Thanks, Jennifer, and good morning, everyone. As part of thinking through what normal meant pre-pandemic and what it could mean now in post-pandemic, I'll be focusing on 2 COVID-related cases I was part of in my previous role at the HIV and AIDS Legal Clinic, and how these cases intersect with conceptions of normalcy. The first case flowed from concerns for the health of people in federal prisons that arose in the early months of the pandemic in the spring of 2020. There were reports of outbreaks in at least 3 federal prisons, hundreds of prisoners being diagnosed with COVID, and 2 tragically dying. And the number of outbreaks and deaths have since climbed. Physical distancing was impossible. Lockdowns were frequently used to limit physical contact, and visits from friends, family, and lawyers were heavily curtailed. The legal case called most prominently for the reduction of the federal prison population, using already available mechanisms for temporary or exceptional release for medical reasons, because absent that kind of reduction in population, adequate physical distancing wouldn't be possible. During the course of the litigation, some people in federal prisons were released, but the focus of authorities then shifted to vaccination once it became available. The second case flowed from inadequate physical distancing in Toronto's shelter system, which was also apparent in the early months of the pandemic. Despite public health authorities calling for 2 meters of physical distancing as a general rule, Toronto's shelters were allowed to maintain significantly less physical distance between shelter beds. The risk of COVID transmission was high given shared living spaces, and more than 110 people in shelters were diagnosed with COVID by late April 2020. The legal case was started to compel the city to, among other things, implement 2 meters of physical distancing in shelters. These cases raise a number of questions about normalcy, of which I'll highlight two. First, if it was possible to release some people in prisons in response to COVID-related health threats because their release posed minimal risk to the community, why were they in prison at all pre-pandemic? And how does this connect to what we think of as normal forms of responding to so-called crime? Now that prisoners are largely vaccinated and conversations about health risks to them have all but disappeared from mainstream public discourse, will the previous normal carceral and punitive responses once again become the default approach? And second, how did, does, and will our conceptions of normal play into who got and continues to get the benefit of public health responses to the pandemic? And what does this more broadly reflect about how we allocate resources societally and who we think of as worthy of access to resources and safety? In thinking about these questions, I recall the early months of the pandemic, when we so frequently heard the guidance of stay home, stay safe, and maintain physical distance. But the reality is that these mechanisms of staying safe were not available to many people. People in prisons and shelters who are disproportionately made up of Indigenous, Black, and other racialized people couldn't stay home to stay safe. And the institutions governing their living arrangements didn't provide for physical distancing. These realities were often disregarded. So I'll suggest that for a meaningful and equitable assessment of what was, what will, and most importantly, what should be normal, we must turn our minds to the realities of people and communities whose interests are far too often disregarded. Thank you.
Thank you so much for those remarks, Khalid. I now turn to Laverne Jacobs.
Thank you, Jennifer. Good morning, everyone. My name is Laverne Jacobs. I join you from the University of Windsor, which sits on the traditional territory of the Three Fires Confederacy of First Nations. I identify as a Black woman with physical disabilities, and I'm a wheelchair user. The COVID-19 crisis has shown us how susceptible to inequality people with disabilities are around the world. People with disabilities have experienced heightened vulnerability in ways that illustrate systemic discrimination in our legal structures. When we carefully consider the pandemic and people with disabilities in Canada, there are at least two themes that are prevalent. And these two themes arise whether we are looking at the impact of COVID-19 or how to build back better, to use a common expression. The first theme is absence, and the second one is intersection. I use absence to refer to a lack of access to the tools needed to secure disability equality. For example, during the pandemic, there were reports of safety information being provided in inaccessible formats, triage protocols that placed people with disabilities at the bottom of the priority list, and systems that did not allow for access to necessary communication support during healthcare. The pandemic also invited us to think about the ways that students with disabilities can be better accommodated in both pandemic and non-pandemic times, so that they can have meaningful access to education. But beyond actual lack of access, I use absence to denote the non-inclusive policies that lie behind inaccessibility. These are policies that fail to incorporate a disability lens, and as a result, do not bring people with disabilities into the picture or the process during their design. Absence from the design of policies has harmful practical implications for people with disabilities, but there are deeper implications as well. In terms of equality, theorists have discussed the importance of recognition for decades. Martha Nussbaum, for example, speaks of the importance of every individual being treated as a dignified being whose worth is equal to that of others. The space that disabled individuals take up in the world matters and needs to be recognized, especially in contexts of life and death, where arguably this recognition is the most important. As for the second concept, intersection, the pandemic has also revealed a need for us to pay closer attention to the ways in which those who live at the intersection of being multiply marginalized experience disability discrimination. Yet I use the term intersection as well to prompt us to think about the ways in which the pandemic has resulted in different social movements working together. For example, movements against racial injustice have prompted disabled people within racialized communities to voice concerns about racialized people with disabilities. As a final example, intersection leads us to think more deeply about how to ameliorate the conditions of people who live at the intersections of poverty and disability, which is reported by Stats Can as being between 45 and 50% of those living in poverty in Canada. This is not a new intersection, but one that has become more apparent with the pandemic. Absence and intersection seem like contradictory ideas, but I argue that during the pandemic, we saw these two concepts converge and collide through the absence of adequate access and policies and the presence of multiple marginalization. We've seen emerge a stark need to listen to the lived experiences of people with disabilities in order to learn from the pandemic and move forward more equitably. Thank you.
Thank you so much, Laverne, for those remarks. And we'll now turn to Lauren McDonald.
Thank you and good morning. COVID presented a staggering example of ableism, which is favoring people without disabilities. Consider that for years, people with disabilities, or PWDs, had pleaded for accommodations such as working from home and flex time that would enable them to become more productive employees, to no avail. But once COVID hit, we all saw the dizzying speed with which employers transitioned their employees to work from home and the explosion of the use of online meeting platforms. Suddenly, this was no longer a can't be done response to a reasonable accommodation request. Ableism was alive and well. So now that remote work has been proven to be effective, does this mean that all is good for PWDs as employees think about how the return to work will look? My response is an emphatic no. While I acknowledge the many gains for PWDs during COVID, I remind you that the new normal will not be a utopia. We need to remember that the old normal wasn't working and won't be fixed overnight. Yes, remote work does appear to provide greater autonomy for PWDs by removing the need to travel while giving flexibility for pain management and control over one's environment. But at what long-term cost? First, we need to recognize that remote work does not necessarily offer a solution for inclusion and accessibility in the workplace. This is a complex issue that has no simple fix. Further, keeping PWDs in a work from home situation is not a way to sidestep or defer the obligation to make work environments accessible or ignore the need for inclusive employer practices. Instead, this may become a way to silo or segregate PWDs, adopting an out of sight, out of mind view. You don't have to address what you don't see. And disability rights take one step forward, 2 steps back. In addition, working from home means that those already disproportionately affected by isolation will continue to lose connection, impacting their sense of purpose and mental health. The bottom line, for recovery to benefit all people equitably, the voices of the people most affected must be part of the critical conversation. Remote work needs to be presented as an option instead of a solution or alternative to providing accommodation. Thank you.
Thank you, Lauren. We'll now turn to Ronaldo Walcott.
Thank you, Jennifer, and thank you to the Ryerson Law School for inviting me to participate in this conversation. I'm going to try to be slow and clear because the captioners don't have my remarks because they're notes. I want to make 3 points. The first is that many of you would recall that in the early moments of the pandemic, that our Prime Minister and other political leaders, when they realized the magnitude of what we were going to be living through, all insisted that we were going to build back better. Build back better became the slogan. We just had a federal election, and I would ask all of you to think about what Build Back Better as a slogan means in the context of the recent outcome of that election. Indeed, if we went into COVID with an economy where long-term care was under-subsidized in terms of workers' pay, access to steady employment, and so on. If we think about workers in supermarkets, if you think about nurses and cleaners and janitorial staff and couriers, we were faced with thinking about what Build Back Better would look like for those people. The second point that I want to make that's really related to that point is that in the midst of the pandemic, the call and the demand for the collection of race-based data, because it was very clear who was dying in larger numbers from in the pandemic, Black, POC, Indigenous people, that the question of Build Back Better again continues to rebound for us. The Royal Society did a dossier called Impacts of COVID-19 in Racialized Communities in May 2021, and you can find my article and a number of articles that take up the question of the limits of collecting race-based data if policy isn't also going to follow from the collection of that data. So what we know is that COVID did not simply reveal inequality, but it also pointed to the intensification of inequality, and it continues to point to the intensification of inequality. The third point that I will make very quickly that brings these together is that in the moment of COVID, in the moment of the slogan and rhetoric of Build Back Better, in the face of the devastating evidence of who was most being significantly impacted by COVID, that renewed push for EDI ventures came in to stand for how we would address these significant and deadly inequalities. And of course, what was revealed to us is not just, what was revealed to us was a racially stratified workforce where low-paying, dangerous, racialized work where low-paying, dangerous work was deeply racialized, and EDI at the senior levels became something of representation rather than something of justice. So we just went through this election where we're supposed to build back better, but there were no real investments made in community, in people. There were no significant demands for the removal of barriers for non-Canadian qualifications in a number of areas, nursing and so on. We continue to find that various colleges of professions continue to gatekeep, continue to use Canadian experience as modes and practices to keep people out. And we know that our immigration system is hand in hand with that. We also know that in the face of COVID, we went through the summer of the racial reckoning spurred by the death, the very public murder of George Floyd. We saw prime ministers and police chiefs take knees, engage in this symbolic action, while at the same time, those same police forces were over-policing people in poor houses who had to go to public parks, who lived in food deserts and had to travel around on poor public transportation as we had public order mandates during COVID. So what we see in Build Back Better was indeed a fantasy, that Build Back Better continues the status quo. It continues the status quo of multiple violences. And the example I will leave you with is very locally here in my city of Toronto. We see this violence in the continued and repeated evictions of homeless people from parks, but we have seen this in Hamilton, we've seen it in Halifax, we've seen it across the country. So for me then, the fundamental question that when we talk about a normal is that any normal that we might return to is a normal that has to fundamentally rethink the foundations of how we live together. And I leave you with this question: is our leadership up to that actual task? Thank you.
Thank you very much, Ronaldo, and thank you to all of our panelists for these thoughtful remarks. They've given us a lot to think about, and so let's dive into some questions now. In each of the remarks given by our panelists, they identified inequalities and discriminatory norms that existed before the pandemic hit. The reality of the pandemic not only increased many of these disparities, but shed new light on old problems. I want to begin by exploring what the crisis has taught us, and then we'll discuss ways that we can work to ensure that we don't move backwards to a state of normal that was insufficient in the first place. Let's start with Laverne. What were some of the biggest challenges for students with disabilities before the pandemic, and how did they change in March 2020?
Thank you, Jennifer. There are several challenges, but I would say that the biggest challenge faced by students with disabilities before the pandemic was stigma. This is a widespread problem affecting all students with disabilities, but I'll focus on students with disabilities in the post-secondary context, and particularly in law schools. Stigma didn't go away during the pandemic, but there were some changes in teaching practice that assisted students to some extent, and I'd like to see them remain. I think that as legal educators and members of the legal profession, we need to fight the idea that students with disabilities are receiving unfair competitive benefits when they receive accommodations. Instead, we should be focusing on the idea of how to support our students, all of our students, including by providing the accommodations that disabled students need. This is in keeping with the 2012 Supreme Court of Canada decision in Moore, which held that students should have meaningful access to education, and that support should be provided to enable students with disabilities to receive an education on an equal basis with others. Moreover, when the stereotype that students with disabilities are simply seeking an unfair advantage through accommodation requests is portrayed by classmates of students with disabilities, it's important that as faculty leaders, we correct that image. One very concrete impact of stigma is that students with disabilities may see their accommodation needs undermined. Professional views on accommodations can be second-guessed, and when students articulate their accommodation needs, often to provide further detail, this information from their lived experiences has sometimes been disbelieved. Thank you.
Thank you. I really appreciate the answer and pointing out how we can support our students with disabilities. Lauren, I'm going to turn to you next. COVID has brought about increased awareness of EDI initiatives, and many organizations are creating new EDI initiatives. But how have these initiatives impacted people with disabilities?
Thank you for the question, Jennifer. So diversity, equity, and inclusion became hot topic during COVID in the wake of social movements that brought about a long overdue reckoning. The focus remains on the BIPOC communities who have also faced the lack of representation in the workplace. So companies are scrambling to come up with better talent strategies and improved workplace cultures to support diverse employees. However, it may shock you to learn that even in this moment of inclusiveness, of the 90% of companies that claim to prioritize diversity, only 4% consider disability in those initiatives. The word disabled means many things, not just people in wheelchairs. It includes those with visible, invisible, cognitive, and episodic disabilities, as well as mental health issues and addiction. Moreover, disability isn't a singular experience. People of all races, genders, sexual orientations, nationalities, religions, incomes, and social classes have disabilities. A recent Forbes article noted that including disability in EDI activities is essential for making these efforts truly diverse, equitable, and inclusive. But unfortunately, disability is too often either left out of EDI initiatives or shortchanged, tacked on as an afterthought. There is no rational excuse for this. Those responsible for EDI initiatives, now that they know better, must simply do better. Thank you.
So well said, Lauren. I want to stay on this concept of EDI initiatives for a moment and turn to Ronaldo. Ronaldo, can you elaborate on how you see our understanding of EDI initiatives in our post-secondary institutions changing?
Thank you for the question, Jennifer. I spend a lot of time thinking about EDI as a practice within higher education, and I've come to believe from everything that I study and look at that EDI has been a radical failure. It's been a failure of imagination, and it's been a failure in terms of transforming the institution. And what I mean by that is that if you look at the way in which EDI has been deployed, first EDI was deployed in a series of offices, LGBT, race and cultural offices, and so on. And then it was moved to the executive level. And at the site of the executive level, EDI then begins to function as one among many other vice presidents or vice provosts, and so on. And what that means is that where action actually needs to happen, which is in the transformation at the level of faculty hires, at the level of administrative staff hires, and so on, it dissipates. So universities, post-secondary education at the level of EDI, often the EDI office is really deployed to slow down more significant demands, or to engage in processes and practices like, committees and investigations that report a year later, 2 years later, when other demands are being made. And so for me, EDI has served its time and its purpose, and we need to transition to other ways of how we're going to actually make the university a more democratic and open space.
Thank you, Ronaldo. I now want to turn to a point that Julia made. Julia, the rise of violent acts against people of East Asian descent brought racism out into the open. In your experience, what seemed like a sudden eruption of hate during the pandemic taught the Korean Legal Clinic and the National GC Network?
Thanks, Jennifer. In order to respond to hate, discrimination, and racism, we have to be organized and we have to be funded. The pandemic underscored the need for an increase in legal support that's culturally and linguistically tailored to community needs. There's a need to fund more research and education initiatives targeted to communities so that the community can advocate for and support change. Thankfully, the Korean Legal Clinic received a small grant from the Law Foundation of Ontario, as well as support from Thomson Reuters, Tories, and McCarthy's. And I want to pay special thanks to Tom Kim, Mitch Fraser, and Godine Sibe, who were wonderful allies. For the National GC Network, we realized as legal leaders of color, we were depended upon to advise on how to respond to hate. I think in order to affect change, you need people working for change inside as well as outside an organization. We realized that we had a special role to advance EDI in our organizations and the profession. We had to continue to push for change inside, and we had to leverage our collective buying power as corporate counsel within the law firms, and suppliers in order to affect change, to ensure that more racialized lawyers are getting the legal work and working on great files.
Thank you. That gives us so many concrete actions we can take. Khalid, in your opening remarks, you spoke of the experiences of some of the most marginalized people in our society, incarcerated persons and clients of our shelter system. I will add residents of long-term care to that list. There have been great efforts made to protect some of the most vulnerable people during the pandemic, but it seems in some ways that the systems were set up to fail. What have you learned from observing the practices of prisons and shelters during the past 2 years?
Well, to answer that question, I think we need to start further back in time, before the pandemic, because we already knew at that time that our housing and prison systems were in crisis. There was deeply inadequate access to affordable and subsidized housing, and we knew that the shelter system was just a stopgap measure in an already broken system. Shelters don't solve housing problems, and we needed to move towards proactive provision of stable housing. The prison system was dangerous, racist, and counterproductive, and there was an extensive body of research and literature demonstrating this. So we needed to move towards restorative and rehabilitative forms of justice. Social assistance provided benefits well below the poverty line, and many workers were not being paid living wages, and we knew that these socioeconomic factors feed into the housing and prison crises. So we needed to move towards basic income programs and adequate wages. And perhaps one of the strongest condemnations of these failing systems was that there was what some have termed a revolving door between shelters and prisons, in reference to extremely high rates of arrest and incarceration among people experiencing homelessness. And the failing systems perpetuated this problem because people without a fixed address were more likely to be arrested, to be denied bail, and to plead guilty to an offense. So when you say that in some ways those systems were set up to fail, I say that's absolutely right. And they were in fact failing before the pandemic. In terms of what I've learned observing these systems in the last 2 years, I'll very briefly share 3 observations. First, I observed that failing and broken systems, unsurprisingly, don't fare well during times of crisis in some of the ways I've described. So the systems that marginalized communities interact with and rely upon have to be progressive and robust to function well through crisis. Second, I observed that there's some cause for hope because we saw mainstream and media attention to what people in prisons and people experiencing homelessness were living through, and we saw critical discourse about how those systems need to change. Third, and perhaps somewhat discouragingly, I observed a return to complacency in regard to those failing systems, as the most acute concerns were somewhat addressed by vaccination, and then observed in some ways a regression. For example, in Toronto, we saw the city spend $2 million to violently remove people from encampments and parks instead of using that money to provide housing. At the federal level, despite past promises from the Prime Minister for more restorative justice and reduction of incarceration of Indigenous peoples and ending solitary confinement, we see the government resisting challenges to mandatory minimums and maintaining majority of them even after legislative reform and ongoing solitary confinement by another name. So that's what I've observed, and to be honest, I'm still reflecting on what can be learned from all of that.
Thank you so much, Khalid. I now want to give some time to questions from our audience. And the first question we have is, as legal practitioners, what role can we play in strengthening access to justice? And I just want to add that as we think about this, are there any actions or practices that were developed during the pandemic that we want to bring forward in our post-pandemic world? Perhaps I'll start with you, Lauren. Would you like to tackle that question?
Because disability is often not part of the larger conversation, I would just really encourage lawyers, the legal profession, to take a look around and see who is around the table, who is silent and who is talking, who can benefit from you using your privilege to amplify voices and to encourage people from marginalized groups to speak up and feel supported, feel safe in doing so. So that's my suggestion.
Julia, do you have any comments to add to that?
My answer is volunteer. Volunteer in your community legal clinic, volunteer in organizations that are committed to advancing EDI, volunteer on a board, volunteer in fundraising efforts, fundraise for organizations. There's just so much you can do, and there's so much needed help because, throughout this conference, we've talked about teamwork, mobilizing people. It takes many, many people to advance EDI.
Thank you. Great points. Laverne, what do you think? What can we do as legal practitioners?
Absolutely. I think that one of the important things to do when we think about law school education is to think more about universal design. So instead of asking students to seek accommodations, we should be thinking as educators of ways that we can create curricula that bring everyone in and that offer alternatives and assignments, et cetera. So that's one thing that I think is definitely important and that I'd like to see.
Wonderful, thank you. Khalid, from your perspective.
Yeah, so I think I'd broaden the question and I'd move beyond access, because accessing justice isn't enough. It has to be effective and equitable justice. And when I think about lawyering, there's a whole body of discourse about how it can be another site of oppression and trauma for folks who've already lived through oppression and trauma. So particularly when marginalized communities and people are accessing legal services, lawyers need to know how to provide anti-oppressive and trauma-informed services. And I think that is training that is often missing. And far too often I've seen in my career that lawyers can be another site of oppression and trauma for their clients. And we really need to move beyond that, because access to a broken system isn't going to solve the problem.
Thank you. Great points. Ronaldo, we have another question that I wanted to toss your way. What do you see as the biggest barriers to a more inclusive society in a post-pandemic context?
Yeah, I think that the barriers are not so much what already exists, but what we need to be doing. I think we have to refuse and reject government that continues to divest itself from being responsible for the largest amount of people within our society. So we have governments that continually talk about tax reductions as opposed to tax increases and as opposed to tax gathering. We have governments that continually devolve their responsibility to the majority of us. And we have to collectively insist that our governments do otherwise, that public resources be reinvested in the people as opposed to siphoned off and continually given to the wealthiest in our societies, that our public resources are no longer continually privatized and so on. So to me, the kind of question of how we build back better is also about what we as citizens, as people, demand from our leaders, and not so much be taken in by what our leaders claim that they're incapable of doing. So the question of changing perspectives, changing priorities, and changing what we value.
Thank you. Thank you, Ronaldo. Laverne, do you have anything to add on this point? What are the biggest barriers to an inclusive society?
I agree with everything that's been said so far. I don't have anything in addition to add at this point. Thanks.
Okay, that's fine. I have another question that Lauren, I think you may want to tackle. The question is, as someone with hearing loss, I have needed and relied on accommodations during my academics. It was always a strenuous task to make sure I received the accommodations that I needed. My question is there an initiative to streamline access to accommodations throughout post-secondary institutions and educate access centers on the many different accommodations for people with disabilities to help people with disabilities to have smoother educational paths?
recognizing the shortness of time and the complexity of the topic, I fully hear what you're saying, no pun intended, with respect to accommodations in post-secondary education. I do know that there are broader associations of services that support students with disabilities across Canada, and those conversations are being held. I can't speak to anything specific because I'm not directly involved with those professional associations, but just continue to have the conversation. And back to Jennifer to wrap up. Thank you.
Thank you so much, Lauren. I want to thank all of our panelists today for the time and the thought that they put into these presentations and for just answering such complex questions so clearly. Julia Shindoy, Lauren McDonald, Laverne Jacobs, Khalid Jen Mohammed, and Ronaldo Walcott, thank you so much for joining us today. We are extremely grateful. Thank you very much, everyone.
Thank you so much. Thank you so much, Professor Orange. What a wonderful panel to start us off. And I moved, what resonated with me so much, basically everything, but a line that Dr. Walcott said of what it means to have to now, as we redefine the new normal, fundamentally rethink the foundations of how we live together as a society. And so thinking about that has been so important, I think, in this panel. We heard several things. We heard that it wasn't that inequality all of a sudden came to be or emerged as a result of the pandemic, but that it was a magnifying of inequalities and failed systems that were already at play in our society, and that they had disproportionate impacts on some of the most vulnerable people in our societies. We also heard all of you as panelists talk about the ways in which institutions and members of these institutions, all of us, have to respond inside and outside of the systems, everything from examining the roles and resources of the people that are undertaking the work in our systems to what we can do as individuals in terms of volunteering and coming together in our communities. I also was most moved by this idea that redefining the new normal was taking experiences and learnings from COVID and from the pandemic that we should have thought about implementing before, but now have hard evidence around how they can be effective to help folks now. Everything from thinking about people that need to be working remotely, people that need accommodations, and ways in which we can not only provide those kinds of offerings to people that are in need of those accommodations, but that in universal design, in giving breaks and thinking about our curriculum and thinking about how we work, everyone will benefit from work that's done more thoughtfully. I will close by saying that the power of holding not only government accountable, but always asking ourselves, as Lauren asked us to do, who's at the table, who's speaking, and who's not being heard or seen at the table, to think about that as we redefine the new normal. I feel like we've gone back in such a quick, it feels like a blender how quickly we've gone back in, and it'll be interesting to see what we actually have learned. So we'll move now to the next panel, and really excited to invite you to our next plenary session. It's entitled Legal Professionalism in Indigenous Practice Areas. And here we're going to try to connect both Indigenous and non-Indigenous lawyers to hear their experience and explore the scope of professional regulation and ethics for advancing reconciliation. We are so excited that moderating this conversation is Professor Scott Franks, who serves as an assistant professor with the Lincoln Alexander School of Law. I have the privilege of working very closely with him, and I can tell you his commitment, his passion, and his dedication, not just to the work, but what he gives in terms of time to students and to advancing in thinking about Indigenous issues and supports within our curriculum has been unparalleled for me. Professor Franks' research include Canadian Aboriginal law, Indigenous legal orders, constitutional law, legal professionalism and ethics, and Indigenous and interdisciplinary research methodologies. He also writes about criminal law and procedure, admin law, and other legal areas relevant to Indigenous settler relations. He's a citizen of the Manitoba Métis Federation and is from Northern Saskatchewan. So just bear with us as we make the transition to the next session. We're going to be starting momentarily. Thank you.
Thanks, Tony, for that introduction. I don't really have much to add for introducing myself. I'm really delighted to invite our panelists today. We have Drew Lafon, Kathy Gerges, Paul Seaman, and Pooja Parmar. And we're going to be exploring EDI in the context of Indigenous legal practice areas, and also discussing the possibility of reform to professional standards of conduct for lawyers. So first, I'm going to introduce our panelists. We have Kathy Girgis. Kathy is a partner at Altius Clear Townshend. Her practice is focused on advancing Aboriginal and treaty rights through litigation and negotiation. And I worked with Kathy at OKT for about 1.5 years, 2 years before coming to Lincoln Alexander. We also have Drew LaFond. He's a partner at MLT Aikens and is also president of the Indigenous Bar Association. Drew provides advice to businesses on corporate structure, finance, governance, and cannabis, liquor, and gaming licensing. He also has extensive experience advising Indigenous clients on governance and jurisdictional issues. Drew was raised in Treaty 6 territory on the Muskeg Lake Cree Nation Reserve and is also of Shuswap descent from the Simquot First Nation in British Columbia. Paul Seaman is a partner at Gowlings WLG's Indigenous and Environmental Law Group. Paul has a national practice and acts on complex constitutional, regulatory, and transactional matters. His Indigenous law practice focuses on projects and transactions where the Crown's duty to consult Indigenous peoples is engaged. He is a citizen of the Manitoba Métis Federation and an active member of the Saskatchewan Métis community. And finally, we have Dr. Pooja Parmar joining us. Dr. Parmar is an associate professor at the UVic Faculty of Law. Her current research focuses on the legal profession, its history, and on ethical lawyering. Dr. Parmar has written on legal ethics and professionalism in the context of reconciliation and has an article called Reconciliation and Ethical Lawyering, Some Thoughts on Cultural Competence. This session today will be organized according to 2 themes. First, equity, diversity, and inclusion in Indigenous or Aboriginal law practice areas, and ethics and legal professionalism in the context of reconciliation. Our first question will be for Drew LaFond, who's president of the Indigenous Bar Association and partner at MLT Aikens. The Indigenous Bar Association provides continuing legal education and advocacy for Indigenous lawyers and legal professionals in Canada. The IBA has advocated, for example, for the use of land acknowledgements in courts, as well as other procedures related to the inclusion of Indigenous legal traditions. Its members have been involved in developing guides for law firms and lawyers who practice in Aboriginal or Indigenous law. In your role as president of the Indigenous Bar Association, Drew, how would you characterize equity, diversity, and inclusion in the context of the priorities of the IBA? How might Indigenous legal orders be relevant to EDI activities?
Thank you for inviting me, Scott, and thank you for asking that very timely question. I think just to give you a little bit of a background as to where I am now and how this informs my response. As a partner with MLT Aikens LLP, I worked in the Calgary office for the better part of 11 years, but myself being a member of the Muskeg Lake Cree Nation and being from Treaty 6 territory, where I'm joining you from here today, I did find it during the COVID times very important to reconnect with the community. And it's now where I'm living and working from right on the Muskeg Lake Cree Nation Reserve, about 45 minutes north of Saskatoon, which has given me the opportunity, like I had anticipated, to reconnect with the community out here. And it's only driven home the point of there's a tremendous gulf that exists between where Indigenous communities are now and where the legal profession itself is at. And my hope is, through the work that I've been doing with the board at the Indigenous Bar Association, is to try to identify some of the factors or intersectionalities which are contributing to that disparity, that disconnect between Indigenous communities, Indigenous legal orders, and where the legal profession is heading. And I can tell you, in the 2 years and some odd months of serving as the president of the Indigenous Bar Association and serving as a partner for 4 years in the firm here, that there are tremendous challenges that lay ahead in terms of equity, diversity, and inclusion. And I think I've got a few minutes here. I'd just like to share my thoughts. But the work through the IBA right now formally is intended, I think, to we're targeting the judiciary, law societies, law firms, law schools, to challenge them to see what they can do better to try to increase equity, diversity, and inclusion. And that obviously through our lens means the incorporation or integration of more Indigenous peoples, cultures, and legal orders into their day-to-day practices and into the fabric of them. But ultimately, it's what you see in the legal profession now is it's not exclusive to the legal profession. The lack of inclusion or diversity within the profession is more symptomatic of what we're seeing in our society as a whole. It makes it extraordinarily difficult to have this conversation in isolation of what can we, when I've spoken to law firms or practitioners and they're asking themselves, what can we as a firm do to be more inclusive or to be more equitable within the four corners of their offices, but then going back to a society ultimately, like I indicated, where I'm living in the Muskeg Lake Cree Nation, where you have societal or systemic racism, you have blatant or very egregious or very outright racism, which is being practiced on a day-to-day basis, and to try to reconcile what's happening in your regular society or rural societies with what's happening in the legal profession is going to be very difficult, because ultimately the law in the legal profession is a reflection of the societies that it serves or in which we operate. So I'll do my best to try to focus on the legal profession and on these institutions, the judiciary, law societies, law firms, and law schools, knowing full well that we can try to spearhead change in these institutions, but ultimately these institutions are a reflection of the societies upon which they're built. So to the legal profession, I think one of the things that if I were to boil it down to a single phrase about what the challenge is to the judiciary, to law societies, firms, and schools is, as an Indigenous person, as an Indigenous community, and as a person representing the IBA, I think the question we would ask is, or the challenge that we would place before them is, you're here for your community, you're not here for your career. And it's a loaded statement, and I appreciate the phrase can mean a multiplicity of things, but it's a simple way of expressing when you're providing legal services, you're a member who's providing access to justice for Indigenous peoples, and substance over form, I think, is integral to ensuring that reconciliation is put in place and that we have systems that are responsive to the needs of Indigenous peoples. I don't want to trivialize the metrics that are currently out there right now for measuring equity, diversity, and inclusion. Like I said, many of the firms out there within the four corners of their institutions like to refer to numbers. They like to refer to things such as, we've hired so many Indigenous people this year, we're training this person. The low-hanging fruit, like we have an Indigenous scholarship that's out there for Indigenous students to access, and we've paid this many students way through law school, and so on and so forth. I mean, those are very important because they're indicative ultimately of people who are participating in the legal systems that we work in. The problem with these metrics is that they're very superficial and they only give a surface level analysis of what's happening. Now, there are going to be deeper issues and problems with focusing exclusively on these metrics, obviously, because if firms and associations such as the judiciary are dedicated to saying, this is how many people, these are our percentages of minorities or Indigenous people that we've incorporated within our groups, there's a real danger, and this is very well written on, but the danger is tokenism. The danger is that you have Indigenous peoples working for organizations who are there who are not benefiting from their participation. So they're not inheriting mentorship. They're not having their voices heard within the organizations, or their voices and experiences aren't being used as a way to shift the direction of the organization. They're simply being brought into the organizations on a superficial level. The other is equity, diversity, and inclusion fatigue. I think this is a real thing, and we've experienced this in the last year. When it comes to the orange shirt days, or the Kamloops mass grave experiences, or when you have these outbursts of reconciliation within the media, that organizations suddenly turn their attention internally to increase equity, diversity, and inclusion, and ultimately you land in a place where a lot of that burden about making a work environment or a profession inclusive falls upon the few people who are participating in that. So you have the one Indigenous person from a firm or an organization having to answer to every single person within their firm about, well, this is my experience and this is what it means. This is what I think it means for moving forward, and which is fine from a strategic standpoint, but from a cultural, from a normative standpoint within an organization, that gives rise to fatigue pretty quickly when people are, when you have 300 individuals, in the case of MLT, 300 lawyers, 300 staff members reaching out to 4 Indigenous people, asking them what their viewpoints are, trying to empathize with their experiences. It gets pretty heavy pretty quickly. So seeking to increase numbers within firms just for the sake of having the numbers is going to be problematic for a variety of reasons, not just those 2 that I had mentioned. So going back to this, the gap between what I see as a cultural norm or cultural practices or Indigenous legal orders on one hand, and the mainstream legal profession on the other hand, I think bridging that gap, what can professionals do beyond, moving beyond those statistical analyses? Well, 2 big ones, I think that, and I don't have a lot of time here, but 2 big ones I think are capacity and intellectual property. I think the first, with respect to capacity, anyone working with an Indigenous community knows that there's a chronic lack of capacity. It doesn't matter where you're from, unless you're working for one of the 10 First Nations who happen to be situated within a 10-kilometer radius of an urban center. You're going to be dealing with capacity issues, and you're going to have, it's going to be a major barrier to implementing Indigenous legal orders or having those orders recognized. Intellectual property. In the age of reconciliation, we've seen an outflow of intellectual property from First Nation communities to their lawyers, consultants, advisors, where that information is essentially being integrated into the mainstream commercial industries, and they're not being used or analyzed or stored in a way that's beneficial to the community. So again, there's a lot of issues surrounding these, and these are huge issues with a lot of intersectionalities. I don't want to go too far into these, and I'm happy to answer any questions about this, but examples for both of these are robust, and beyond that, I want to thank everybody for inviting me today. But a lot of hard work in front of us. And I think this is something that we should all be mindful of. And I'm glad we're talking about it today, because these are conversations that we weren't having 10 years ago, 15 years ago, when myself and my good cousin here, Paul Seaman from back in Saskatchewan, joined the legal practice. These weren't things that were on the table. And I'm glad we're having the discussion, but we have so much more work to do that's in front of us.
Thank you, Mr. Lafont. I want to thank you as well for your work over the past 2.5 years as president of the Indigenous Bar Association, because the IBA has done a lot of work to advance many of these areas. And it's amazing what the Indigenous Bar has contributed to this. So I want to then turn to questions related to EDI in the context of practice in a boutique, what could be called a boutique Aboriginal or Indigenous law firm. Kathy Gerges, as I mentioned, Kathy is a partner, Ms. Gerges is a partner at Olthius Clear Townsend. And OKT is a national Indigenous law firm that provides legal advice solely to Indigenous peoples. Right now, it has 3 partners who are Indigenous, and it regularly hires Indigenous articling students and associates. So my question for you, Ms. Gerges, is, as a law firm that specializes in legal advice for Indigenous communities, how does OKT characterize its priorities for equity, diversity, and inclusion? For example, does EDI consider preferential hiring, training in Indigenous legal orders, cultural accommodations related to billable hours, or pro bono service? In your experience, how would you describe progress in these areas?
Thank you, Scott. Thank you for inviting me here today to participate in this very important panel. I'm really excited to be here. So to answer your question, in terms of, just to give you a bit of background, as you noted, we're a national law firm. We have 2 offices in Toronto and Yellowknife, and we've grown substantially, I think, in the past several years, serving Indigenous nations across the country. So ultimately, our priorities for equity, diversity, and inclusion is to reflect first the communities that we serve in terms of how we practice law and in terms of who our lawyers are and who our staff is, and also to reflect the diversity of the communities where our workplaces are. So the diversity of Toronto, Yellowknife, and the surrounding areas. We're continually trying to create a workplace where our lawyers and staff can bring their whole selves, and continually trying to serve the needs and to advance the interests of our clients, of the Indigenous nations that we serve. So some of the ways that we're working to do this is what you mentioned: our recruitment and hiring practices. We are intentional, and we are making moves to get more intentional as we grow. To make it clear that our recruitment and our hiring is, postings include that we have a commitment to equity, diversity, and inclusion, particularly to training and providing experience to Indigenous law students and Indigenous lawyers. We do have accommodations, things like measures through cultural leave policy put in place for Indigenous students and lawyers to participate in, their nation's traditions, events, to make sure that that connection is there and available. And also we have a commitment to kind of creating opportunities to build up those connections for all of our lawyers, our Indigenous lawyers in particular, having sessions with elders at the firm, opportunities for learning about Indigenous legal orders, having training in that. We have an example of the Anishinaabe Law Camp at the Chippewas of Nawash unceded First Nation, for example, that we've sent, that we support our lawyers to go to. And then also just then to make sure that we're providing good opportunities for our Indigenous students and Indigenous lawyers to do good work for their own communities. For other communities, putting a priority on doing pro bono work to that end. That's part of our objectives and our priorities to meet the needs of the communities we serve, but also to make sure that we're reflecting that in our workplace and the workplace we're trying to create. So in terms of how we would describe our work so far in this area, I think I would say that the progress has been learn as you go, but moving towards more intention and planning towards that objective. So let me explain that a bit, is that since I started at OKT, which was in 2007, I have seen a lot of growth in this firm, which has been really great. There's been a lot of growth and there's been a lot of progress since its inception. OKT was created by our three original partners, John Olthius, Nancy Clear, Roger Townshend, that were committed to the service of Indigenous nations and providing support to Indigenous nations to achieve their objectives of sovereignty and self-determination. Those core values and those objectives remain. But now we are becoming much more mindful of all of the other things that we need to do rather than just put our heads down and practice law. To achieve these core objectives. So not only in our practice of law, but also in our workplace environment, also in who we are recruiting and training and being intentional about that. I say that a lot with respect to EDI priorities about the intention of it, because the intention I think is really important about to move past those challenges of just numbers, hiring that Drew was talking about, and moving to something more real, something more substantive. What we're mindful of that we need to be intentional about the diversity of voices needed in our leadership. We want to reflect the communities we serve, and we want to reflect the diversity of the communities where we are located. So, you mentioned, Scott, that we have 3 Indigenous partners. We want to see that grow. We want to see that grow. We want to see non-Indigenous people of color also having a voice in terms of the partnership as well, the leadership, and also providing an opportunity for our associates, our Indigenous lawyers, our Indigenous students to have their voices heard throughout our firm and leading OKT forward. So how do we do this? We're trying to create structures to measure this. As we grow, we need to bring on structures that support this. We need to be intentional about this. It's not something that just happens. It requires some planning. It requires being mindful of how you can do that. Bringing on, we brought on a director of human resources that's creating an EDI strategy, that's establishing internal engagement surveys so that we work with our own people, and then also external engagement surveys so that we work with our clients, with the communities that we serve, to establish how we evaluate and measure how we have done, how we are doing, where we need to improve, and to develop kind of concrete action plans for the future, education plans for the future. And I mentioned this before, is that one thing that we are committed to is being really intentional about our responsibility to train and provide experience to Indigenous law students and lawyers. And that is even if they don't end up staying with OKT. So the usual track that you see in law firms is someone gets, you bring on a student, they get trained up, you want them to be committed to the firm, and they move on through that. But working at a Toronto law firm or a Yellowknife law firm, working at a Toronto law firm is not necessarily going to be the end goal for all Indigenous law students or lawyers, for example, that want to return to do work for their own communities and build that capacity within their own communities and within their own nations, or move on to share their experience in an academic forum or otherwise. When that happens, we see that as part of achieving our priorities, our broader goals. We see that as a success, because ultimately, if our core value, and it is, OKT's core value is dedicated to the service and advancement of Indigenous sovereignty and the goals of our clients, then really we want to provide that capacity to be back in those nations. We want that to happen. We want to almost work ourselves out of a job to some extent. So that's really something that we see as a measure of success and progress, that we make that intentional move, that we have that responsibility to train and provide experience to those Indigenous lawyers that are coming up, even if they don't end up staying with us.
Thank you. So as you mentioned, all the different things that OKT is doing, I'm curious myself, and these are my questions for Mr. Seaman, is how is this different? How is EDI in the context different for those law firms that are general practice law firms with specific Indigenous or Aboriginal law practice groups? So Gowlings WLG is one of those types of firms. It's a general law firm that has an Indigenous/Aboriginal law practice group. The common naming now is as an Indigenous law practice group. And this practice group is embedded in the larger institutional culture that provides services to clients that could include non-Indigenous proponents. So last year, Gowlings announced a reconciliation action plan. Paul, how would you characterize the relationship between Gowlings' broader commitment to EDI at the firm as a whole and its reconciliation action plan, or its work in the Indigenous law practice group?
Thanks, and good morning, Scott. Thanks for the question, and thanks for the introduction earlier. Before I answer, I wanted to briefly also say thanks to Lincoln Alexander School of Law for the invitation to be here today, and to the panel, my fellow panelists and the audience listening. I also wanted to acknowledge I'm speaking to you today from the unceded territory, the Musqueam, the Squamish, and the Tsleil-Waututh people. So I'm on the West Coast in Vancouver. So good morning to everyone from the West Coast. There are challenges in the legal profession. The prior two panelists, Ms. Gerguis and Mr. Lafond have already covered them really, really well. So I'm not going to cover that ground again, but like many institutions, our firm, we do have a ways to go from an EDI perspective, and I don't want to suggest otherwise, just by way of preliminary comment. But one specific aspect of your question's interesting to me because it speaks to I think what you've referred to as a larger institutional culture in a private law firm of our size. So I wanted to tell you a little bit about that larger institutional culture and sort of how it comes to be from the perspective of a big firm like ours. So in our case, in Gowling WLG's case, the firm's been around in one form or another since 1887. There was a firm called Henderson and McVitie founded in Ottawa, I think it was 1887. But over the last 20 years or so, Gowlings became a national law firm with, I think, over about 700 professionals. And since roughly 2016, it's become a multinational law firm of about 1,400 professionals. But this is, of course, a bit of a process. And so the firm grows to become what it is today. Through a number of mergers with smaller law firms in different cities, in some cases, greenfield offices that begin with just one or two lawyers. And I suppose that's one aspect of as you say, a larger institutional culture that I think always has to be remembered. First, it's a huge place. There's a lot of people. There's a diversity, in geography and practitioners and clients and all the rest. And in some ways, a national law firm, I say sometimes, seems like what I call like a microcosm of confederation, where some of the concerns that arise in different offices seem to mirror sometimes the larger geopolitical concerns of the day. And second, knowing that in some ways that the firm is going to be, a bit of what I call sometimes like a Frankenstein's monster of a sum of the significant parts that have been added over the years. So each time the firm has grown in, one city or another, it's added something to the diversity of clients and the diversity of practitioners and something to the institutional culture. And this isn't without its challenges. In our case, though, some of our office's major clients have been Indigenous governments. Some of the practitioners that have been added over the years have been senior lawyers that practice in the relevant area. So I think that one thing I would try and add to the conversation on this topic, on the topic of institutional culture, is that it has helped guide the Reconciliation Action Plan. Our history has helped guide it a bit, because in some ways, working with Indigenous peoples, working with Indigenous governments, having Indigenous practitioners is in the firm's DNA. Some might remember that the firm used to be called Gowling Lafleur Henderson, and the Henderson in that name was a man named Gordon Henderson, who by all accounts was quite the barrister. I'm told that he appeared at the Supreme Court of Canada something like 90 times in his career. It's quite amazing to me, obviously, and one of those 90 occasions was for a man named Louis Francis, a Mohawk from Akwesasne, in the Francis case that was heard by the Supreme Court sometime around 1956. Why is that a bit amazing to me? Well, it's of course just 5 years after some of the most odious provisions of the Indian Act, the ones that prevented, for example, bands and status Indians from suing about rights, were repealed. One of the senior practitioners that's in our group to this day has been with the firm for decades, and he appeared for the National Indian Brotherhood, as it was called at the time, the AFN's predecessor, in the Guerin case in 1984. So this is just 2 years after Section 35 was added to the Constitution. So, we do have challenges in this regard, and the challenges have been spelled out by Mr. Lafon and Ms. Gerglis, and we are no exception to this phenomenon. There are so many things to talk about, and Mr. Lafon says, thank goodness that we're talking about them now and today. But in the case of my firm, I think, and my group, I think what we're very fortunate to have and what to draw on is our history in Indigenous law, and having that as part of our institutional culture, and trying to draw that out and trying to emphasize that in a way that it hasn't been before. And again, I want to be clear that I'm not suggesting that my firm is perfect, but what we do have is we have something to draw on that's positive from an institutional culture perspective that tends to balance out some of these phenomena that have been referred to some extent. And of course, this interacts with and this influences the Reconciliation Action Plan and the firm's commitment to EDI, at least in that context. So in my view, in any case, whether it's my firm or a big firm or a small firm, but certainly a big firm, that it's going to be, I think, more challenging, is firms need to examine and sort of acknowledge and be very candid and truthful with themselves about what their history is in this area, what their firm culture is in this area, what the diversity of clients is in this area, to understand exactly how they might want to approach these issues from a remedial perspective.
Thank you, Paul. Hearing both you and Kathy speak makes me think about how important it is to look at the vision or the vision of the firm, its history, and what it seeks to achieve for Indigenous clients and communities, and kind of to measure progress based on what that vision is, and to keep that vision in mind as the firms grow and as their practices grow and they hire new lawyers and look into different initiatives. One of the things that has been talked about quite a bit, at least at the level of the bar is around reform, either reform to the professional code of conduct for lawyers who practice for Indigenous clients or communities or more broadly, or if not reform to professional codes, some form of training such as Indigenous cultural competency training or anti-racism. So in its final report, the Truth and Reconciliation Commission noted how cultural competency, the lack of cultural competency for some lawyers and possibly even professionals involved in the court might have resulted in survivors' experiences not being understood and what their needs were in that process not being communicated, and then ultimately going into the decisions that have been made. So this kind of pushes to an interest in something like, and it is listed in Call to Action 27 and 28, the need for cultural competency and anti-racism. We've seen the Advocate Society create a guide for working with Indigenous clients and communities, and that was Kathleen Lickers and Candice Metallic, both members of the Indigenous Bar Association. And that guide is available on the Advocate Society's website, as well as Aboriginal Legal Services has also produced a guide for this kind of purpose. And we've seen the Canadian Bar Association develop a program called the Learning Path, I think it's called the PATH, for effectively a multi-module Indigenous cultural competency program. And the University of British Columbia has released a certificate in Indigenous cultural competency for its law students to take while they complete their JD. So for the most part, conversations about legal ethics and professionalism have centered around this idea of cultural competency, rather than the enforcement of certain types of standards or accountability. Dr. Parmar, how would you describe the current progress on reconceptualizing ethics and professionalism in the context of reconciliation? What does it mean for you to make lawyers accountable for reconciliation?
Thank you, Scott, for inviting me to this panel. And also I want to thank Lincoln Alexander School of Law for this invitation. So I just want to begin by also just saying that I am joining you today from the traditional territories of the Lekwungen peoples. And also just want to acknowledge the Songhees, Esquimalt, and Saanich peoples whose historical relationships with this land that I'm in today continue to this day. So in response to your question, I think, so the work has to obviously begin with appropriate training, learning and acknowledging the histories of this place and the ongoing racism and some of the other systemic issues that, for example, Drew mentioned earlier. These are key as we begin to rethink legal education, competence, and ethical lawyering and ethical practice in the context of reconciliation. So I do think ongoing training is important, but of course, only 2 provincial law societies have introduced mandatory training so far, BC, the Law Society of BC being one of them. So a lot more work on appropriate training remains to be done before the profession can actually have meaningful conversations about standards and what they might be and how they might be enforced. In response to your question about sort of the progress in terms of or reconceptualizing ethics and professional responsibility in the context of reconciliation, one thing I've suggested in my paper, as you know, is that the profession has to recognize Indigenous laws and Indigenous epistemologies as a source of ethical practice. That is, I think, necessary in order to reconceptualize ethics and professional responsibility. And I think if we accept that, for example, ethical practice or ideas about ethics are grounded in social and legal cultures, then we have to examine our existing practices and ethical principles and codes, for lawyers or judges in order to determine whether and to what extent they can be seen as ethical in this specific context of reconciliation, right? So do the existing standards, for example, further exclude those who have been historically excluded? If they do, then who are they really serving? Right? These are the questions we need to ask, the profession needs to ask. And a lot of work needs to be done on that. I acknowledge that to treat Indigenous laws as sources of ethical standards is an idea that unfortunately, many lawyers, judges, and regulators are still not comfortable with, but it is the kind of work that has to be done for things to really change. I think that's the only ethical response at this point. I do also want to acknowledge some of the work that you've mentioned, the guides that are available, certainly the IBA guide for lawyers working with Indigenous peoples, also the Attorney General's directive on civil litigation involving Indigenous peoples. These are, and the ones you mentioned, the CBA, like these are all, guidelines that offer valuable advice to help think or rethink professional responsibilities and ethical conduct for lawyers in Canada today. But I have to say my co-panelists are probably in a better position to comment on whether these have actually led to any change on the ground. In terms of accountability, as you know, I've suggested in my paper that the TRC calls to action demand a response that centers accountability. And I think the calls 27 and 28 place a responsibility upon lawyers and judges to be more accountable to Indigenous peoples, to communities who have not been served well by the legal system, and in fact to communities in whose oppression and dispossession the legal system is implicated, right? So accountability begins with acknowledging these truths, sometimes difficult truths, but we have to begin there, right? And despite all the work that's been done to document these truths, there's considerable resistance to acknowledging them among many people in Canada, including lawyers and judges. So that's one of the reasons why I think that accountability is critical in any decision that is made about standards. So for example, how do we think about competence in ways that centers the idea of accountability? How do we think about individual and institutional obligations and responsibilities in the context of reconciliation? And this is part of my concern with, sort of a simplistic understanding of cultural competence. It can't just be about learning about others, about Indigenous peoples. It has to be about thinking of ways of addressing, of minimizing the systemic power imbalances, the exclusions. It's about acknowledging that Canadian law and legal systems, the profession, have not adequately responded to Indigenous communities. So then accountability is about reflecting on the role that lawyers and judges and courts have played many times in the past and continue to play in maintaining, instead of reducing or undoing colonial violence, right? So one example very quickly in the paper that I've offered is that of hearing to respond, which is a phrase I borrow from the scholar Gayatri Spivak. So hearing to respond is an act that centers accountability. It is an act that is grounded in the responsibility to respond to what a client or a claimant is actually saying, right? So it's an obligation to respond to what an Indigenous claimant is actually seeking a response to. And it is only, I think, when lawyers and judges try to do that, and it's not easy to do given our legal system, but it's only when they try to do that that they will really begin to see how inadequate the legal system's response to Indigenous claims has been so far. So I think that's sort of where I would begin to think about accountability.
Thank you, Dr. Parmar. So we have just a few minutes for questions. I have a question for the panelists. We're talking about mostly what we've discussed today in the context of practice for Indigenous clients or communities. How is what we've discussed today relevant to lawyers and judges who are not necessarily working on cases that they perceive to involve Indigenous clients or communities, or even in cases that don't involve Indigenous clients or communities, or law firms that don't seek out to represent those communities as clients. How is what we discussed today relevant to those types of lawyers? Maybe I'll ask if Dr. Parmar can tell us a bit more, or if there's somebody else who has a better idea.
Did you want me to respond first?
Yes, please.
Yeah. So, in my humble opinion, I think that when we begin to rethink ethical practice, that has to be across the board. So, I don't think that that it only applies to lawyers who are working with Indigenous communities. I think in a multi-juridical space like Canada, in a place where Indigenous legal orders, Indigenous legal systems, Indigenous laws are practiced, are a living, systems that are alive, that the principles of ethics that exist within those legal systems have to be part of ethical principles across the board for every member of the profession, right? So I don't think, I know people can, disagree with that, but I don't think that pluralism makes people uncomfortable, and that's fine, but it's also the reality of this place, right? That Indigenous laws exist. And so Indigenous principles of ethics have to be part of how we think about ethics and professional responsibility for everyone.
Thank you, Dr. Parmar. It seems that is the end of our panel for today. I want to thank all the panelists for participating. It was really a pleasure for me to have you all here and to see many of you who I've met before, to see you come. And I just want to say how grateful I am for being able to hear your thoughts on this topic.
I have the privilege of teaching with Professor Franks and torts at Lincoln Alexander. I've never said this to him, but I'm inspired by his energy and commitment to his students. The care that he applies in everything to teaching in accordance with his Indigenous values. Everything that we do in the course is informed by his cultural values. Every decision from the planning of the course to how students contribute to discussions to how we deal with student issues. Substantively, he's providing the students with an approach to torts that advances truth by exploring cases in which torts and Indigenous law intersect, but more importantly, he's on a path to transform tort law by seeking to ground basic tort principles in Indigenous principles and exploring remedies to compensate victims of tortious conduct. As a partner at a law firm that's trying to meaningfully engage with truth and reconciliation, to be in Professor Parmar's words, accountable, I want to thank each of the panelists for the contributions they made. Mr. LaFond for that discussion about substance over form, which we heard echoed in the comments of Professor Walcott. Ms. Grieres talking about the intentional recruitment and hiring. I can tell you that I have a copy, thanks for the reference, Scott, of the Aboriginal Law Handbook that OKT provides, and that's part of a commitment to educating the bar about Indigenous law and how Indigenous law is affected in various areas, including the areas in which I practice. Mr. Seaman, your observations about the evolution of larger institutional culture at Gowlings and that commitment to understanding and acknowledging the history of a firm and to consider the remedial acts that are demanded if we take truth and reconciliation seriously. I found those remarks profound. And then Professor Parmar, when we talk about cultural competency and anti-racism in the representation of Indigenous clients and, getting off from not only to prevent harm in our representation of clients, but to achieve their goals. in those comments about Indigenous laws and epistemology and grounding legal ethics, and to emphasize not just when we're approaching truth and reconciliation, but as part of our core professional ethical principles in representing all clients. I just thought that was fantastic. So I just want to thank you again. It was a great panel. Thank you for your leadership, Scott, on that. So somehow we're already at lunchtime. We're going to take a short lunch break. If you enjoyed the morning, you're going to want to stay for the afternoon because we've got more action-packed. Our upcoming sessions will explore themes including vaccine apartheid, critical race theory, mental health, racial injustice, EDI and big law, and a Dean's Roundtable, hosted by yours truly, that you won't want to miss. And it's not just because I'm moderating it. Anyway, we'll see you in 30 minutes.
When I think of lawyers, I think of these incredible human beings who can do so much for other people, yet they're often not accessible because of how expensive they are. What Lincoln Alexander School of Law is trying to do is they're trying to bridge off that gap so that more people can have access to these, again, incredible human beings that can help you out in ways others can't. I don't think that your financial circumstances should determine whether you get that help or not. That's not how it should work. Everyone should have an opportunity to retain a lawyer, to get help.
the legal profession doesn't create enough spaces for everyone. In the Canadian context, we are very much struggling with access to justice, and to have access, it demands that we have enough spaces for everybody. By upholding the values that we hold so dear or that we like to cherish, I think we need to create more space the same way Lincoln Alexander had to force a space for himself. As those living in his memory, we need to do the same to ensure that those that come after can have spaces for them that are maintained, protected, within the legal profession and beyond.
Welcome back. We hope you had a nice lunch break. We're now ready for today's third plenary session on vaccine apartheid and Canada's role in global health. Our moderator today is Professor Uche Nwaba. Before joining the Lincoln Alexander School of Law, Professor Nwaba worked as sessional lecturer in Australia at Macquarie University, University of Western Sydney, and Deakin University. Professor Nwaba's areas of expertise include public health and human rights, international human rights law, health systems, health governance, frameworks, constitutional theory, comparative constitutional law, and transitional justice. Professor Nwaba began his career in commercial legal practice in Lagos, where he was involved in a number of high-profile litigation cases before superior courts of Nigeria. Please join me in welcoming Professor Nwaba and the next panel.
Thank you for the kind introduction, Sean. It is my great honor to be moderating this panel on vaccine apartheid and Canada's role in the international response to COVID-19 and other global health issues. Good morning, everyone. It is now plain as day that there has been a failure of global cooperation and international solidarity in the distribution of COVID-19 vaccines in accordance with transparent, equitable, and scientifically sound principles. A needs-based global distribution of vaccines paradigm, which would have made sense for a variety of reasons and from a moral and ethical standpoint, has instead given way to a means-based paradigm where wealthy countries like Canada have more vaccines than they are able to use and many more under contracts, while poorer countries, especially in the global south, have not been able to vaccinate their essential workers and vulnerable populations. Canada and other wealthy countries have not only stockpiled vaccines as well as locked up future orders, but they have also done so at the expense of poorer countries' access to vaccines. Canada's multilateral commitments through the COVAX initiative, which was meant to prevent this emergent phenomenon of vaccine apartheid, has not lived up to expectations. Yet, it is clear to the discerning that the push to eradicate COVID and return society to some form of normal will not happen as long as the threat of new variants of the COVID virus remains. Joining me in this panel session to interrogate this phenomenon of vaccine apartheid and what kind of role Canada should be playing in the international response to the COVID-19 pandemic and other global health issues are three distinguished panelists whom I will be introducing very shortly. Before introducing the panelists, I would like to mention that the Honorable Anita Anand, the Member of Parliament for Oakville and newly appointed Minister of National Defense of Canada, who previously served as the Minister of Public Services and Procurement, is unable to join the panel in person, but she has sent a video message which we shall listen to shortly. The first panelist I would like to introduce is Ms. Rujin Habibi, a research fellow at the Global Strategy Lab and a fellow of Canadian International Council. She is also a doctoral candidate at Osgoode Hall Law School. The second panelist is Dr. Sanjay Ruparelia, an associate professor in the Department of Politics and Public Administration at Ryerson University. He also holds the Jarilowski Democracy Chair. The final panelist to be introduced is Professor Obiora Chinedu Okafor, the Edward B. Bolin Chair in International Law and Institutions at Johns Hopkins University School of Advanced International Studies in Washington, D.C. He is the UN Independent Expert on Human Rights and International Solidarity. Welcome to the panelists. We shall now listen to the video message of the Honorable Anita Anand.
Hello, my name is Anita Anand, the Member of Parliament for Oakville.
During the COVID-19 pandemic's first year and a half, I was the Minister of Public Services and Procurement, and in that role led the procurement and delivery of vaccines to Canada for the Canadian population. Prior to the end of July of this year, we were able to have delivered to Canada approximately 68 million vaccines, which was enough for all eligible Canadians to have 2 shots of vaccine. That was 2 months ahead of schedule and was an important milestone for our country. At the same time, we recognize that unless everyone in the world is safe, no one is safe. So we have concentrated efforts as well on contributing to the COVAX facility and Gavi as a whole. We are the second largest financial contributor to Gavi, and we have contributed over $30 million to Gavi as well. We made sure to donate over 40 million vaccines to COVAX and are, in addition, distributing vaccines on a bilateral basis to certain countries as well, including in the Caribbean. What I want to make sure I impart to you today is the dedication that we have to ensuring that Canadians have vaccines and that we are fulfilling our moral responsibility to the developing world. More can be done, more will be done, and Canada will continue to play an important role. I'd like to thank you so much for organizing this important conference and hope that I can contribute as a continual basis in the days and years to come to this effort. Thank you.
We've heard from the Honorable Minister. Now, before opening the panel discussion, I would like to invite each of the panelists to give their brief opening remarks. I will start with you, Ms. Abibi.
Thank you very much, Uche. Thank you for the introduction, and thank you to Minister Anand as well for her remarks at the start of this conference. I'd like to first start by noting that it's impossible not to see the global racial divide in COVID-19 vaccinations. Just 10 in 100 people on the African continent have received a single dose, while countries like Canada boast of having enough to inoculate 38 million Canadians, not just twice over, but several times over. Beyond leaving millions unprotected against the virus, the world itself has closed off to people living in countries without access to vaccines or without access to the internationally preferred vaccines, such as Pfizer and Moderna. As the adequately vaccinated rekindle their love of travel, students, professionals, and families in the global south wait for their first dose. Their already limited passport to the world now hinges on the benevolence of pharmaceutical companies whose CEOs go live on television claiming without proof that Africa's low vaccination rate is a problem of vaccine hesitancy and not rooted in structural inequality. It didn't have to be this way. For one thing, countries could have cooperated to vaccinate the world through COVAX. Now, we've heard Minister Anand speak of Canada's contributions to COVAX, but really the idea behind COVAX was to build a strong and unified pool of funds that would diversify the portfolio of vaccine candidates available to all countries in the world. But very quickly, very early on in the pandemic, countries like Canada began cutting the front of the queue and negotiating their own secret deals with companies, paying more than what COVAX had to offer. That move was crucial, and it essentially crippled the world's collective bargaining power with vaccine makers. Now, we've heard activists and researchers and journalists describe this situation of grotesque inequality as vaccine apartheid. The word harkens us back to the struggle to end South Africa's apartheid regime, which is one of the darkest chapters of our not too distant human history. Yet vaccine apartheid also belies the deeply embedded, colonially derived multilateral regimes we have in the world today, which undermine local resilience to epidemics everywhere, and in particular in the global south. It implies an exceptional situation when what we're really seeing before our eyes may just be the global health regime par excellence, the global health regime as it was designed to work. To that extent, and to the extent that we deploy the word apartheid to draw attention to that systemically rooted injustice, the term may be appropriate. Yet with its use comes a heavy burden of responsibility, because if we fail to overcome this pandemic, if we fail to overcome apartheid, what does it say about us, not merely as Canadians, but more fundamentally as humans? I'm going to end my remarks there, and I look forward to answering questions as they come. Thank you, Uche.
Thank you very much, Ms. Abibi. That's a very, very powerful opening statement. I will now invite Dr. Ruparelia to make his opening statement.
Thank you, Uche, and thank you to organizers for this conference and for organizing this session, which is really crucial at this moment. My remarks follow very much those of the opening. The 10 richest countries in the world, many of them Western democracies, account for roughly 75% of global vaccine distribution. G7 countries alone account for over a third, even though we only represent about 13% of the global population. As we know, we are now administering booster shots to and inoculating our children before frontline workers and vulnerable populations in the global south have even received their first dose. So what does this situation reveal about us and the world? Well, first, we clearly hedged our bets, the Canadian government, by ordering advanced vaccine purchases multiple times over our population requirements. According to the latest data that I just saw yesterday, Canada has more per capita supplies than any other country in the world. Now, you might say that this was prudent. You might say that this was democratic responsibility of our government to protect our citizens, but we clearly were hoarding. And this form of rationality was narrow and instrumental, and it's very predictably created a tragedy of the commons, in which most of the world still lacks access to a first dose. And it's going to come to haunt us because, as we know, the virus mutates the longer that it spreads. Second, Western liberal democracies like ours for the last few years have been claiming that there are grave threats to the multilateral world order. Nationalism, populism, and autocracy are just some of those threats. Yet our actions in this stance are hypocritical. We have pursued vaccine nationalism, which has trumped our professed commitments to liberal values and universal human rights. We clearly place through our actions a far higher premium on the lives of our own citizens than the lives of billions in the global south. Indeed, our pledges to COVAX itself, though commendable, are largely in cash and take an expedient charity-based approach. Too many donations arrive too late in small quantities shortly before they're about to expire. And only a small percentage of these pledges have actually been turned into actual doses so far. Now, some might counter that states have a sovereign responsibility to protect their citizens, but our actions in protecting our citizens have clearly made it impossible for the majority of states and governments around the world to protect theirs. Finally, our current rules-based international order, in many respects, is the problem itself. The global political economy confers systemic advantages to northern rich democracies and the multinational companies that we represent and house. Hence, our opposition to calls at the WTO a year ago, led by India and South Africa, to temporarily waive intellectual property rights on vaccines, tests, and therapeutics so that developing countries could manufacture generic versions, even though our own patent laws allow that to happen. Or equally, the failure of our governments to compel major pharmaceutical companies to share their technology, despite the massive public subsidies and open science that enable these vaccines to be produced at record speed, and the historic windfall profits that these companies have now earned in an acute global crisis. In doing so, aspects of our current international order reproduce colonial dynamics. And it's for this reason that so many in the global south currently describe our situation as vaccine apartheid. Thank you.
Thank you very much, Dr. Parile, for those very powerful statements. I will now invite Professor Okafor to make his opening remarks.
Thank you so much, Professor Ngwaba. I begin with a small quote from the Reverend Martin Luther King Jr. In his letter from a Birmingham jail, he reminded us, he taught us that we, and he wasn't speaking about the US or the West, he was speaking about the globe, are tied together in the single garment of destiny, caught in an inescapable network of mutuality. Powerful words in the 60s. The COVID-19 pandemic appears to have deepened our realization that we do live in some kind of global community, that events over there affect us over here, that this pandemic will not end, and this bears repetition, will not end for anyone until it ends for everyone. The question at issue today for this panel must therefore be understood within this context. From my perspective, law, especially international law, including international law, as my former PhD supervisor used to say all the time in the 1990s, a great Canadian jurist Ivan Head, former Foreign Affairs advisor to Pierre Trudeau, law has something to do with it. Global legal obligations, and I do not speak here of charity, obligations to each other do already exist. But we need to better understand them while also deepening them. We also need to actually respect them, not just talk about them, which a lot of countries tend to do in the COVID-19 pandemic context. We also need to implement them, which a lot of countries don't do, as we've heard from the panelists who went before me. Unfortunately, there has been a serious failure, or rather serious failures among too many states, and not just state, other actors in the international community to do any of this. The rest of my remarks today will be framed by these more general thoughts, and I look forward to developing them in conversation with my panelists and the audience. Thank you so much.
Thank you very much, Professor Okafor, for your opening remarks. I will now move on to the discussion session with the panelists, and I'll be posing a series of questions. I will start with you, Professor Okafor. In May 2021, WHO Director General Tedros Ghebreyesus declared that the world had reached a situation of vaccine apartheid and was no longer just at risk of that situation. This characterization has since gained traction with many scholars and activists, especially from the Global South, as accusing Global North countries of practicing vaccine apartheid with their selfish hoarding of vaccines at a time when Global South states cannot vaccinate even their frontline health workers. Do you agree with this characterization of apartheid? What makes the current situation apartheid? Or has the term been deployed because of its shock value? And if so, does that not trivialize an otherwise unacceptable practice? Professor Okafor.
Thank you, Professor Ngwaba. As a good old Nigerian, I'm going to answer the question with a question. What exactly is apartheid? Right? That's the preliminary question that we must understand. And how does it relate or not relate to COVID-19 vaccines? And what is Canada's role, if at all, in this entire sort of matrix? The International Convention on the Suppression and Punishment of the Crime of Apartheid, which is a 1974 international treaty, which binds 109 states formally, entered into force in 1976, defines apartheid. Canada is not formally a party to this treaty, but it is a party to the Rome Statute, which also incorporates the definition in this document. So I think we need to understand, especially for the audience, what apartheid means and how it might or might not relate to what is going on with access or lack thereof, more properly said, to vaccines around the world. So if you look at Article 2 of that document, it defines apartheid as any of the listed policies, practices, and acts committed for the purpose of establishing and maintaining domination by one racial group of persons over any other racial group of persons, or systematically oppressing them. I will not bore you by going through that long list, but suffice it to say that many of the elements involved in the denial of access to vaccines could fit within some within that list. This is a very important point, that we're not just then talking about charity and stuff like that. If we're actually serious about characterizing it as apartheid, we're talking about offenses here. So we need to be clear about that. It is, at the very least, a very serious infraction of existing international law. More specifically, the definition includes denial to a racial group of the right to life. It's very specific and very opposite in the vaccine context. People die if they're not vaccinated. I don't think I need to stress that point. Everybody knows this, okay? It leads to that. So the question then is, and I'm just raising the question, not actually reaching any conclusions, that does hoarding vaccines far more than you ever need in several lifetimes for the foreseeable future qualify as denial to racial groups, and what racial groups are being denied of the right to life? But so clearly, one could make the argument that what is going on is apartheid. But I actually don't think that we need to resolve this question or even characterize it as this lack of access as a form of apartheid to see that a serious harm, an extremely serious harm, is resulting from such lack of access to vaccines. In part, at least, because of the actions and behavior of countries like Canada, of countries largely in the global north. Not only, there are a few others, but of countries largely in the global north. So whether or not it qualifies as apartheid, it reminds me of the whole debate about genocide and mass murder, as if mass murder is not bad enough. This is how I look at this. What is going on is, it's as egregious. I don't need to resolve the question whether it is apartheid or not, crime, to reach the conclusion that it is extremely egregious what is going on. I also want to remind us that we don't need to resolve this question as well before seeing that a serious failure of imagination is occurring, in my view. Also, a breach of, again, existing international law obligations, existing international solidarity and cooperation obligations is occurring and continues to occur before our very eyes. What has occurred and is occurring to me does not have to be styled apartheid to be as terrible and egregious as apartheid, okay, in my view. So however you see that question, something egregious and terrible and self-defeating, quite importantly, is occurring before our very eyes. So I can go on and tell you, because I have made the claim that there are existing international law obligations, solidarity, that require cooperation in the right to health context. I've not developed that, but I don't know if I have time. If I have time, I will go on to develop it because it's actually quite simple, right? So I will let you decide as chair whether I have more time to go on. Yeah.
Maybe a minute or two.
Okay. So these obligations, if you say, what is their provenance? Where can we find these obligations? These obligations exist in, actually exist in international human rights treaties. So for example, let's start with the UDH, which again, a lot of these countries like to cite to a lot of the countries that are denying access to vaccines. So the Universal Declaration on Human Rights, Article 28 is extremely clear. Basically, I'm summarizing. It states an entitlement of everyone, anywhere in the world, among all the 176 state parties,
to a social and international order in which their rights to health and other human rights can be fully realized. In my view, your right to health in the COVID-19 pandemic cannot be realized if you don't have access to vaccines. It's impossible, right? This right, which Canada, the US, every single country that's holding vaccines has subscribed to the UDH because it's formally non-binding, although it is customary international law and therefore binds every state, is existing. This is not something we need to invent. It's on paper. The International Covenant on Economic, Social, and Cultural Rights, Article 2, is even more explicit and is a binding treaty. Obligation to cooperate to advance the right to health. Every single 175 states, including Canada, has ratified and is obligated. It's a binding legal obligation. The obligation to cooperate to advance health rights in the COVID-19 pandemic cannot be emptied of content with the kind of argument that I hear global North states often make at the UN, that, oh, it's just an informal agreement in a binding treaty. That doesn't make any sense whatsoever. If you even look at Articles 55 and 56 of the UN Charter, the obligation to cooperate in the human rights sphere, including the right to health, including the right to access to vaccines, is stated clearly there by logical implication. And let me also remind us, as I often do, that as usual, the African Charter is extremely way ahead of the international human rights conversation. In 1981, they already had an explicit duty on everyone, every state, to cooperate in the right to health and human rights context with everyone else anywhere in the world. It's in Article 27 of the African Charter. And so I can go on, but I just have the main sources of these obligations that I've often written about. And just shamelessly, I'll put in a plug for my last report to the UN Human Rights Council, where it is developed in extreme detail, if you want to read more about it.
Thank you very much, Professor Kafo. Dr. Ruparelia, I have a question for you. We have just concluded a federal election that was called by the Liberal government of Justin Trudeau on the back of what has been widely hailed as a very successful COVID-19 national response strategy. We all heard from the Honorable Minister earlier. Yet Canada's international response to the pandemic in fulfillment of its international human rights obligations and commitments has been widely criticized as less than ideal. We've also heard from Professor Kafo. What does this say about who we are as a nation, our values, our commitments, and where our priorities lie?
It's an important question. I think it's clear that, our government, like other governments in the North, were thinking about their own citizens and protecting them. Canada's response initially to the pandemic, as we know, was off to a slow start. We had eliminated or stopped our international surveillance regime. We were slow to close our borders. We really struggled with testing and tracing early on. And so it's sort of logical politically that the government would scramble as it did to put in as many orders as possible. But the number of orders that were put forward are estimates of 5 to 6, 7 times our population needs. So I think there's sort of two forms of rationality here at work. One is a short-term, narrow, myopic rationality, as if we were the only country in the world. And a second is a more enlightened long-term rationality that thinks about what are the repercussions of our actions. And I think that is where Canada has been criticized vociferously in the international community, and rightly, because it is our actions that have helped create this situation. It's true that we are one of the biggest donors to COVAX, but these pledges we have to act on these pledges in time. As Professor Okafor had said and Dr. Habibi had said, this is a virus, of course, as we know, that grows exponentially. It mutates. the Delta virus, which is wreaking havoc around the world, was a mutation, and we expect to see more. And it's not enough to say we're going to pledge 200 million vaccines, as the government now has done, by the end of 2022, but to discover from the latest reports that I've read, it's between 5 and 10 million have been donated, right? So pledges are important, but we have to act on those pledges quickly. So I think far faster than we're doing. So that's the first thing. And the reason that we have to pledge so much now is precisely because we hoarded the purchase of all of these advance agreements. I think that's something that it doesn't come through, right? We're having to act in this way precisely because we help create the situation. Similar to, in other instances. I mean, what's happening in Glasgow right now, the COP26, the northern rich countries pledged in 2009 in Copenhagen to, for instance, support the transition in developing countries. It's more than a decade later, and we still haven't met that commitment of $100 billion a year. So these things are important. And I think it says something else about us. It's not simply the responsibility of this government, although of course it was this government that was empowered and made these decisions. I remember seeing a poll in the summer, I think it was by the Angus Reid Foundation, that asked Canadians, are you willing to donate vaccines to vulnerable populations before everyone here is inoculated? And a vast majority said no. So the government is responding to popular opinion, but it says something about us. And I think that's where I was trying to draw a remark, my opening comments. You cannot say you are for a multilateral system that protects universal human rights and believes in liberal democratic values if you act in a way that basically shows that the value of some citizens are far more important than others. And it says something about our democratic system. Democracies are crucial for representation and accountability, right? We don't want to have autocratic regimes. But the political incentives of our institutions clearly have failed in this crisis. We are not acting away. So we need a more enlightened understanding of self-interest. We need to fulfill those international obligations, as Professor Okafor has said. And we need to act with far more urgency than we have. And I think, we are criticized in the international community, and we need to be criticized. We need to change radically how it is we're acting. And these are other issues we can talk about, but I want to make sure there's enough time for everyone to speak and address the other questions you have.
Thank you very much, Dr. Ruparelia. And I come to you, Ms. Habibi. Canada has always situated itself as a global leader in health. Yet, many have criticized the Canadian government's vaccine nationalism policy at a time when global leadership in health is desperately required. You yourself, Ms. Habibi, you have championed a campaign through a widely signed petition by health scholars and activists, calling upon Canada to take more responsible action to promote global health justice. Do you believe Canada's international response to the pandemic, or lack thereof, is uncharacteristic of Canada, a deviation from the norm? Or has COVID-19 merely surfaced what was previously masked or hidden about Canada's global health justice credentials?
Thank you very much, Professor Nwaba. And I guess I'll begin at this point by describing how Canada is typically characterized as a middle power in international affairs. And this is in the scholarship by political scientists who study extensively Canada's role in international affairs. They find that often the role that Canada takes is a middle ground consensus approach, whereby Canada doesn't rock the boat too much or spearhead a bold initiative that breaks away from that broader political consensus. And really, its engagements in global health are no exception. Now, we've heard from Minister Anand that Canada had made several pledges in various international fora to make vaccines affordable and available to everyone, everywhere. And it has donated both funds and in-kind and doses to COVAX. But pledges, as Dr. Ruparelia has said in his question just earlier, do not automatically amount to jabs in people's arms. So COVAX has been beset by many delays, again, because of the hampering of COVAX's effectiveness very early on in the pandemic. But what Canada hasn't really supported at this point in time is a change in narrative from a narrative of charity to one of legal obligation and to one of justice, as Professor Okafor has also powerfully articulated. Canada has gone on record claiming that we don't need to waive intellectual property rules at the World Trade Organization because we have existing flexibilities in the intellectual property system that are working well enough. Now, what's interesting here is that Canada is actually one of the few countries that has in the past taken advantage of these flexibilities to export drugs at a much cheaper price to countries that need them. But that Canadian regime, it's called the Canadian Access to Medicines regime, if it is to work properly, requires leadership from the federal government right now to amend it to include access to COVID-19 vaccines as being among the list of eligible therapeutics that it can export to other countries, to manufacture at home and then to export to other countries. So it seems disingenuous at this point for Canada to say that existing flexibilities around IP rules are working well enough when it refuses to take the steps domestically to implement the changes needed to make those flexibilities work for the rest of the world. But more fundamentally, I think what we have to reconfigure in global health amongst in the narrative of global health politics or global health diplomacy is it useful to characterize countries as powers, right? So when there was a change in leadership and Biden came into the presidency of the United States, there was a narrative that the US is back as a bold leader in global health. The US can come back and save global health. Is that narrative really going to be sustainable for the pandemics that we are to face in the future? In the past, just before Biden took power, we had a president who was not afraid of leveraging xenophobic narratives about the pandemic to essentially advance, to advance his own political objectives. Can we trust powers in the global north to really always guide us in the global health initiatives that we're taking? And so my plea is to really stop thinking about Canada as a middle power or the US as a leading power in global health, and to really shift the narrative to one of mutual vulnerability, whereby we understand that not only are other countries dependent on Canada, but as you, Professor Nwaba, have written about very well, we as Canada are also dependent on other countries. And we're dependent, for instance, in one of the ways that you've described, Professor Nwaba, that we receive the human personnel, the human capital to fund and to sustain our own healthcare system here in Canada. We need to recognize that narrative. It needs to be much more at the forefront of our discussions. And so really, I urge us to move away from narratives of global powers in global health and charity as a model.
Thank you very much, Ms. Abibi. I have a question from the audience. I will just throw it to the panelists before I circle back to my questions. And so it says, are we not talking about equity in the sense of accessibility to an international resource that will be better classified as a global property right that each country ought to have, and thus an individual property right to an international resource that all global citizens must be secured? Are we not then classifying certain resources as belonging to everyone equally? If so, then it will be the global initiative to guarantee certain resources that all, not just Canada, as a global actor, must be held accountable in securing. I suppose the question seems to be suggesting that there should be global accountability and not just Canadian accountability. Any of the panelists want to jump on this question? Okay, Dr. Ruparelia?
I think it's a really important question, and it's absolutely right. I mean, you can characterize, we need a vaccine for the world. It's a global public good. So the question becomes, what do our governments do to help create that global public good? As Dr. Bibi was just talking about, Canada could, we're here in Canada, so I'm going to talk about Canada first, and then what the US has also been doing. India and South Africa, over a year ago, went to the WTO to ask for a temporary waiver on intellectual property rights in order so that their generic manufacturers could produce the vaccine for their own populations. They basically didn't trust the global north to share the vaccine, and basically their suspicions have been borne out over the last year. Only in April did the United States, and I take Dr. Bibi's sort of caution about talking about as global power, but it's as the most powerful country in the world right now, agreed to support some of this waiver for vaccines, but not therapeutics and tests. But it changed its position. The EU has been vociferously against this. Canada has not joined this. And the question has always been put that, well, can these countries actually manufacture the vaccine? But as recent articles have shown, including from one of our own journalists, Stephanie Nolan, it was about a month ago in the New York Times, there are at least 10 major pharmaceutical companies in the global south, in India, in Thailand, in South Africa, in Indonesia, in Brazil, that can produce at scale rapidly these vaccines. They need access to the patents, and they need to know that they're not going to be punished by these companies. And Canada has not supported that, right, at the WTO. It's dithering. As Dr. Habibi said, it's not willing to issue a compulsory license to one of our own companies that has been approached by the Bolivian government to produce vaccines for Bolivia. And it's hard to see what the argument is against this. And so it's absolutely right. The person who asked the question is absolutely right in the audience that it's not just Canada's fault. I focus on Canada because per capita, I think we have the worst record in excess vaccine orders. It relies on many countries, but it has to do with how our international system is structured. And it's structured in a way that reproduces, as I think many have argued, these sort of colonial dynamics. Just one more thing, the international health regulations, for instance, have far more onerous hurdles for developing countries to jump through, called a pre-qualification mechanism, to have their vaccines seen as legitimate and recognized by the WHO, right? So we have rules. That's why I'm saying it's a rules-based international order that actually is asymmetric. It tilts the playing field against Southern countries. And that's why we need serious institutional reform at the global level. And we need serious action right now. And it's been a year since this petition, for instance, has been sitting at the WTO. And there's very little evidence to say that these companies in the South can't produce these vaccines. But that's the argument we stick to.
Thank you very much. Professor Kafo, could you quickly comment on this question as well, linking that up with your work with international solidarity?
Thank you so much, Professor Ngwaba. I agree entirely with the eloquent answer provided by Professor Rupalia. He's quite diplomatic about it, but it's mind-boggling. The entire TRIPS, the trade-related, intellectual property rights debacle, one would say, where global North countries are blocking essentially something that looks like the Doha Agreement on TRIPS and public health, with which HIV/AIDS drugs were manufactured across the world on an argument that the same companies that made HIV cannot make the vaccine. It doesn't make any sense. It is, in my view, an egregious lack of urgency in the face of massive suffering and massive death before our eyes. I commend the US for shifting position on it when the Biden administration came in. And I think that Canada needs to immediately, with a sense of urgency, shift its position. This is not a harmless policy position. It is leading to people dying around the world. These vaccines can be produced. There is evidence is there. Professor Rupalia has already offered, the evidence, right? In any case, it is a bit disingenuous to say if there's a legal barrier stopping certain countries from ramping up their capacity, because you don't ramp up your capacity to produce something that you cannot produce, that you shouldn't remove that legal barrier, right? So it's a kind of circular argument. Remove the legal barrier first and then see if anyone is capable of taking it up or not, right? That's what I would say. So it is as Professor Rupalia said, it's a long history of these asymmetrical international system rules that are designed to, basically speak out of both sides of the mouth. On the one hand, we claim global citizenship and dense citizenship when we want to harvest resources from the South. Imagine if this vaccine was a resource held by, say, Ghana. Imagine what Canada and the US would be saying. Go read about the oil crisis of the 70s and see the arguments in the American Journal of International Law. International law is about oil. It's as if the oil is on their territory, how entitled they are to the oil.
on the basis of dense global citizenship. And then we come to something that will save people's lives, and these arguments are being made. It's really quite frustrating, I must tell you, when you hear these things at the UN and WTO level.
Thank you very much, Professor Okafor. And this is all the time we have. I will then hand over to Tony. Thank you for the panelists.
We are so grateful to have had you here. And I think this is a topic that many people have had on their minds and wanted to hear your extraordinary thinking about. So thank you for bringing us here. What I'm seeing is a theme throughout this conference, which is about inequity that was existing before COVID and that has been magnified. And what I've heard you say that was so powerful, all of you, is that it's not necessarily that the systems were broken, but the systems are doing exactly what they were set out to do. And on our local levels, our domestic levels, and international levels, what we're seeing is a failure to serve people with basic needs that would allow them to live. And I was shocked. I knew that Canada was one of the worst. I did not know we were the worst per capita in excess vaccine hoarding, I'll call it. But more than that, to think about the analogy that has been made here and how deeply you've talked about the concept of apartheid, where there are systems in place that are actually resulting in the limiting of people having access to healthcare and in many, many circumstances to life-saving help. So we're very grateful to you, not only for calling it out, but for talking about Canada's specific role. And one of the things that I think came out for many of you is that to be silent or not to take a leadership role is also a form of violence and a form of cruelty. I think again to the first panel where we talked about and thought about the fact that there needs to be a fundamental rethinking of what it means to live in community. And if anything, COVID has taught us that as one person is sick in the world, we are all so connected that every person is affected. And you have called on us to think about that connection and how we serve our neighbors in a way we would hope to be served if we were in that situation. I especially loved the ending where you were talking about what would it be like if another country such as Ghana was hoarding vaccines. How would the world react? So important for us to think about both as people working in systems and as individuals who need to push for these kinds of things. Thank you so, so much to all of our panelists. It was extraordinary. Professor Uche, we really appreciate your moderation. Thank you. We're going to move to the next plenary session now, and we've got some back-to-back power panels for you right now. I will say this one is very close to my heart. It was the root of my doctoral research, and this next plenary session is called Integrating Critical Race Theory into the Curriculum of Canada's Law Schools. And in the wake of global uprisings for racial justice, critical race theory has become a very polarizing topic, both in the US, but also here at home. And I'm really looking forward to hearing some of our panelists about why the critical analysis of racial inequality is giving rise to strong opposition from certain groups, and what it means to truly integrate critical race theory into legal education in Canada, something that many of us believe is an obligation to our students that will be entering this profession. Moderating this session is Professor Joshua Seeley Harrington. If you have never heard him speak before, you are in for a treat. He is a passionate educator, a scholar, and an advocate. He draws on critical race theory, and in his research, he explores ways in which law mediates racial hierarchy with a particular focus on criminal and constitutional law and how it subordinates Black and Indigenous people. Relatedly, he also looks at the construction notions of racial identity. So he looks at dialogue with gender, sexuality, disability, and class and those intersections, and offers a very rich analysis. So please give us a moment and we will move into the next session. Thank you.
It is truly an honor to moderate this panel on integrating critical race theory into the curriculum of Canadian law schools. For the uninitiated, critical race theory is a body of scholarship that examines the ways in which law and legal institutions interact with questions of race, racism, and racial justice. Critical race theory is close to my heart for two reasons. First, because I am a new professor at Lincoln Alexander Law, where we take very seriously the project of critically informed legal pedagogy. And second, because I draw extensively on critical race theory in my own legal scholarship and legal advocacy. While critical discussion about law and race is always important, it takes on particular significance in the current moment. Indeed, the teaching of critical race theory by Black scholars in Canada has prompted some sitting benchers of the Law Society of Ontario to campaign on the removal of critical race theory from the Law Society and the law schools, a troubling echo of the wave of anti-critical race theory legislation we've recently witnessed across the United States. Rather than discussing whether we should be talking about race in law school, which I consider fairly obvious given the law's past and present role in creating and maintaining racial hierarchy, we will be discussing why and how we should be having that conversation. And I could not be more pleased with who I am privileged to be having this conversation with today. I'm joined by four exceptional panelists who each brings crucial insights and perspectives to critical race theory and legal education. They are Donna Young, Dean of the Lincoln Alexander School of Law, an expert in, among other subjects, race and gender discrimination and university governance, and a prolific writer and presenter on critical race theory, race and gender justice, and academic freedom. Patricia Williams, the University Distinguished Professor of Law and Humanities at the Northeastern University School of Law, a founding scholar of critical race theory, and the author of several path-breaking books, including my favorite legal text, The Alchemy of Race and Rights. Scott Franks, an assistant professor at the Lincoln Alexander School of Law and an expert in, among other subjects, Aboriginal law, Indigenous legal orders and constitutionalisms, and critical Indigenous legal theory, whose research specifically includes investigating barriers and opportunities to implementing the Truth and Reconciliation Commission's calls to action with respect to law schools, and Angela Lee, an assistant professor at the Lincoln Alexander School of Law and an expert in, among other subjects, law and technology, food and agriculture law, feminist legal theory, and critical race theory, whose scholarship explores the complex relationships amongst various forms of injustice with food and environmental systems. In terms of format, I will be discussing four themes with the panelists for about 10 minutes each, followed by some questions from the audience. Accordingly, if you have questions, please submit them using the online platform, and I will present some of those questions to the panelists for further discussion during the final segment of the panel. So I'm thrilled to begin by posing a question to Dean Donna Young. As the inaugural dean at the Lincoln Alexander School of Law, you've been resolute in orienting the law school towards critical legal education, and in particular, a curriculum and faculty invested in interrogating questions of racial justice. How did critical race theory first influence your understanding of the law? Is that influence distinct in your experience between Canada and the United States? And how do those distinctions inform your views on integrating critical race theory in legal education?
Thanks, Joshua. I just wanted to begin by saying how thrilled I am to be speaking on this panel with both Patricia Williams, who is one of the founders of critical race theory, and then the three of you, all faculty members at the Lincoln Alexander School of Law, who are working diligently to integrate some of the teachings of CRT and other critiques of law into our curriculum. And I think it's extremely important. It's an important panel and an important topic. I wanted to talk a little bit about what was going on in the 1980s and early 1990s when I was a law student at Osgoode Hall Law School. It was an important time for feminist legal theory and critical race theory. Feminism, or feminist legal theory was making significant inroads in the US and in Canada. Charter jurisprudence was still in its infancy, and lessons from Canadian feminist lawyers were just beginning to find their way into judicial decisions, legislation, and international initiatives. At the time, Canadian law schools were not particularly diverse in terms of the demographics of the faculty or the student body, but the curriculum was just beginning to expand, and issues of race and gender and Aboriginal law and Indigenous law were just beginning to be incorporated. But that incorporation did not really happen in terms of the professors of color, whose numbers in Canadian law schools were still quite limited. So in the United States, more so in the US than in Canada, analyses of racism and colonialism were beginning to be incorporated into mainstream legal analysis through the activity of a group of lawyers and law professors of color who had begun to organize around a new way of examining law. And these folks, many of us know their names. They are the founders of critical race theory: Derek Bell, Kimberly Crenshaw, Charles Lawrence, Mari Matsuda, and of course, Patricia Williams. And they all had a really enormous influence over me and my legal education, even though they were operating south of the border, and their jurisprudence and their theories and their practice, because many of them were practitioners in law. They had an enormous influence over how I was absorbing my legal education in Canada. They were dedicated to highlighting the ways in which race and racism were infused in legal processes and structures, and they were committed to using various rhetorical and practical devices to address systemic bias and racism. And this movement was a response to the almost complete erasure of Black, Latino, Asian, and Indigenous voices in analyzing and interpreting and implementing the law, and out of a deep frustration with the still dominant idea that racism was an aberration that could be eliminated through anti-discrimination laws, without any deeper appreciation that the legal system itself was inherently anti-egalitarian and intertwined within a system of white supremacy. So as a law student way back when, in the 1980s and 90s, I found critical race theory life-affirming and profound. In my second year of law school, I somehow found out that there was a critical race theory conference in Wisconsin. It turned out that that was the second critical race theory conference in the United States. And I gathered together a group of law students at Osgood who drove across the border. Took us 12 hours, kind of during a snowstorm, and we attended this conference. And it was there that I met professors who were the founders of critical race theory, including Professor Derek Bell, who was the first person to suggest that I consider a career as a law professor. No one had said that to me before, and it wasn't within my contemplation. It took an amazing man, first Black professor at Harvard Law, really profound scholar and researcher, to suggest that someone like me might consider a career in academia. And so when we talk about the influence of critical race theory, it wasn't just in terms of my understanding of the law, but also in terms of the people who were mentoring students like me and encouraging us to go in a different legal path. And so the second part of your question has to do with the influence of critical race theory and whether it's distinct in Canada and the US. And of course, the influence of CRT is really, it's both. It's both distinct and very similar, and distinct to the extent that our legal and political systems, our history, and our place in the world are distinct. But the influence plays out very similarly in both countries. So I'm going to step back a bit and explain something that at first seems so obvious that we don't even consider it usually. But this is the thing. The outcomes of legal disputes often depend on who has the better story. That story can be a legal one, whose story fits better into the theory of the case, but it also depends on how the story resonates with and is understood by the decision makers. So to understand how law is practiced, we must first appreciate that disputes consist of different and sometimes contradictory stories about the same problem. In other words, the law is replete with stories and dedicated to determining whose stories are the most persuasive. And this is true whether you're in the United States or Canada. And so critical race theory back in the 80s and 90s played a really important role in pointing out that about the stories that get told in the law by showing us whose voices are left out of these stories, by demonstrating the similarities between the stories or histories of those with decision-making authority in the law, and by reorienting the legal discussion towards attention to and credit given to the voices and experiences of those who have been marginalized in both Canada and in the United States. So law schools play an important role in legal practice, and the typical progression into the legal profession for most of the 20th and 21st centuries was through law schools. So this may seem so obvious that we hardly ever think about it, but there is an enormous role that law schools play in what gets practiced and how it gets practiced. And through the 20th century, there was a raging debate about the role of law schools in preparing students for the practice of law. There's still a raging debate. We're well involved in it. It's not over. And the Lincoln Alexander School of Law comes in, and we want to do all of it, right? We want to train students in the practice of law, but in doing that, it is fundamental to understand that we are also part of the academy. And as such, we serve the public good, as does every other institution, through its mandate to educate, to seek truth, to explore complex societal dynamics, and to help explain mysteries, and to answer some of the most pressing problems of our time. And this is where I think critical race theory shines. It is not a theory as we understand the term colloquially in the abstract. In law schools, it teaches us skill that enhances the quality of legal education and justice. And so fundamentally, it helps us understand the stories that are being told by the case law, by legislation, by legislative history and legislative debates. And it tells us to refocus those stories in ways that make sense, that requires a critical reflection, and that pushes us to understand what is missing in law. So it is a starting point. It is an analysis. It's the buttressing and the reproduction of an idea that in order to be a good lawyer, we must understand what stories are being told in law, and we must give voice to the stories that are excluded. Thank you.
That's really wonderful, Donna. And there's a couple things that kind of raises in my head. One is, as you've described kind of in your trip to from Osgood, your road trip, and as Derek Bell's own story illustrates, student initiatives often operate at the genesis of critical race theory and a lot of kind of anti-subordinative legal theories and areas of legal thought. At somewhere like Lincoln, where there's greater institutional support for critical race theory, what role how do you situate student initiatives in that dialogue of shifts in pedagogy, shifts in curriculum, et cetera, when we're kind of at a new moment of institutional support for these types of things?
I think the student story is essential. As you said, when I was a law student, there was a very set curriculum. Students are always pushing for differences in curriculum. I think that activism is absolutely essential. It should always be the case, and it should never be suppressed. And so I think the students have a very important role to play in development around these things. They are the future lawyers, and they have a say in the education that they are being given. And I want to say that at our law school, we are in our second year of operation. We are still growing. We are still hiring. We are still admitting our students. And so I feel really privileged that our students have the ability to help us shape the future of not only our law school, but the legal profession too. So I think their voices are critical.
One other thing that your comments made me think of is, the role of storytelling in legal advocacy. Does integrating critical race theory involve integrating narrative theory? Does it involve integrating law and literature? Are these kind of adjacent to or running parallel with or constitutive of what it means to integrate critical race theory? I'm just curious what your thoughts are on that.
I absolutely think so. One of the things that critical race theory tells us is that a very broad approach to analysis of law is really necessary to understand law and to shift legal practices and premises. And so kind of an interdisciplinary analysis of law is really important. There are other reasons for this, right? So in that debate I referred to between, about law schools and their role between theory and practice, though that debate is false, right? That distinction has been described in a way that doesn't actually get to the nuances, I think, of what theory and practice really are. Many of the critiques of critical race theory are critiques of something that doesn't really exist. It's not critical race theory, it's something else in the minds of the people who are critiquing it. But one thing that I think we are privileged in the Legal Academy to do is introduce our students to a lot of different ways of learning, including historical analysis and critical analysis from very different perspectives in order to understand our role in the legal profession. And so it is incumbent upon us in the Legal Academy to introduce our students to different ways of thinking, maybe not standard, this is what you need to, these are the skills that you need, but in a way that is integrative and really holistic.
That's all wonderful. I really appreciate all those comments. So I'm now going to shift, and it's my great pleasure to pose a question to Patricia Williams. In your book, The Alchemy of Race and Rights, published in 1991, you wrote that legal theory in Anglo-American jurisprudence is characterized by certain features, including the existence of objective, unmediated voices by which transcendent universal truths find their expression. There's that word truth again that Donna just mentioned. How does critical race theory challenge those supposedly objective voices, and what role does that challenge play in the legal curriculum? Further, would you say that this challenge is similar today, 30 years after you first wrote those words, or does recent opposition to critical race theory in the United States in particular signal a distinct era of resistance to critical legal thought? In particular, you recently wrote in The Nation that the almost identical critical race theory bans emerging across the United States have been prepared by a team coordinated and funded by an array of conservative think tanks. As a founding scholar of critical race theory, do these recent attacks feel like something new, or more of the same elite resistance to reckoning with the complex texture of law and society?
Oh, well, there's a lot to unpack in that. I think that, to go back to the first part of your question about what critical race theory does, it's a hard question to answer. Critical race theory, as I understand it, is a conversation. And so when I am called a founder of critical race theory, I just think I was in a particular place and at a particular time where I participated in a conversation that presented a challenge to a certain normative understanding of the way in which law operates and how law is taught. And by that, I mean that when I started teaching, there were 7 women of color in the entire United States in 1980. And so the degree to which our experience brought a different perspective, that some of which was the product of specific exclusion. You know, we were a country still, you know, reeling and recovering from the civil rights movement and from the legacy of Jim Crow, but some of which was pure and complete oversight. People had never thought about it in positions of high power, in positions of legislative power, in positions of judicial power. And so when I was in law school, I learned things like the reasonable man standard. And that reasonableness of manhood was quite gendered and quite normative. And so we learned rules like it's a mitigating factor to kill one's wife in the heat of passion when you discover that she's been unfaithful. It's that recent within our jurisprudence. And so it was really the rising number of women that changed or challenged that. That was part of the feminist legal theory movement that occurred during the 70s and 80s. When I, you know, I think I've written about this, it might have been in Alchemy, about coming across 2 baskets of Barbie dolls in a, you know, a 5 and dime store. And, you know, one basket was $5 and the other basket was $10. And the dolls were identical. They had been cast from the same mold. They both had hair down to their butts, as Barbie dolls do, and they were dressed identically. And so from a rational, reasonable, economic man perspective, it is irrational to have 2 different identically plastic cast molded Barbie dolls to be differently priced. If you understand that one Barbie doll was black, that was the $5 one, and one Barbie doll was white, tinted white, the mere paint jobs of each, or the coloration of each, the tincture of each accounted for that, then you begin to see that there's a way in which the irrationality of that economic assessment is rationalized by color and by then race. And so, you know, to present that from one lens, it seems like, you know, race really rationalizes irrational economic judgments. And that is unsettling, I suppose, of an assumption of universal norms. Now, certainly universalism is an ideal, but in practice, those kinds of differences, those kinds of aesthetic valuations, which are then made practical and which are acted upon in the real world, are part of what I think some have perceived as a challenge, rather than as a corrective or as an offering of different perspective or as a reality check. You know, it's a reality check. It's a, you know, it's a bit of truth that didn't make it into the canon of knowledge production that constituted the law at that time. I think we've chipped away at that. What's called critical race theory has been more defined as a movement. But I still think it has aspects of a conversation. So in that sense, I think it's hard to attach anything but a relatively fluid meaning of exchange among participants who are not, as the current characterization would have it, simply a black-white debate. And that's the thing I find most troubling, and, you know, a real difference about the pushback right now. It depicts critical race theory as a singular position about racial oppression, which oppresses whites and says that whites are responsible for all historical sin. It doesn't distinguish, as critical race theory most carefully does, the actions of individuals or the feelings of individuals or the intentions of individuals from structural legacies. Critical race theory is concerned with structures, and structures are akin to that example I gave of the Barbie dolls. Whose fault is that? That's more embedded in a system of valuation that we need to examine, all of us, whether we're Black, white, Asian, recent immigrants, non-immigrants, whether anywhere we are in the world. And it seems to me that the reductiveness with which critical race theory has been described, and very suddenly, almost overnight, and as you say, it's been Manhattan Institute, Heritage Foundation, Thomas Smith Foundation, they have, through beginning with most vividly or most loudly, I suppose, through Trump's executive order back in November or December of last year, said that critical race theory is something that it's not. And in that sense, I think there's a great deal of confusion about what we're talking about. And that's a different confusion, but simply saying that both of us, two people sitting in a room talking about a particular racial problem are disagreeing. This is a colonization of the very meaning of critical race theory. And the fellow at the Manhattan Institute, Christopher Rufo, said it very plainly that he intended to co-opt the meaning. He intended to colonize the meaning. And he wanted to put into it all the meanings that would alarm Americans generally. And certainly it's become a rallying point for the Republican Party. Almost every Republican candidate running in the United States, almost overnight or within the last 6 months, suddenly has, I am against critical race theory. And then critical race theory becomes defined as something which is, this is intolerant, not just anti-racist, but anti-white. And I despair. This is a new form of McCarthyism on steroids, and that makes me very sad. Because that is a raw power grab, a raw act of colonization of meaning that is very hard to provide a rational riposte to, because you're not even responding within the same universes.
Does that tactic of misrepresentation that you're describing change how we as scholars should be responding to meet the moment?
Well, I think it's complex. I do think that if that it is important that we understand that there are two levels of conversation going on. And one of the things that concerns me about the way in which it's being discussed in popular media and on news outlets like Fox News, or even more conventional media, people simply haven't bothered to read what people have written. People haven't read what Derek Bell wrote. People haven't read what I wrote. People haven't read what Kimberly Crenshaw has written. To the extent they know anything about it, it's because Kimberly Crenshaw has been much more visible in media, and they hold her to her words, which are very coherent, very straightforward. I think she's done a great job of a counter-publicity, of holding people, holding the feet to the fire in terms of what the definition is, what the law school conversation has been about. But to the extent that she's gotten any publicity, it is completely drowned out by the larger misinformation, the volumes of misinformation. So if one is talking about the attack on critical race theory that has been put forth by very McCarthyistic forces, then I think we are talking about a political propaganda campaign in which it's necessary to talk about the function of unregulated news, supposedly news outlets like Fox or Newsmax, the unregulated power of technology to drive people into, echo chambers of the dark web. And so I think we're really talking about two different problems, and it's impossible to answer Fox News with the fact that, with the mere fact that this is what critical race theory is, this is what I have written. They don't give a damn. That's not what this campaign is about. It's not about me. It's not about Derek Bell. It's not about that writing. This is a much broader campaign. It seems to me to turn the entire civil rights movement into something which has been redefined as anti-white, and that's why it is alarming to me when when one looks at what the impact of some of these identical laws have had already, so that in some jurisdiction, people try to bar Toni Morrison's Beloved because it makes people feel bad. So if we're going down that route, that's Toni Morrison wasn't part of critical race theory. This was not about law. Nobel Prize winning novels can be taken out of a curriculum like that. Then we're talking about raw censorship, and we're talking about censorship in the true governmental sense. These are laws which seem to be barring the ability to read, or in some instances of these laws, very specific sets of readings, whether the 1619 Project or whether even Kendi's book on how not to be a racist. If we are making laws to bar what can be said or not said, then it's a different kind of constitutional crisis. But it's not about critical race theory as the conversation that began in the 60s and 70s and 80s, often attributed to Derek Bell's desire to talk about the successes or failures of what was a very mainstream civil rights effort to integrate institutions in this country.
There's something very meta in the CRT debate not being about text, but subtext. That's a core critique of CRT and jurisprudence. Those are all wonderful remarks. Now I want to explore a topic that I think we as critical race scholars pay inadequate attention to, namely the solidarity, collaboration, and tensions between critical race theory and Indigenous legal perspectives. And I'm thrilled to learn more about these complex relations with my colleague, Scott Franks. Professor Franks, you've been instrumental within the faculty at integrating Indigenous legal perspectives and orders in our curriculum and pedagogy, including in my own legal theory course, the syllabus of which is hugely indebted to your keen insights and generous support. As a scholar specifically interested in implementing the Truth and Reconciliation Commission's calls to action, including Call 28 concerning integrating Indigenous law and perspectives in law school curricula, what lessons have you learned from the process of integrating Indigenous legal orders and perspectives in law schools, and how can those lessons be applied to the process of integrating critical race theory? Additionally, what synergies, but also what tensions might exist between those two processes of integration?
Thanks, Josh. I kind of want to start with the question of tensions and synergies, more on tensions side. The addition, what critical Indigenous legal theory and tribal crit theory adds to critical race theory is to imagine ideologies related to settler colonialism and how they utilize processes of racialization, racial categorization, in order to fulfill a certain objective, which is the displacement of Indigenous peoples and the replacement of it with people designated as a settler class, often ethnically white, as founders, what Stephen Harper called old stock Canadians, and then new settlers, often identified as not necessarily white, sometimes also white, non-white, non-Indigenous populations that aren't associated with the founders. So what tribal crit and tribal crit and what critical Indigenous legal theory adds is that component to critique and understand the ideology, the structure, and processes of settler colonialism. And I think kind of maintaining a focus on how settler colonialism can also be a structure that can be used to relocate or reallocate resources among different settlers, some of which include racialized persons who are non-Indigenous. That's something that we want to maintain a focus on and a critique of. What critical Indigenous legal theory, as distinct from, as I understand it, sometimes tribal crit, although I think the distinction isn't much anymore, is a focus on the revitalization, not only the decolonization of settler colonialism, which would be the dismantling of legal and social hierarchies based on settler colonialism, the displacement of Indigenous peoples and the taking of their land. What Indigenous legal theory adds to it is a reimagining of a possibility of a different way of living under Indigenous constitutionalisms, under Indigenous legal orders, and it being a welcoming place for non-Indigenous peoples in order to be governed and govern themselves and live in relationships in that different structure. So that, to me, is the core tension between, not really a tension, but the difference between critical race theory and critical Indigenous legal theory. On the question of integration, there's two ways to look at it. One is I integrate critical race theory in my courses. I integrate it in my master's work. I think it's key to use critical race theory, focusing on process of racialization of Indigenous persons, because racial logics, racism is one of the means that settler colonialism as a structuring ideology uses to displace and then to replace and put in place Indigenous peoples in assimilated kind of roles. And so there's a variety of ways that I do that in my Indigenous and Aboriginal law classes. Race is a huge part of talking about the history of the Indian Act, and especially the way that race is almost hidden as a category in the application of status provisions under the Indian Act. Also in the way that people in just their day-to-day conceptualize who Indigenous peoples are. And we can see examples in society of Indigenous peoples being racialized and impacted by laws that are geared in that way, or by practices that the law doesn't really necessarily correct against. So stereotyping and racial prejudice related to Indigenous people's access to healthcare, differential child welfare and education funding for Indigenous peoples compared to non-Indigenous Canadians. These are all things that a critical race theory can help us understand. In addition, the experiences of Indigenous students, staff, and faculty members when they're trying to operate within mainstream Canadian contexts, like in law schools. But what I feel it sometimes lacks is to see that actually when we break it down, the core thing that opposes the major barrier to Indigenous law, Indigenous perspectives, is not just coded in racism, but is also about sustaining settler colonialism, a future for the economies that exist for this economies, the narrow focus of spiritualities on Abrahamic religions and not Indigenous religious practices, as we see in the case of Ktunaxa Nation. That is really what settler colonialism is about and forwarding. So that kind of answers how I integrate it into my Aboriginal Indigenous law courses. On the topic of like what I'm doing on integrating Indigenous law and how that can be beneficial for critical race theory, I'm kind of going to leave it here and see if you want me to proceed with that, Joshua, but I'm going to leave it for now.
I just have one follow-up on what you raised, which I think is really important. You know, when you talk about racial logics being one of the means of settler colonialism, seemingly then, you know, it's crucial when you're teaching about Indigenous legal theory and perspectives to not only come at them from a critical race perspective, not only because that would be incomplete, but because that could also actively obscure alternate means of settler colonialism. Is that a fair kind of description of what you're saying? Because I think that's a really helpful point.
I'm not too worried about it obscuring. I think there are parts where it can, if we think that racism is the only hierarchy of oppression that exists and relates to Indigenous peoples, the Canadian state's relationship to Indigenous peoples as it is today. I don't think it obscures it unless we just kind of focus on that solely. I see it as an absolutely necessary ingredient to explaining settler colonialism and as a precursor step before even having discussions about decolonization.
That's all great. That's really, that's super helpful. Finally, I want to get a bit more concrete in terms of critical legal pedagogy and scholarship. And I'm overjoyed to learn about how another critically inspired colleague, Angela Lee, informs her teaching and writing with critical race theory. Professor Lee part of your scholarship and teaching explores some of the complex relationships between food and agriculture, technology, the environment, and various forms of justice, including racial justice. What does critical race theory as a lens bring to your work? And in particular, how does a critical race theory lens inform not only what you teach, but how you teach it? Additionally, is critical race theory as a lens one additional perspective that you explore in your scholarship and courses, or does it reflect something more foundational about how you approach questions of law, equity, and social change?
Thank you, Joshua, for those questions. And thank you as well to my fellow panelists for sharing all of their really valuable insights and expertise on the topic that we're discussing today. So I'm going to try to address all the various aspects of what you asked. So I'll start by talking briefly about my research and then go on to talk a little bit about my teaching. So first, as you mentioned, much of my research in the past few years, including my doctoral dissertation, has focused on the relationships between food and agriculture, technology, the environment, and different forms of justice, including racial justice. And one of the primary reasons that I'm interested in sites like food and technology and the environment is because of the ways in which they're directly relevant to everyone. So to take food as an example, because we all need to eat to live, food affects us all the same way that law affects us all. So whether we like it or not, and whether we're aware of all of the different underlying issues or not. And so in this way, I think that food is a really valuable site to engage with broader questions about power, because every day we all make individual decisions about what we eat that have both micro and macro level implications for things like our health, for the environment, for animal welfare, et cetera. But not all groups have had equal power or access to the power to make the kinds of higher level structural decisions that determine the range of options that are available to us in making those choices. So as many scholars have pointed out, effective and equitable food systems reforms ultimately turn on structural transformations that are context specific. So it's not just about individual actions or small scale voluntarism. We really need to focus on the bigger picture here. So while it's easy to say that everyone should try to eat fresh, nutritious, local homemade meals or whatever, and as we're grappling with the climate crisis right now, there are a lot of other imperatives in relation to food that are being raised, such as the suggestion that everyone should adopt a plant-based diet, given the extremely detrimental consequences of industrial animal agriculture. But I think that that's far too oversimplistic a position at the very least, and amounts to moral imperialism at the worst. And it completely fails to acknowledge the historical legacy of colonialism and racism and the material impacts that they've had for different groups of people. So while there are areas of law in which race plays a very obvious role, like criminal law and immigration law, for example, I think there are many subtler ways in which issues of race are deeply infused into the law and legal institutions and other institutions of power and social ordering, and just within society more broadly. So CRT is really useful in that it helps us get a more accurate picture of what forces are at play in the present by thinking through what transpired historically and why. And CRT also helps us to imagine different kinds of futures and what it might take to make these more emancipatory alternatives a reality. So building on that, I would absolutely say that a lot of how I understand and approach various issues is influenced by my own identity as a racialized woman, which I think is inevitably true of all research and scholarship. So I think it's impossible to fully separate who you are from what you know and how you know it. And I think that taking a critical perspective on the law in general, whether that's through a CRT lens or otherwise, means accepting the tenet that the law is not and never truly can be neutral or apolitical. And we can't assume a degree of universalism that doesn't exist in terms of how people interpret and experience the law. So while CRT emphasizes the importance of asking questions like who has the power to make decisions and set the agenda, who gets to participate in decision-making processes, whose voices and narratives are being amplified and whose are being left out, it's not necessarily prescriptive in terms of solutions. And I think that there are legitimate disagreements that can be had on that front in terms of both the possibilities and the limitations of the law. So for example, we might ask whether or not legal change is the most effective mechanism for creating social change in all circumstances, or what the relationship between legal change and social change is more generally. And I don't think that there's one right answer to those kinds of questions. Now, when it comes to teaching, although I've taught upper year seminars on topics like food law and animal law previously at other institutions, all of my teaching at the Lincoln Alexander School of Law so far has been in the first year program, which I really enjoy because I think it's so important to establish critical thinking skills and attention to issues of diversity, equity, inclusion, and representation early on in one's legal education. And as for how to go about doing that, there are, I think, some obvious ways, such as not relying on the same tired canon of jurisprudence or privileging certain kinds of knowledge over others. But I think in addition to substance, there are considerations of form that are really important as well. So trying to cultivate the kind of classroom environment where all students, regardless of who they are or how they're situated, can feel comfortable sharing their opinions and their perspectives. And I think it's important for everyone, including instructors, to enter spaces of learning in a spirit of humility. So not assuming that you have all the answers or you know everything in an absolute sense. And more fundamentally, I explicitly start from the premise that systemic racism exists in Canada and that colonialism is an ongoing phenomenon. But to point to oppressive systems and the harms that they exert disproportionately on certain groups isn't necessarily to pass moral judgment on the people who have benefited from white supremacy, the patriarchy, and so on. So it's not about trying to ascribe blame, but instead it's to articulate and point out that there are experiences and perspectives that you might not understand because you haven't lived them. And so there's real value in listening to and learning from those who have suffered from racism, discrimination, and so on, and try to work together in solidarity to combat inequality in all forms. So even though you might not have created the rules of the system, you're still responsible for your behavior within it. And it's open to you to be part of the problem or to be a part of the solution. And both acts and omissions in this sense are political. So choosing not to do something can also be a political position. So I think teaching is always an iterative phenomenon. So you're not necessarily going to be teaching the same way to different groups of people in all times and at all places. And our students are extraordinarily diverse. They're a wonderful group. And so for many of them, I think that CRT is especially important because it furnishes them with the conceptual and analytical tools and language to help make more intelligible to them their own lived experiences of racism and oppression, including as facilitated through the law. So whether this is that which affects them personally, their families, their communities, or that which they might have witnessed secondhand. So to try to end things on a bit of a positive note, I think that teaching and learning about racism and other forms of injustice is not easy by any means. There are always going to be different kinds of challenges that arise. But I am constantly inspired by our students and their willingness to learn from each other and to have these kinds of difficult but fruitful conversations and really commit to generating change that is oriented towards justice, however long that arc might be.
Thank you for those wonderful remarks. And, you know, I'm newer to the faculty than you and Professor Franks, but I've had a very similar and wonderful experience with the students so far. There's one question that we've received from the audience that is, you know, a classic question posed in the context of critical race theory that I think is helpful for us to discuss. Someone asks, how can CRT overcome the problem of class? Major works of CRT are mainly read by the highly educated. I know there are exceptions, yet many CRT proponents were raised in and currently situate themselves in the upper middle class. It seems like this issue is central to determining the future of CRT and its pedagogy. I want to ask first, Patricia Williams, if you want to talk a bit about CRT and class and your views on that.
Yeah, I think it's one of the really, really distressing parts about the way in which critical race theory is being referenced. I think that there is such a definitional muddle, a Tower of Babel that has been superimposed on critical race theory that one forgets the extraordinary diversity of, again, what I refer to as a conversation of many points of view coming together. And it seems to be completely reduced to people who only publish in Harvard Law Review, it seems to be completely divorced from praxis and the practice of law, which has been so central to both the development and the subjects about which critical scholars have written. If one wants to look at Kim Crenshaw's African American Policy Forum, her work on behalf of that institution's work on behalf of women, poor women, the carceral condition of both men and women has been a central part of critical race theory's address, including education programs and legal programs in prisons. Even among the very small group of people who were at the beginning, as old as I am, we included people who were dealing with questions of anti-Semitism, Hawaiian rights, Indigenous rights in the United States, such as they are, it's I think it's too glib and too easy to say because you write and because you publish things, because you're literate in talking about this, that therefore you don't care about class. I think the class issue is a general problem for scholars. There is a kind of invisibility of class issues across the board, but this is not a problem that is disproportionately afflicting critical race theory. If there is any place in the law that deals with critical race, that deals with class, it seems to me it's within this group of scholars, this group of voices, this group of writings, and most particularly this group of activists. And indeed, it's sort of bewildering to me because on the one hand, we're accused of being socialists and Marxists and people who talk about nothing but class. And I think, again, if one actually reads the literature, if one reads the broad variety of concerns, it's an astonishingly varied and nuanced literature, again, emanating from a fairly small group of people. So,
no, the size says it all.
The class is it's so hard to talk about in the United States under any circumstances. This, I will acknowledge, it is a very, very hard topic to talk about, to be recognized for, to have published. But I think if anybody is doing it, it is among critical race scholars.
I want to pivot briefly to Scott as to whether or not there's any comments, or Professor Franks, I should say, any comments on class in the context of critical Indigenous legal theory.
Yeah, it's interesting. I think when we start with class, we're presuming a capitalist extractive mode, right? And that is a particular mode that is very facilitative of settler colonialism and the objectives of it. So there's an immediate critique of that, right? Of saying that, adding a class analysis to critical Indigenous legal theory, what is that actually giving us? Adding a class analysis to critical race theory might give us something when we're talking about egalitarianism for racialized persons who are not Indigenous in terms of equity for accessing economic well-being and health. But when it comes to the context of critical Indigenous legal theory, there is ultimately that tension with the broader goals of it, which is decolonization. And we see this tension in the example of Indigenous economic sovereignty and how it's conceptualized in community. As far as it goes to the critique on Indigenous scholars and professors, I think one of the things that kind of stands out for many of us is that our Indigenous ethics and research methodologies mandate us, require us to be back in community. That is literally the source of all of our energy and the legal orders that guide us. So if class is a comment about, if the class critique is a comment about one's disconnection from the grassroots, I don't see that as anything more than an ad hominem for the fact that we're present in universities and have went through university. There is a need for us to unlearn and decolonize a lot of the stuff that we've had to adjust to in order to communicate in university systems. But the general critique that we're cut off from community or are uninterested in it, I don't think is accurate at all.
Well, I cannot thank all of you enough for this fantastic discussion. I've learned so much. I hope our audience has as well. I wish we could keep going. And I consider the process, not the event, of integrating critical race theory in legal education to be something that is ongoing. As Patricia Williams says, it's a conversation. And so let's keep these conversations going. And I look forward to conversing with all of you on these topics and others in the future. So thank you very much.
Thank you.
That was fantastic. It gives us so much to think about. Thank you to all the panelists, bringing everything together, which is very hard with critical race theory, but think of what Professor Seeley Harrington was talking about with the current situation in the legal profession, with the attacks on critical race theory by Adventures of the Law Society of Ontario, which, in my view, not necessarily the view of the organizers of the conference, betrays a fundamental misunderstanding of critical race theory and a lack of respect of the importance of academic freedom. But more fundamentally betrays a lack of understanding of how teaching critical race theory is in many ways about teaching legal competence in advocacy. I'll leave that there. Now moving along, again, thank you to the panelists. We now have our breakout sessions. So here's how it goes. We have two terrific options for you. It's up to you to choose. The first option is the COVID-19 and mental health, ensuring a healthy and resilient legal workforce, moderated by my co-MC, Assistant Dean Tony DeMello. The second option is an EDI and big law breakout session, a peek into the progress of Canadian law firms and corporations, which is moderated by Aaron Baines, an associate with Aaron Bearless and the former president of the South Asian Bar Association of Toronto. So please go right now, click on whatever session you want to join either session. Please click on the Zoom breakout links at the bottom right of your screen. And just give us a couple of minutes to get started. And I'll see you back.
Hello, everyone, and welcome. This panel is about mental health and ensuring a healthy and resilient legal workforce. My name is Tanya DeMello. I go by Tony, and I'm the Assistant Dean of Students at the Lincoln Alexander School of Law. It's been my honor and pleasure to MC this day today and also be a part of this panel to moderate it. When the committee was coming together, we wanted to talk about the ways mental health issues have catapulted to the top of the agenda for every profession, and the legal profession is not exempt. We've seen everything from dramatic rises in depression to anxiety as a result of what it's felt like to live in emergency and constant uncertainty, lockdowns, and isolation. We also have to think about what it's going to mean as we come out of COVID, supposedly, or we transition to a new normal, as we've talked about today, that there will be a collective trauma of people who've experienced this and continue to experience the consequences or the continued effects of COVID and its ravage. And we need to think about how people subsist in the new normal. According to the Center of Addiction and Mental Health, over 50% of people surveyed shared that their mental health dramatically worsened as a result of the pandemic. And so we have to think about the fact that those with mental health issues before COVID, they've fared the worst in terms of impacts on their mental health. They're now experiencing sort of side effects, but also a community that continues to struggle, not always prioritizing the needs of folks that have long-term mental health issues. We thought it was really important to think about how this affects every profession, but the legal profession specifically. And we looked at the International Bar Association. It did a survey to talk about part of the problem isn't just having mental health issues, but over 41% of people that responded said they weren't even comfortable talking about mental health and well-being with their employers. They were worried it would damage their careers and livelihood, and you'll hear about that on the panel today. Lots of concerns came out around not having enough help, not having enough guidance, not feeling it was something you could bring to work. And more than 75% of folks in the legal profession that were interviewed by the IBA said that they really felt that their employers could be doing more to support them in this time. I want to highlight that it's a workplace issue, it's a community issue, it's an issue that everybody has had to bring to the front. And we do see that certain communities have been affected disproportionately, and we'll be talking about that today. So young racialized women, folks with disabilities, people that were already struggling with their finances, with job security, people who have dependents, people who identify as having disabilities, people who had mental health issues such as dementia and trying to get services and needs, newcomers to Canada, immigrants, refugees, people living in housing that is shared with many people, communal housing, right? Those folks have fared, have disproportionately been affected by mental health and COVID's intersection. So we have an incredible panel today, and I want to just get started by introducing them. And each one of them will speak from their perspective. Some will bring a very strong legal perspective. Some will bring a perspective of working in the community or working with vulnerable groups. Some will bring an educational perspective. And so we really wanted to have all of those here today. The first person I want to introduce is Beth Beatty. She's currently senior counsel at the Ministry of Attorney General in Civil Law Division, Ministry of Health, and Ministry of Long-Term Care branch. She also has a broad-based litigation practice. Beth was willing to share with all of us, and will share more today, that in 2002 she was diagnosed with bipolar disorder following a psychotic episode where she had to be hospitalized. Because of the stigma around mental health, not just in general, but specifically in the legal profession, she hid her illness for over 14 years and telling only very close people about it. And she endured a lot of angst around the thought that her colleagues and clients would find out about her illness and her hospitalization. In 2017, she made the decision to come out of what she calls the mental health closet. And she started speaking publicly. She has spoken widely. She is a friend of the Bell Let's Talk campaign. She's told her story of living and working with bipolar disorder. It's been featured across television, radio, and print media. And she's written articles about it and trying to help people disclosing mental health illness in order to reduce stigma and isolation. So we're so happy to have you here today, Beth. We appreciate it. Then I wanted to introduce Zara Juma. Zara is a registered nurse at a downtown community health center. She supports the health and wellness needs of racialized women specifically. Many of the center's newcomers, our clients are newcomers and refugees to Canada, single parents, individuals that have undergone significant trauma, individuals with disabilities. So the very groups that I was talking about that have been disproportionately affected by mental health. She also works with folks from Indigenous communities, LGBTQ2SI+ communities, and she's going to speak for the challenges from a health and well-being of the most vulnerable populations in our communities. Her experience in mental health includes having been a policy analyst at the Canadian Mental Health Association, a course instructor. She has a master's degree in public health from Columbia University, and together with these degrees in psychology and nursing, she has this in-depth understanding that she'll bring to the social determinants of individuals' health and well-being. So we're so happy to have you here today, Zara. Then I'd like to introduce a colleague I've worked with now for many years very closely, Dr. Jasmine Mendoza. He's a registered psychologist and professional counselor at our university, soon to be renamed. And he's at the Center for Development and Counseling here. He provides therapy and counseling to students on a range of mental health and developmental concerns. But in addition to these supports, and I know this well, having worked with him, he provides all kinds of consultation to faculty and staff on complex issues to make sure that there's a comprehensive response. Prior to working at this university, he provided support in a number of social services and criminal justice settings and has applied a very integrated, inclusive, and positive psychology approach to his clinical work and community work he delivers. And I've worked with him very closely. I can tell you his knowledge has made a big difference in our university community. And finally, and not last, but definitely not least, Dr. Tess Sheldon, who is an associate professor at the Faculty of Law at the University of Windsor. Her incredible research, including discussing coercive medication administration practice in psychiatric settings, has been really pivotal in our understanding of how this undertaking should be done. She scrutinizes law's possibilities to confront the regimes that reflect and reinforce economic and social exclusion of persons with disabilities and consumers or survivors of the psychiatric system. So welcome, Dr. Tess. So I'm going to start by asking each of you to speak for a few minutes to start us off, to share from your vantage point what mental health impacts you believe have resulted from the pandemic and its restrictions, right? Not just the pandemic, but what it meant to be isolated and working or studying from home. How have you seen these impacts and their consequences manifest in the legal sector if you happen to be working in that sector? And has there been any positive or increased focus about our understanding of ways in which we can support mental health in the workplace, in communities, in educational institutions and legal institutions? So I'll ask you to take from that what you will and give us a bit of an intro in your response to that. And if we can start with Beth, and then we'll move to Zara, then Jasmine, then Tess. I'll let you folks take it away. They're going to ask you to unmute, Beth.
Okay. You know what? I even put an unmute sticker on my computer, so I'd be sure to unmute myself.
Oh, it's every day for me, every day.
Thanks, Tony, for having me here today. In addition to having a bipolar disorder, I also have an anxiety disorder. And I understand clearly that uncertainty drives anxiety. And we've just had so much uncertainty in our lives over the last 20 months. As lawyers, we ask ourselves questions such as, how are we going to represent our clients properly when we can't even meet with them in person? And how are we going to carry out litigation via video conference? And what is returning to the office going to look like? I've seen some upsides to the pandemic. There is a greater understanding by leaders that the more lawyers can control our practices, the more our stress is reduced. The ability to work remotely, it has definitely had some downsides, but it's also had some positive sides for those of us who have a good setup at work or at home. It means that we have flexibility in how we work and when we work, and that leads to us being able to have more flexibility in terms of childcare, elder care, and self-care. And I certainly hope that flexible work arrangements become the post-pandemic norm. Another upside is that we're seeing more action taken around incorporating mental health into legal practice. Something that is small, but is symbolic, is that at every one of our weekly staff meetings at my branch, we have a mindfulness moment. And usually what we do is a short mindfulness meditation. And it sounds like a small thing, but it really gets the meeting off on a good track and gets us thinking about using mindfulness throughout our workday. There's more attention being given to CLE programs for mental health. The Law Society this past May put on a blockbuster 2-day mental health for legal professionals summit. There were over 4,300 registrants, and there were 28 people mainly speaking of lived experience. And it created a real sense of community of support in the legal profession. And there's going to be a second summit on May the 3rd, 2022. So the pandemic has taught us a lot about the importance of protecting and promoting mental health. And we need to translate those lessons into actions moving forward.
In my practice, I have seen individuals who, because of the social determinants of health, have been adversely affected even before the pandemic. Individuals who lack access to food security, individuals who have housing insecurity, who had precarious employment before COVID-19, who had mental health concerns before COVID-19, just like Beth pointed out. These individuals have been disproportionately affected because with COVID-19, a lot of individuals lost employment, which led to income insecurity, which led to food insecurity, housing insecurity, more than what they've experienced before. And with all of these impacts, it affected their physical health. And in some cases, they weren't able to access the medical care, the social services, the health services that make such a difference. And part of this was due to a lack of knowledge regarding what services were available, but also not being able to meet face-to-face with providers, not being able to speak the language. And can you imagine somebody who calls us and we have to rely on interpreters to be able to provide healthcare to them? Sometimes the message gets lost through interpreters, the message that they're trying to convey to us, the message that we're conveying in return. There's a lack of significant nonverbal cues that we're normally able to take into account, which we can't. So it's very difficult sometimes to provide medical care. And some individuals for whom English isn't their first language, and sometimes we're not able to find an interpreter for these individuals, they find it very difficult to communicate with us. And the accents, pose a barrier as well for us to comprehend what they need. So for these individuals, it's very difficult. COVID-19 has also posed challenges to individuals who are working parents and having to take care of their children at home and at the same time work. It's very, very difficult, and many of you have experienced this challenge firsthand. So these are some of the challenges that COVID-19 has posed. In addition, we see refugees, they've had significant barriers to overcome coming to Canada. A lot of access barriers. A lot of them have difficulty filling out forms to get OHIP, to get the International Federal Health Program, to get other benefits like CERB. And so, a lot of these difficulties pose additional barriers to them getting financial, legal, health, social service supports, and that plays out in their mental health as well. Not being able to see a provider face-to-face also poses its own challenges when individuals have mental health concerns, and it's very difficult for them to be able to connect with somebody when a meeting is virtual, and then you add on layers like language barriers, and it makes it even more difficult.
I would basically echo what Beth and Zara have pointed out. I think speaking specifically from a student mental health perspective from colleges and universities, I think it's fair to say probably for the general population, there's of course been increased stress and anxiety because of the pandemic. And I think that we can say the same thing for college and university age students. And of course, early on in the pandemic, and because of the stricter measures like quarantine lockdown, as been already alluded to, it disrupted everyday routines or livelihoods, and studying and going to class. And we saw, at least from the counseling center perspective, there were increased levels of loneliness, depression, harmful alcohol and drug use, self-harm or suicidal behavior, or on the flip side, more violence, actually. So we've heard a lot of partner abuse too, and people struggling or being in families where there was active abuse going on and having to help those particular students seek refuge in the middle of the pandemic, of course. And I would say that there's certainly an understanding of student mental health and how it's been exacerbated by the pandemic. And that's actually probably, I wonder if it's exerted pressure on the discussion on returning to campus sooner rather than later. But I will say this, that the levels of support, I don't know that we've seen increased levels of support. So with respect to staffing, I haven't seen an immediate change, not only just, here at our university, but probably at all the other universities that I, have colleagues at across the province. And I don't think that student well-being divisions have been given the runway to redevelop their support programs in light of this kind of new world that we're living in. And when I check in with, some of my counterparts in student affairs, they would probably say the same thing, right? That they, at least this term, have been asked to pilot what would it look like to have a return to campus, and all the efforts and energies they have in terms of kind of reintroducing back the programs that they used to have pre-pandemic. There seems to be very little attendance, and I think that there needs to be time and space to develop new programs, because I think there is a different normal, as you had alluded to earlier, Tony.
Thank you so much, Tony. I'm honored to be here in Dish with One Spoon territory in conversation with my brilliant colleagues. I came to Toronto in the late 90s and found Toronto to be home to a consumer survivor movement, mad people's organizing in response to the police killing of Edmund Yu on the TTC, eerily foreshadowing the killing of Sami Yatim in 2013. So this changed the way that I think about everything. So my work is about law's complicity in disability injustice. And there is no doubt that COVID has revealed that injustice, the structures that have been built to exclude people with mental health disabilities. So only some people with disabilities or some disability-related needs are vulnerable to the virus itself, but many more people with disabilities, including people with mental health disabilities, are vulnerable to the other effects of COVID, including poverty, barriers to employment and income support, inaccessibility of transportation, information and communication barriers. These stark, persistent inequalities have plagued the disability community way before COVID. They are the product of unconscious sanist biases about the value of their labor that rely on neoliberal understandings of productivity, linking someone's value to their ability to generate profit. So it took a pandemic for disabled people to get the accommodations that they've been asking for, that we've been asking for. And it's bittersweet, right? That suddenly we get the flexibility and the support that we've been asking for, but followed by the shock that actually this whole time they have been available. So it's certain that these accommodations are more available than they were before, but that's not because of some collective awakening or newfound empathy. It's because everyone is disabled, right? This relies on the social model of disability that imagines disability as caused by societal barriers and proposes that a person may have no functional limitations other than those that are created by prejudice, stigma, and stereotype, in contrast to the medical model of disability that characterizes disability as a physiological impairment, something wrong with the person. But with COVID, many people who were not labeled as disabled before were suddenly isolated, lonely, and disconnected. They were now disabled. That loneliness and exclusion is familiar to people with mental health disabilities. The isolation of quarantine is not new. And in a way, we are uniquely equipped for the pandemic experience. And according to SINS Invalid, a disability justice organization, they say, welcome to our world. I'll leave it there.
Thank you so much. And still, since I have you, Tess, I'm going to keep going with you. I found all of your contributions so profound, just looking at the ways in which we have to think about certain communities, we have to think about supports. And something that I want to highlight that Dr. Mendoza mentioned, like, what does it look like to properly resource the work? So Zara and Beth are talking about the need out there and some of the things we've been doing. How do we resource that work properly? So thinking about that is important. Since I have you, Tess, I'm going to ask you if you think that mental health access is a human rights issue. And if you think that we should be approaching mental health care through a systemic policy thinking approach in sort of your work that came out, I'd love to hear your thoughts, and I'll maybe take one more of you on that.
For sure. So COVID, no doubt, is a profound human rights crisis that has, like I said before, exposed persistent ableism and sanism that infects our communities. So sanism relies on implicit biases, unconscious attitudes about people with mental health disabilities as either in need of protection or unpredictably violent. It makes normal the practice of silencing and exclusion. It infects our jurisprudence and it affects our lawyering practices. So sometimes or often a pendulum is used to describe the way that we treat people with mental health disabilities. On one end is easy interventionism, paternalism used to defend coercive regimes. And then on the other is the vigorous assertion of autonomy, the right to refuse unwanted treatment. And it usually kind of boils down to a trade-off, right? But I'm interested in the prospect of recalibration. So mental health and health are allies with human rights. They are not conflicting obligations. Their relationship is synergistic, that human rights violations have mental health consequences, and preserving health requires respect for rights. And any focus on mental health has to be accompanied by attention to those rights.
Thank you for that. Jasmine, I'd love to hear if you have anything to add based on your lens.
Tessa said it beautifully, but I would just say that, yes, indeed, like access to mental health services is not only just a human right issue, it's a public good. It needs to be seen as a public good. I think the reason why we have wait lists, many wait lists for mental health services is because these systems and policies that we have don't prioritize mental health and don't view mental health being in the public interest. And I think this pandemic, alongside what Tess has spoken to in terms of what it's revealed, reveals that we haven't before seen mental health and mental well-being as being a public good. And so that's what I would probably add to the discussion.
Thank you. That's really powerful. Again, sort of thinking about how do we resource, how do we put our money where our mouth is, how do we put our energies where our priorities are? I think so important. Thank you both. When you were speaking, Zara, one of the things that really struck me was thinking about the ways in which we can really understand and work closely with folks that are from newcomer communities, work with racialized women, all the folks you work with that have experienced trauma. What role do you say that poor access to justice and a confusing kind of a legal system has contributed to in mental health of these individuals? And how has COVID and the pandemic affected them? So if you could share a little bit from what you're seeing from these populations.
So in my experience, individuals who have been affected by domestic abuse, who are refugees, who cannot return to their homeland, and who don't have access to legal supports and social services and may not even know which legal supports to access in the first place, what is available to them, they are the most affected. Oftentimes, they have to return to a situation where they are being abused, where there is no recourse to go to a shelter because they're so concerned about living in congregate settings and putting themselves and potentially even their children at risk for COVID-19 and for other adverse outcomes. And so these individuals oftentimes return to a situation which is very debilitating, and they're not aware of what social services are available to them. And I think that definitely affects their mental health. In addition, a lot of refugees who need legal supports for their hearings, who need legal supports for immigration purposes, they don't have access to these supports. A lot of meetings are occurring virtually, and a lot of the times there's a lot of bureaucracy processing their applications, which leads to them not getting the supports that they require and having to face a very complicated process, which really impacts their mental health, impacts their physical health. One more thing that I forgot to add earlier is that a really good service that has been provided is that Gerstein Crisis Center has partnered with the police, and that provides really, really good support to individuals with mental health conditions that are non-emergent. And so now we have counselors that are trained to respond to individuals with mental health concerns responding, and that leads to way better outcomes than the police responding. And when the police used to respond, a lot of these individuals felt criminalized, and a lot of these individuals weren't getting the support that they needed from the police, because despite the police knowing how to do their job and being very, very good at their job, they're not trained counselors. And so now with this partnership between the police and Gerstein, individuals are able to access counselors a little bit more easily for imminent crisis situations.
Thank you so much for that, Zara. And I think one of the really important things that's resonated as you're speaking to me is it's not just navigating the systems, it's some folks don't even know they exist. So just want to honor the work that you're doing every day to help communities access and know about these services and referrals, and so how important that is. As you were talking about sort of the intersection of policing and folks with mental health, I'm thinking about, Dr. Tess, who talked about Sami Yatin, who talked about these incidents that have happened, deaths that people have questioned and how they were handled. And so I wonder, Tess, how you would respond to this question.
I would say that saneism individualizes structural problems, right? By ignoring its origins. So it thinks about mental health as an individual failing rather than caused by institutional barriers, workplace barriers, and that these individualized approaches distort violence, that it distorts violence even into care, that care ends up being a pretext for control. So violent expressions of control, and I'm thinking in particular about mandatory leave policies at universities, they get justified as for your own good. So to me, there's no doubt that Satanism also needs to confront the complex ways that people with mental health disabilities experience discrimination, paying attention to the lived experience of discrimination. And I'm thinking about examples of anti-Black Satanism, including the police killing of Andrew Loku, Regis Kraczynski Paquette. And it's just so important that disability organizations and disability, that we can take account of the ways in which disability injustice has amplified gender and racial injustice during COVID, because to do otherwise risks a mechanical approach that sidelines intersectional identities, forces people to characterize their experience, and minimizes or even obliterates their lived experience.
Thank you for that. Dr. Mendoza, I'm wondering what you would add to this, given, you've been talking about the fact that poor access is at the heart of some of these issues. Do you have anything to add?
Yeah, I would say that the most vulnerable in our societies have the least access to resources, whether it be legal or health, in terms of what Zara and Tess have been already speaking to. And the inaccessibility to these resources create this kind of domino and exacerbating effect that's already been spoken about. And I think to myself that when I think about the most vulnerable, I think we owe them the most duty for care, right? And I base this on the code of ethics that I'm asked to subscribe to, and I gladly subscribe to, but it's like the most vulnerable, right? Do we have a duty of care to? And yet this pandemic has revealed a stark healthcare inequity, and it's shocking. It's just shocking, right? And what else has it revealed? It's revealed that the caring labor, so both professional and personal, right, forms the invisible backbone of this economy that we're in, and yet at the same time, we don't feed it enough. We don't give it enough resources, right? And as Tess was talking about, the intersectionality piece, right, of people's identities then get even further marginalized. So I would just say that it's a shame that it took a pandemic to kind of reveal who the most vulnerable are, and that we owe them even more of an extra duty. And I don't think we're doing that well.
No, I couldn't agree with you more. Thank you all for that. I'd like to spend a good chunk of time here. Beth, I was so moved to see, even in your bio, how much you share of your personal life and how it intersects with your work. I know that depression and anxiety are very high in the legal sector, and yet the lowest reportings. I have seen the stigma firsthand, where you become your diagnosis or you become your mental health issue versus that being a part of who you are, and people being afraid. And so the idea that you talk about coming out of the mental health closet and bringing up your mental health challenges to your colleagues and bosses, especially in this profession, I feel it's a very tough up culture. That's pervasive, this, buckle up, pretend you're fine, I'm fine, everybody's fine. And so I just want to hear a little bit about that experience. How was it for you? We have so many people on this call. We have students that are just in law school and have been there for a few months, to people that I think have practiced for many, many years. And I'd love them to hear a bit from you.
Yes, thanks, Tony. Well, it's interesting picking up on what Dr. Mendoza was saying about the difficulties that students are having. Well, that's going to transition into articling students and the challenges that they're going to face. Tony, you had mentioned at the outset that I have bipolar disorder and that I was hospitalized for 2 years, or sorry, 2 weeks. 2 years would have been even more problematic. And I was mortified by my diagnoses and the fact that I had been hospitalized. And I was more mortified at the thought that other people would find out about my illness, because as a lawyer, I want to be seen as unflappable. I'm a litigator, and I think that clients have a particular expectation that their counsel appearing in court or appearing in front of tribunals are going to be strong. And the idea of having someone represent you who lives with an anxiety disorder, potential mania, potential depression would be very problematic. So I kept my illness a secret for 14 years, other than telling my loved ones. I didn't tell anyone. until about 4 years ago when I made the conscious decision to disclose my mental illness at work. I was approaching 50 and I just was thinking about what does the next stage of my life look like. And I decided that I would come out. So it started with having a conversation with a few of my closest friends at the office, and they were wonderfully supportive. And then I approached my legal director and told her, and she was really wonderfully supportive. So I decided to do the hardest thing that I've ever done in my life, which was to make a presentation at one of our staff meetings to everyone there. And it's about 50 lawyers and staff. And the weeks leading up to that presentation were agony. I had a hard time sleeping. I had a hard time eating. I had pangs of anxiety shooting through my chest, but I was determined to make the presentation, and I did, and it went over remarkably well. Everyone was so supportive. They even gave me a standing ovation at the end of it. And not surprisingly, what was the hardest thing that I've ever done in my life turned out to be the best thing that I've ever done. Because once I had the support of my colleagues, there was no looking back, and I've been advocating ever since. And I've made presentations to well over 100 different audiences, and I am pleased and a little bit amazed to tell you that I've never received a negative comment to my face. No doubt there's the occasional sort of whispering behind closed doors, but I've never received any actual negative feedback myself. On the contrary, I've heard from a tremendous number of people that I've helped them feel comforted, I have helped them feel less alone, and that they're more willing to reach out and to get the support that they need. So I encourage others to share their stories of lived experience, even if it's just to one person at a time, because it can be cathartic, empowering, and wonderfully helpful to everyone involved in that sort of conversation.
I didn't even know how to thank you, Beth. And I will say, I know for the folks on this panel, we know how many people this will help, how many people that are watching that it'll support. I think of my students that have come and said, we're struggling in COVID, we were struggling before. But the people that you are going to give that opening to because of your courage, I'm very grateful to you. Thank you. I'm going to move to a question around where I'll ask Zara to comment first. Whereas a society, we seem to be talking and thinking about mental health much more. I find before, just maybe it's because 50% of people are saying that they were deeply impacted, but also for the first time, I'm hearing people say, I never knew depression till COVID. I never had anxiety till COVID. I'm hearing dentists say people are cracking their teeth. People are getting headaches from gnashing their jaw, from sort of worry of what it means to live in these unprecedented times. And it is a significant change from 15 to 20 years ago in my mind. But are we actually addressing mental health needs as a society? I'd love to hear what you think about that, Sarah.
I think that there are steps forward, and I think that what Tess also spoke to it earlier when she said that these supports have been in place, and we are now becoming more aware of it. We are now disseminating them widely to wider audiences. Things like the Connex Mental Health Helpline, which is a free 24-hour, 7-day-a-week helpline, providing confidential services, is being made more available. It was always there, but it's spoken about a lot more. In addition, we have corporate insurance companies like Morneau Chappelle offering mental health benefits that they didn't offer before. But we got to remember that these are available to individuals with private health insurance, and that individuals without health insurance, individuals who have not as yet qualified for OHIP or who do not have IFHP, which is available to all refugees, that these individuals are having a very difficult time accessing medical support for physical health needs. And so accessing mental health supports is almost unheard of. And then within the educational institution, we have students who are worried about disclosing their mental health concerns. They fear adverse treatment from their professors. They fear discriminating treatment from fellow students. And this has happened. So their fears, in a way, could be justified. And so not being able to disclose in an academic setting, not being able to disclose a mental health condition in an employment setting means that accommodations are not available to these individuals because nobody knows about it. And so it is in the best interest of students, of employees, to disclose their mental health conditions, because mental health is a human right, and receive accommodations so that they are able to live up to their full potential. But because of the fear, because of the discrimination, because of the harassment that still unfortunately exists, a lot of people are hesitant to come forward. And so that is why Beth's story is so incredibly valuable, because we see somebody who has achieved enormous success and has surmounted enormous barriers at the same time. And so it really gives others a chance, a glimmer of hope. And that is really, really important, to enable individuals to receive the accommodations that they need to fulfill their full potential. And that is what we want for everybody, regardless of their physical health, regardless of their mental health, regardless of their position in life. That's what we want for everybody.
Really powerful. And we've been hearing this today about what does it look like to even have universal design, so people don't have to ask, that we put it into the system so that there's supports for people. Yes, it serves everyone, but it disproportionately helps certain people that require it as a matter of course. So thinking about that, and also being very individual in what we do. Beth, would you add anything to that, given sort of your experience, and what have you seen changed? You told us, for a decade, you didn't share with anybody. What's different now? Is there responses that we need to be looking at? I'm going to unmute you again.
Yeah, I think we are seeing change, but we need to see more of it in the form of people, preferably senior people, disclosing the fact that they have mental health issues. And there are a variety of reasons for that. We need people to show that you can function at a very high level while living with a mental illness if you get the help that you need. And by disclosing our stories, we vastly improve the lives of those around us who are also living with mental health issues, because we help them to feel less stigmatized and less isolated. And I hear you, Zara, absolutely, about what students experience. I do think younger people are better at talking amongst themselves in their own friend group about mental health issues. Like I think we're seeing that. And I think we're seeing with young lawyers more of a movement to improve work-life balance. We are seeing that. It's tricky though, so we got to get it happening from the top down as well, not just rely on young people being advocates for themselves. So if leaders step forward and disclose their own mental health challenges, there is a much greater likelihood that change will occur at workplaces, that it's not just going to be talk, that there's going to be action. For instance, something that I'm very concerned about is making sure our workplaces have accommodation strategies in place for people who are struggling. And it's also very important that there be smooth return to work policies for those people who do go off on mental health leaves, because some of the most troubling stories I find are young people, or older people as well, but mainly younger people needing to take leaves. And then when they're ready to come back, it's not a smooth transition. So I really think that we have to do some work in that area.
Thank you so much, Beth. I've got one more question, and then I have a couple of questions from the audience that we'll use to close up. And I wanted to start with Jasmine. Dr. Mendoza, I want to get a sense from you, and it's a big question.
Okay.
So, but it's what do you think are fundamental changes to the education system that need to be made in order to better support student mental health?
Yeah, that is a big question.
It's huge. And is it a different answer than you would have had for me pre-COVID?
My initial response would be that I don't think it would have been, right? I think I've always seen these needs. I think that, again, the pandemic has probably revealed that this is what we need to do. In terms of what I think actually needs to change within the education system, in addition to academic accommodations, academic consideration policies need to be more flexible. And I think part of it has to do that we view wellness in almost a categorical way. And I think we need to see wellness on a continuum from languishing all the way to flourishing and everything in between. And I don't believe our policies and systems actually reflect this continuum. We're either seen as being well or not well. And it's much more, there's much more in between, especially if we look at the positive psychology literature. It'll show that there's actually different ways of being. And kind of like what Beth has also spoken to, right? We need environments that actually welcome our authentic self, and we should be free to bring our authentic self, right, to the workplace or to the educational institution. If we don't do that, how do we have a better society in some ways, Policies and practices, I also think, need to be trauma and violence informed and be mindful of intersectionalities with respect to our students. And I would probably even extend that to faculty and staff as well. And we need to expand student well-being services and provide administrative support to faculty managing the academic considerations. So it's all well and good to say, students can have academic accommodation and consideration, but if you're a professor, it's like, how do you manage all of that, right? And so then that becomes really stressful for them. I think quite often it's misunderstood that faculty are pushing back because they don't want to provide accommodations. Actually, they're pushing back only simply because they don't have the resources to actually properly deliver the considerations and accommodations that students are requesting. And I think most importantly, the education system needs to return to the idea that we as students, staff, and faculty and administrators, we all belong to a learning community, and that we all play a part in providing care to each other, and not just relegating it to individuals who provide professional caring labor, right? So, professors need to take interest, staff need to take interest. And I'm not asking, faculty and staff and fellow students to be counselors to one another, right? But to kind of play their part, And so when I look at one of the questions, in the Q&A, it's like, what do we need to do, right? I think we need to kind of notice, those that are struggling, engage with them, and then refer them to the proper places instead of leaving it up to them to figure out where the systems are, right? And where the systems lie.
Wonderful. Tess, would you add anything to that? Because I know this is both your area of research, and as a professor, I know how much you care about this.
I definitely care about this. And, I would say that, I've talked about saneism already, and I would say again that sanist stereotypes infect all areas of law, including the way we teach law. So disabled students continue to face barriers in law schools pre and during COVID, and accommodations are often provided on the basis of the medical model of disability, that there's rigid requirements for medical documentation. There's no doubt that attitudinal barriers abound, including allegations of special treatment, being told that accommodations are too expensive, or that students need to get used to the stress of the, quote, real world. But the ability to handle stress is not an occupational requirement, particularly when that stress is caused by more competition in law school, unrealistic expectations, higher tuition, and debt load. So now more than ever, accommodation processes have to be inclusive and accessible, and require baking in a culture of rights. And I think part of baking in a culture of rights requires including disability justice, mental health justice right in the curriculum. So building a more inclusive and accessible, fair law school means that we will graduate students who are better able to build a more inclusive and accessible community. And as I'm thinking about this, I hinted at it earlier, I'm thinking about emergent contemporary questions about mandatory leave policies. So these are policies that have been adopted by post-secondary institutions, including U of T, where students are placed on mandatory leave if they pose a risk to themselves or to others. And these mandatory leave policies have had a chilling effect on students who seek mental health support for fear that the policy will be applied to them. And the Human Rights Commission has expressed concern about these practices. And if you're interested in learning more, I know the Students for Barrier-Free Access at U of T has a lot more detail on their website, including a petition. And I'll just close by saying, I just want to echo Jasmine's comments about being trauma-informed, because I think that the way that we teach law students has typically privileged facts, right? That we rarely attend to, like emotive or affective expressions. And this can, at the end of the day, expose students to trauma or secondary trauma. We know that lawyers are themselves particularly vulnerable to secondary or vicarious trauma. So echoing everything that Jasmine just said there.
Thank you so much. We only have a couple minutes left, so I'm going to take one of the questions, which is, what do we do from here? What's one thing we can do to improve? Where do we head? And if you folks could just give a little bit each, I'll start with you, Beth, and we'll just be conscious of time because we only have a couple minutes. The mute button. It's like me, Beth. I have the same problem every time.
Oh my God. First off, have mandatory training in place, especially for managers, about mental health awareness. Put into place effective mentorship and allyship initiatives, including peer review, peer support programs. The Law Society has a very effective one through Homewood Health, which is part of our members' assistance plan. Increase benefit packages. We're seeing a number of firms go to $5,000 a year for psychotherapy. Scotiabank this past Tuesday, for 50,000 of its employees, has said they're raising it to $10,000 a year. If the bankers can do it, the lawyers can do it. Just generally speaking, be creative about how to embed good mental health into our workplaces and our schools.
Thank you. Jasmine.
I think we need to move towards a culture of care, right? So that people can disclose and be authentic and bring their most authentic selves to work or to school for that matter. And I would encourage all leaders to lead with compassion.
Thank you so much. Zara.
I think that we need to implement comprehensive workplace health policies within all workplaces and look at that as not just implementing, a program or an initiative, but just looking at what are the needs of the workplace and how can we best meet those needs and how can we put into place evaluation so that we know that what we've implemented is successful and has had an effect. So comprehensive workplace health, getting partnerships between interdisciplinary professions just to make sure that when we are addressing the needs of the most vulnerable, that we have partnerships between lawyers, between the medical health professionals, between social service providers, so that we can provide holistic care to individuals, especially individuals trying to navigate complex legal systems and complex medical systems. And then just training is always a good thing. So more training would always be beneficial.
Thank you, Zara. And Dr. Sheldon.
So fast. And I would just say that any approach forward would require a fundamental shift, thinking about people with mental health disabilities as rights holders, thinking about the law's utility to advance their emancipatory claims. And so these accommodations like online learning, working from home, basic income, these are not benevolent gestures or pandemic extras. These are obligations that are owed to workers.
Thank you all so much. I wish we had more time. I wish this was a half-day session. Your expertise, your lived experience, your compassion, and your connection to folks that are experiencing mental health issues in ways in which we can respond has been illuminating and extremely significant. I think we need to talk about it more. We need to act more, and we need to resource this work is what I'm really hearing from all of you, and to really acknowledge who is suffering in these situations. For those of you watching, you are now going to get an 8-minute break. We went slightly over, so please grab something to drink or eat, have a bit of a stretch. And the next session will start promptly at 3. It's a main plenary, and it's called Balancing the Bench, a conversation about advocacy on EDI and racial justice. It's actually being moderated by the Honorable George Straffy, which is the Chief Justice of Ontario. We're lucky to have him with us today, and so we hope you can join us at 3. I am so indebted to all of you, Beth, Zara, Jasmine, and Tess, for taking time out to do this, and it's very obvious how much you care about this work. So thank you for your work every day. Thank you.
Thank you, Tony.
Good afternoon, everyone. Thank you all for joining us, watching the panel, the participants numbers rising. So it's great to see everybody here today on this wonderful Saturday afternoon. We're going to be speaking today on EDI and big law, a peek into the progress at Canadian law firms and corporations. Myself, I'm Aaron Baines. I'm a partner at Airden Burles, the former president of South Asian Bar Association and current secretary of the South Asian Bar Association North America. I'm joined today by some incredible folks, and I'm going to give some brief intros to them, but they don't do any justice to the work that they're doing and have done. So first up is Solomon McKenzie. Solomon is an associate at McCarthy Tetrow in the litigation group. He received his JD from University of Toronto, Faculty of Law, and his master's and BA from McGill University. He's received numerous awards during his studies and was the U of T president of the Students' Law Society and the co-president of the Black Law Students Association and Out in Law. Solomon was called to the bar in 2020. He's a member of the Law Society of Ontario, the OBA, the CBA, and the Canadian Association of Black Lawyers. It's great to be joined by Solomon today. We also have Lale Mushiri. Lale is the National Director of Diversity and Inclusion at BLG. Under her leadership, BLG was recognized as one of the Canada's top 100 diversity employers, and Lale herself has received the Canadian Centre for Diversity and Inclusion's Practitioner of the Year Award in 2017. She received her BA in History from Williams College and her law degree from U of T. She was called to the bar in 1994 and began her legal career at BLG, later transitioning to the firm's administration in 1998. She has over 20 years of progressive responsibility and experiencing in managing professional talent at the law firm. Thanks so much for joining us, Lale. We also have Leila Rafi. Leila is a partner in the Capital Markets Group at Macmillan LLP. She advises on a broad range of securities law matters and is highly transactional practice, including many corporate financings. She also has expertise in investment fund and asset management industry work and considerable experience in structuring and advising foreign and domestic investment funds. She's a prolific speaker and writer, having co-authored several lengthy white papers. She won the Lexpert Rising Star Award for top Canadian lawyers under 40 in 2018, and Lexpert ranked in 2021 as a leading lawyer for capital markets. She's also noted as the best lawyers for corporate law over the past several years. She's a member of the Securities Advisory Committee at the OSC, teaches at several Canadian universities, and is a mentor with the University of Toronto Women's Association program. Wow, 3 incredible speakers who I'm sure we're going to learn an incredible amount from. And I will, and let's get started. We're going to start off with, just to give a little description to those who are attending, we're going to have a little bit of a structured questioning period with the panelists. But at the entire time, feel free to send in your questions on Zoom. You can do so via the Q&A link at the bottom of your screen. It's good to send them in whenever you like. We get them, we'll take a look at them, and we'll be able to address them at the end of the panel, but feel free not to wait till the end. We're going to start off with a kind of general question, but important one for everybody. And I'm going to start off with Solomon, then Lale and Leila. What do you think are some of the biggest challenges, or for that matter, opportunities in overcoming barriers to diversity and inclusion in law firms across the country?
Thanks, Aaron. I think I would start with opportunities and then work through challenges. So I'll just do, one quick opportunity and then 2 challenges. And the opportunity is really that there's just such a clear and obvious business case for having equitable and diverse teams in general. We now have a ton of research which shows that you get more complex decision making, you can come up with better ways of digesting complex problems, and you're more able to think multilaterally when you have diverse teams. And when we're thinking about legal practice, which when push comes to shove is about selling our thoughts and selling our thinking, it's kind of a no-brainer that having more diverse and equitable firms, more diverse and equitable profession is for the benefit of all lawyers, all employers, and society at wide in general. I think the 2 pieces that folks are putting a lot of energy into at the moment, and I know at McCarthy's we've been doing a ton of work internally and externally around this, is around the retention piece and the pipeline piece. So the retention piece is, I think a lot of folks will talk about making sure that there are diverse folks represented at the table. Retention is moving past, there just being a seat at the table, and thinking more deeply about if you have a voice at the table, if you're thriving at the table, if you, to push this analogy further than any of us needs to talk about furniture, whether you're enjoying being seated at the table in the first place. and you know, there's a lot of structural work that we can do internally around that, and more broadly, stuff that we need to be doing in the profession as well. And I know we'll be talking about that further as we go on today, and I'll have an opportunity to talk about some of the stuff that McCarthy's has done as well. But additionally, I think there's the pipeline piece as well, which is when push comes to shove, if we're not making sure that we have applicants who are moving from high school into the undergrad space through law school and then being in a position that they can join the profession, then it really doesn't matter in the grand scheme of things how much we're doing at the profession stage, because we still need folks who've been put in that position in the first place. And that's some work that firms can do in community and in cooperation with law schools. And then that's some work as well that we need to be reaching out to community partners to really be able to drill down on.
No, brilliant. Thank you, Solomon. I agree. And I think it's interesting. The first thing you said, someone asked me a question yesterday about how does my background is an issue to me. And I said, I've never seen it as an issue. I said, nobody else in the room of white Anglo-Saxon males has any experience of being Punjabi. I have an experience they'll never be able to have, unfortunately. And that brings diversity of thought and experience. So that's great. And we'll talk about some of those solutions to the pipeline and retention later on. But I'd like to hear now, if I could, from Lale.
Thanks, Aaron and Solomon. I'd like to echo everything that you've said, but I'll sort of be a little bit more specific in my response and say that I actually think one of the biggest challenges that we face is unconscious bias. We all have unconscious biases, and those biases have become baked into our systems, really. And then we have microaggressions, which impact our interactions, are all around us, and are essentially those unconscious biases come to life, if you will. Although actually, I think I'm going to stop myself. Aaron, you shared a great article with us prior to this session. And so I think I'm going to correct myself and not use the term microaggression and use a term that was actually new to me after reading that article. And the suggestion by the author was that the better term is subtle acts of exclusion, because really, when you look at microaggressions, those two terms, there's nothing micro about what's happening. They have a huge impact, particularly the cumulative impact. And then aggression almost implies that there's malice and intent, which really isn't the case. So if I can start again, I'll say the challenges are unconscious biases and these subtle acts of exclusion. And they're difficult to address because they're much more subtle. And I think this is where the hard work really comes in. And you have to work at taking the bias out of the systems. And you also have to work at taking bias out of individuals, although there's certainly research that suggests you can't actually take bias out of individuals. But I think what you can do is raise awareness. And that is something that needs to be done on an individual basis. So I just want to perhaps illustrate with an example and use work allocation as an example and talk about a little bit of what we've done. So, I mean, anybody knows that, you know, at least in the law firm setting that I'm familiar with, the work that you get, the opportunities that you get have a huge impact on your success and your progression. You know, they impact your hours, your skills development, your path to partnership. But there's a very strong affinity bias. There's also a strong maternal bias. So we need to think about how we interrupt that bias. And so, you know, we've done a few things. I mean, we started with, you know, writing a piece about bias in work allocation and sharing it with all of our people. So that was sort of a general awareness raising exercise. But here's the challenge, I think. I think when you have decent, well-meaning people, they don't feel that any of these discussions apply to them because they don't think that they would ever do anything intentionally to hurt someone. So we took it one step further, and we started sharing delegation statistics with our partners, and those delegation statistics were broken down by gender. So partners could actually see in black and white who they were giving their work to. And again, broken down by gender. And that was just an incredible eye-opener for some people. And I had people who picked up the phone and called me and said, I had no idea I was doing this. 50% of the associates in my group are women. And based on these stats, I'm giving, only 30% of my work to them. So then, that was, again, awareness raising. And then the next step really is we're working on developing a work allocation system and that's really about addressing the system and the biases that have been baked in. And so the allocation is anonymized based on a number of factors. Including, whether the associate has capacity, whether they've done that type of work before, et cetera. So sorry, perhaps I took longer than I should have, so I'll only mention the other challenge that I wanted to reference, and I think this is a challenge really for all of us, and that is the lack of good demographic data. It's a challenge for the profession. We don't have good data from the law schools, from the law societies, and so it also becomes a challenge in our firms.
Wow, that's a lot of very important information, and I'm kind of seeing a bit of a theme, not a theme, but a storyline developing here. Solomon's referring to retention and pipeline. We're talking about getting into the firms or getting into the corporations, and Lali's giving some very concrete and really eye-opening examples of what comes next, which is not just restricting and stopping exclusion, but also creating a pathway for inclusion, right? Systems to make sure that people are getting the work that's fair and complex for everybody. Right. And just for everybody's benefit that's listening in, the article that Lali was referring to that I circulated was in the Advocate Society. It was You Don't Look Like a Lawyer by Megan Keenberg. I highly recommend everyone take a look. I learned a lot in that. And we'll share some of the solutions that were in that article at the end, because I think they're very helpful tips. But that's great. And then now, Leila, over to you for this.
So those were great points said by my co-panelists for sure. So, I don't have a lot more to add to that other than I think, law firms like a lot of companies have a huge opportunity. I think there's been a renewed focus on equality, diversity, and inclusion, particularly in the last few years, particularly, with everyone changing where they work, all the different events that have happened around the world. So I think there is kind of a huge opportunity to shift the industry a little bit. And I think that, things are being discussed more than they were being discussed. And I think that people want to do better and firms actually want to actually do better. And I think, for me, when I look at this, I think firms' culture is one of the most important things in terms of whether or not it encourages diversity, inclusion, and equality. So I think it all comes down to culture. And what's culture? It's your people. So are your people comfortable with giving feedback? Are your people comfortable with talking about their day-to-day experiences? Are you talking to your people? Are you actually communicating with all the different people, not just the equity partners, not just the income partners, but staff, the paralegals, the articling students, the lawyers on secondment from other offices. Like, I think it's all about opening the lines of communication, making sure that people feel comfortable raising their hand and actually talking about their experiences. And, I think that can be challenging for law firms sometimes because there are so many people within these huge kind of Bay Street firms. So I think that's kind of where we have to focus our efforts. Like for my firm, Macmillan, we've created a diversity and inclusion council, which is made up of different people at ages and stages with different backgrounds, and they actually report into our senior management team with recommendations on diversity, inclusion, and equality. And how they do that is that they're supposed to collect feedback from all the stakeholders within the firm. And so, it's a huge kind of task, but that's one way where we've tried to approach this issue of culture and just making sure that all the voices are heard. Because you know, it takes time for things to change in industries, and law firms have law firms have undergone quite a lot of changes, I think, in recent years, and there's just actually different paths to things in law firms. There's not everybody takes the same path within a firm. There's many types of jobs or positions available, and so I think just making sure that you have a healthy workplace where everyone has an opportunity to get access to this work that Lala's talking about, to get credit for the files that they're working on, to get meaningful opportunities to participate. Like, those are the actual things that, you know, make a really good lawyer and are able to form the basis of a really meaningful career. So I think for me, it comes down to culture. That's kind of the opportunity firms have.
Brilliant. I think that that fits in well with this, thought process we have with this timeline, which is, retention and pipeline, reducing exclusion, increasing inclusion, and then of course, once you've put those programs in place, ensuring the environment is one where people feel comfortable raising concerns about the, anti-exclusion and pro-inclusion policies. And Solomon, I think you want something to add to that.
And just to jump into that, also just to build out the types of structures, which mean that you're providing opportunities for your diverse employees to be providing feedback on stuff that you can fine tune within the workspace, but where they're not disproportionately holding the burden of doing that work as well. And so something that's been really important inside McCarthy's is we have kind of 4 verticals that do work around race, ability, LGBTQ2S plus identity, and gender identity, which have a very broad-based buy-in from folks across the firm, not just people who are from those identities. And it gives us a space for us to allow for the expertise of kind of the lived experience of folks within the firm to provide direction in terms of both internal and external work that we want to be doing, but also that there are enough hands so that all the heavy lifting isn't being done by diverse folks, and that you don't have 2 jobs, both as a lawyer and as a diversity and inclusion consultant every day, just some days, just Saturdays.
Yes, it's very true. Often the burden unfortunately falls on those who are affected by these things. But I think it's critically important for firms to create the infrastructure that alleviates that burden. You can't not have those people involved because it's their, as they say, lived experience that we're trying to address, right? But the burden of work shouldn't be on them. And in that kind of note, I want to pose a question to Lale about, what are some, you mentioned a few practices that BLG was doing, but what are some other kind of promising practices that you've seen or that you've implemented that can help address some of these diversity issues? Oh, Lale, you're on mute right now. Yep. Had to happen once.
Exactly. You think the last 18 months would have taught me. So lots of, maybe I'll start with a recent initiative that we've rolled out, and it is a sponsorship program that is geared towards women and members of underrepresented groups. We looked at the data at our firm, and one of the pain points, and I frankly don't think this is just our firm, is the whole issue of advancing women into partnership. So, our associates are over 50% women, but those numbers are not reflected in our partnership. So we had to look at what was happening. And of course, there are many, many things that could be going on. But certainly, as I mentioned before, I mean, the affinity bias is strong. The maternal bias is even stronger. And there's research that suggests that in order for people to advance in their career, they need a sponsor. And that same research suggests that women are over-mentored and under-sponsored. And so, just maybe I'll just pause and just quickly talk about the distinction between the two. I mean, a mentor is someone who focuses on your skills development, and a sponsor is someone who focuses more on your career advancement. And, people say a mentor talks to you, a sponsor talks about you. And that sponsor role, again, is really important. And so what we did was we started to collect data. We wanted to see how much of a sponsorship culture do we have at our firm? And we actually discovered that we do have a very strong culture of sponsorship. And a survey of our women equity partners, we surveyed them to find out what they thought had led to their success at the firm, in addition to their hard work. What other external factors was it? Was it a sponsor? Was it, training programs that we had sent them on? And in fact, the vast majority of people, I think almost every single person, said that sponsorship was key and that they had had a sponsor. We then surveyed our associates, and we found, based on that survey, that in fact, when men were being sponsored at a higher level than women. And so we felt that that was an opportunity for us to intervene and to try to interrupt the various biases. And so we've rolled out a program where we are assigning, and sorry, I should step back. Again, the program is geared towards women and members of underrepresented groups. We didn't define underrepresented, and in many ways that was deliberate, because some dimensions of diversity are apparent, others are not, and we felt that people would self-identify. And so we've rolled this out. We're actually in the process of matching our sponsors and proteges, and we have measurable goals that are in place. We have reporting requirements, and I'm happy to report back in a year to see what the impact of this program has been.
No, that's brilliant. And you're right. There's a natural mentorship and sponsorship that happens organically, but not everybody is as fortunate, right? Like a lot of people I see, I thought, I wish I talked to that associate before, because we could have connected them with an opportunity after the fact. And I'm one of, I'm sure, many people who've been very fortunate to have brilliant sponsors. I'm in the office, and next door is Tony Joya's office, one of the biggest sponsors I've ever had for many things, including fixing my car occasionally. I think awesome. they're critically important. And so I want to kind of now go from, we've talked about some kind of not just high level solutions, but kind of institutional changes that Lale was referring to that are very important, and we'll touch on them later, but maybe a few examples of ways in which the panel has seen microaggressions or subtle acts of exclusion and how you've addressed them. And maybe we'll start with you, Solomon, if you have some thoughts on addressing these areas.
Yeah, it's complicated. I think the two which probably crop up the most consistently in my career is, one, I do some criminal work as part of my litigation practice, and I am very consistently being mistaken for a defendant, even when I'm in a suit and carrying all my materials with me, which, there are complex reasons why people interact with the criminal justice system. So I don't want to make it appear that that's, a horrible slight upon me as a person, but after a while, you start to notice that pattern. And similarly, I think I maybe have a bit more of an appreciation of how much security there is around courtrooms and courthouses in general, in a way that some of my colleagues have maybe not reflected on again, because I get ID'd a lot. And that's complicated because it's an external force that's kind of trying to very explicitly tell you, you don't look like you should be inside this profession, and we assume that you're not. And that, in an already very stressful career, can be complex to have that kind of lacquered on the top of it, because you really want to be focusing on how you're going to be helping your clients, not making sure that you have easily accessible ID. I will say that folks who have made it to this stage in their career are well equipped to be navigating those types of experiences. So I'm always a bit hesitant to underplay that in any way. And so I know a lot of folks on this call are potentially law students, for instance, or racialized practitioners in some way. And the tools that they've been using to get themselves this far in their career will continue to unfortunately be relevant throughout the rest of their career in many ways. I will say the two things that have been super important to me is one, just finding allies within my workspace who can understand. I think the somewhat complex thing about microaggressions or experiences which are fleeting and based on implicit bias, like Lala was talking about, is that the outcome that I would never want from that circumstance is for someone, for instance, to lose their job, or for there to be a serious focus on an individual rather than the systemic and social context, which result in people making snap judgments which are bad. And that puts you in a bit of a complex position when you're having an experience that is definitely negatively impacting you, but where you don't necessarily always know that you want to be using some of the traditional pathways to complain because of the implications that will have for a specific individual. So finding allies who I can talk to about these issues and who will reflect the types of support that I'm looking for inside my workspace and outside of it has been very important to me. Having someone who can give me kind of an external view on whether this is the type of experience that I can digest and get to seek support for, or the type of thing that I need to be pushing for next steps for, that can be helpful as well. And then the final piece, which is maybe more psychological and an internal thing, has been me trying to reframe some of these experiences as well. I genuinely believe that, for instance, Black folks are particularly well positioned to become amazing advocates because we have often spent the entirety of our lives having to advocate. We've been put in positions where there are assumptions being made about us, and then we've had to use various tools to navigate that, which is just a lifetime of soft skills that are directly related to what my day-to-day work is. And so thinking through some of the strengths, not that that justifies in any way, shape, or form that experience, but some of the strengths that have come from that and the resilience that comes from those experiences has been important for me to feel less fatalistic about some of these experiences. I think I'll leave it there.
Yeah, no, I think those are very important points. I think that before we ask Leila the same question, just to open up some of those comments that you mentioned there, one of them is being misidentified is a major issue that occurs for both women and people of color in courtrooms and in meetings, quite frankly, in many different instances. And one of the good tools that was mentioned in the article was ask for clarification or more information, almost make it apparent that it was a mistake without kind of punishing. And that's kind of the second thing I wanted to note on what you were describing there, which is that, not to use a biblical reference, but we're hating the sin, not the sinner, right? And I think that often many people get very put up against a wall because, as the article notes, it's fundamental to their identity that they're lawyers, they uphold justice. The very thought that they're excluding somebody is contrary to the very thing that they're meant to be upholding on a daily basis, whether corporate law or barrister practice, it doesn't matter. Public, it's similar. And the nature is more of trying to get people to understand, no, the thing that you said was just based on perhaps a misconception or something you didn't know. Allow me to perhaps educate you on the topic. If you continue to make the mistake, though, that's a different thing, right? But just because I pointed it out to you, and I think that's a very difficult thing for people in our position because we don't want to have an angry discussion with people who are our friends and family and colleagues and whatnot. But it's critical to understand the difference between what we're doing. It's not the punishment, it's actually the education piece. And Leila, how about you? What do you have any thoughts on this?
Yeah, I mean, I think what you just said makes a lot of sense, and it ties back to something Lala said, which is, a lot of people don't even realize what they're doing. So it actually has to go to education, awareness, getting the information, getting the tools to be able to understand why certain behavior is, inappropriate or incorrect. And so, the question is an individual question. So, I'm going to be totally honest and say I have suffered these kinds of situations based on my gender, based on how I look, based on not being married, based on, being Persian throughout my career. So, I have acquired the tools necessary to deal with those things, and all in different ways. I mean, sometimes it's easy to actually just raise it on the spot, or not easy, but it makes sense in the circumstances. It's very individualized, so it depends on what you're comfortable with. And typically it's been a very good discussion back and forth when I do that. Other times it's been a bit more challenging. I did enlist the help of a coach years ago when I was a younger lawyer because I couldn't actually deal with the situation on my own. And so I found my employer of the time was quite receptive and open to assisting me, and I had a coach kind of help me deal with the complexity around that situation, and it was effective. So it was effective. All the communication changed. Everything around it changed for me, and I would say now that I'm older, and I'm 13, 14 years into my practice, I find I have more tools available to me to be able to deal with this type of thing. And when I do mentoring, I sometimes got questions on these types of things, and I find I have, information, and I have the language where I can share my experiences, and that's meaningful, I think, for others. And so, for me, it always comes down to kind of sharing information, building awareness, and just making sure people aren't afraid to actually put up their hand and say things again, because many times I think in the past things have just been said or done, and nothing's actually been addressed, and I don't think we're in that climate anymore. And I think this is the opportunity for law firms again to kind of do better and make sure that we're providing kind of a healthy, inclusive workplace for all. So personally, that's kind of how I've dealt with things over the years. But as Solomon said, everyone's different, and we've all probably had experiences where we've had to draw on some of our tools on how to deal with those things. But the more tools we have, the better it is, and the less likely these things will happen, hopefully, with time and education.
Definitely, although Lale, we didn't have you on this question, I'm keen to hear your thoughts if you're willing to. But just before we go there, I keep making plugs for other things, but there's so much good literature, so much good stuff out there right now, and I have to do a plug for the people that are doing good work out there. Fackle BC released a brilliant film. If you haven't seen it yet, get on the internet. It's the internet's everywhere. It's in your hand. It's in your computers, on your watch. Get on it and watch it. It's called "But I Look Like a Lawyer." It came out on November 25th, and you can see it online. But Lale, I'm keen to hear in the wealth of experience you have, if some of the thoughts on these kind of addressing these subtle acts of aggression or microaggressions.
Yeah, thanks, Aaron. I mean, I love what I've heard so far. And again, I want to echo everything that's been said. One of the things that we have done, and we actually did this recently, just as part of that awareness raising that Layla was talking about, we did a session on bystander intervention. Okay. And we saw that as a way of actually equipping all of our people to be able to address this situation, so that it's not just on the person who's perhaps on the receiving end of a microaggression. And it was, again, I think, I can't remember, somebody said this, but really, I mean, inclusion, the culture is about people, and inclusion is a choice that everybody makes, that each of us makes. And so again, for us, allowing people, we've done a lot of awareness training. So people are sort of familiar with what microaggressions are, people are familiar with the challenges. And I think we've created that greater empathy in our workplace. But I think this particular session on bystander intervention really gave people an opportunity to turn that empathy into action. So it's like, okay, I'm aware, I understand, what do I do? And so we were able to provide very practical tools to people.
Brilliant. No, I think that's great, and those are very practical. I mean, I wrote that down right away. Bystander intervention. I thought we got to get that at Edinburgh Burles. I want to see something on that. I think I'm taking more notes than I'm probably paying attention right now. But that's brilliant. And so just to folks who've been putting in lots of questions, love it. So many questions coming in. I'm great to see such an engaged participant pool. Keep them coming. What we're going to do is we're going to have a couple of more questions now to the panelists. Then towards the last 10 minutes, we'll do a little bit of Q&A. But I want to just talk about this. We've been talking about ways in which to address issues regarding diversity, exclusion, inclusion. Maybe Solomon poses the question to you, what are some ways in which we can bring the folks along in our respective organizations who might feel kind of threatened by these changes or these programming, or even by attending something like a bystander intervention, a panel for a lunch hour?
Yeah, well, I think for starters, I think it's important never to underestimate folks' capacity to be fundamentally decent to each other. I think people rise to your aspirations of them. And that's that might sound a little bit naive, but it has been my fairly consistent experience that if you come into stuff with empathy and an open heart, people will consistently surprise you. I also think it's really important that no one thinks of themselves as like kind of like perfectly shining orb of anti-oppressive light that is casting across the universe and is in a perfect space of purity. Like I think all of us are on journeys, and all of us have complex lived experiences, and all of us have a dog in this fight. Ultimately, I will say that what I think has been very effective inside McCarthy's has been the messaging about how our D&I work, it's a rising tide. It lifts all boats. It's not specifically about, it's not specifically just about, targeting underrepresented communities delinked from everything else that we're doing. It's about creating a workspace where everyone can bring their full self to work, can do the best and highest quality possible work that they can in that context, and can kind of grow together in a work environment which is invested in them fundamentally. And I struggle to think of anyone who is not well placed by being in a workplace that is a bit more gentle and compassionate.
I love that, Solomon. I just, and I think to help people understand that it's not a zero-sum game, that there aren't winners and losers, that we really all win when we are paying attention to inclusion and belonging, respect, and all those things.
Nice. So, but before I pose, I have like a final question that the panelists know about kind of what are the key takeaways they think that some organizations can use to increase diversity. But before I do that, I'd like to insert the Q&A here actually, so that we can end with those thoughts. So so many great questions. Friends and people that I know on here asking questions, great to see them. One question I think, which is important because and this might be a controversial question, but I'm going to ask it anyways, which is that the role of regulators, right? And also this bleeds into two things that were several questions were related to: data and the role of regulators. Should law firms be left to their own devices as a laissez-faire system, or should we have some degree of required EDI content training, implementation of programs from the regulator's perspective? I'll ask each of you, whoever wants to go first. Maybe Leila, you're nodding your head in terms of what's the role of the regulator? Should it be more significant in what law firms do? Obviously, this is very much highlighted given the kind of things that have been happening at the legal regulators in Ontario.
Yeah, I mean, I was nodding my head because I sit on the advisory committee to the Ontario Securities Commission. So obviously we've talked about diversity at length, especially in connection with the Capital Markets Modernization Task Force and their recommendations on diversity. They had recommendations for women and for those who identify as BIPOC to have certain percentages of those groups in executive officer and director positions of Canadian public companies. And I think the recommendation was because the progress has been so slow with the comply or explain model that now exists for women, where there's no actual like target or quota, but it's like, talk about how many women you have. And if you don't have any, tell us why. Like that hasn't resulted in a lot of changes. And so I know the OSC and the Canadian Securities Administrators are very strongly looking at this recommendation from the task force about whether or not targets should be instituted for public companies for these particular types of groups. So we've had a lot of healthy discussions at SAC on it. I do think there can be some benefits with respect to having targets. I think quotas is a bit of a different conversation, and sometimes there are negative effects with respect to quotas. But in terms of the Law Society, I think, now we have an EDI credit that we have to do. And I know they rolled that out over the last couple of years. So I think that's meaningful because that kind of encourages programming and gathering information and building awareness on these types of issues. So I think, they've done that. I think within the law firms, one of the things Macmillan could have done better in the past with hindsight that we've kind of realized over the last couple of years is our tracking. So I think Lala kind of alluded to this too, but, now we are much more careful in how we track progress of certain underrepresented groups. And we started kind of with women and we're working from there, but, looking at numbers, looking at growth, comparing things from year to year, seeing what impact different things that we're doing in the organization actually have, so that it isn't just building information and awareness, but it's actually going into results. And, we're seeing more people get into leadership positions, more people go into equity partnership if that's kind of the path they're on and what they want to do. And so, I think that there is a role for that kind of thing in terms of setting, and whether it's an aspirational target or a hard target. But I think that, law firms should look at it. I think the Law Society should collect that data with respect to the different law firms as well. Like, as Lala said, it's hard sometimes to get information out of organizations. And so, I think we have to do a better job of kind of sharing to make sure that we have that information accessible and we can actually track progress.
Brilliant. Did anybody, Solomon or Lale, did you have any thoughts on that?
Sure, very, very quickly, and at the risk of just trundling into a hot button topic in the world.
Do it, Solomon, do it. We're given this platform, you have to.
We're a client-facing profession who is practicing in one of the most diverse cities in North America inside an incredibly diverse province. It's just basic that one of our core competencies is to be able to provide non-discriminatory service to our clients. I don't think that that's negotiable, and I think it's a absolute no-brainer that our regulatory organizations should, regulatory body should be a role in making sure that we have those core competencies when we go to market. As Leila mentioned, there's some great work and some great folks at the LSO who are pushing very, very hard to make sure that folks are getting the training and access to the resources they need to be able to have those skills to practice as lawyers. I don't think it's particularly controversial to say that that's not universally true at the LSO. And I think we all have a role, especially when it comes to the next election, to think about who's representing lawyers in this province. But that's as far as I'll go.
No, I think that's very far and very important. Sorry, I don't think it's very far. I think it's very important, though. I was having a discussion yesterday with a criminal lawyer regarding some current case law in another panel I was speaking on about wildly how there was certain case law that was evidently racist. Like the contact was evidently racial. The Black person was not being given a drink at a bar. An Asian person was being prohibited from hiring a white woman in the prairies. But the decision making was done to exclude race, to make it seem like it was a matter of contract or employment. Professor Land gave those examples earlier at the Ryerson conference. I have to give him credit for these cases. But what was interesting was recently, though, the Ontario Court of Appeal made it very clear that racism is evident, and that lawyers bringing cases forward and arguments have to address racial issues because they're self-evident. They exist. And I think the same thing can be said. We wouldn't be having this panel if some of these issues didn't exist, right? And we're not talking about air, we're talking about reality, lived experiences, unfortunately, future experiences that people will continue to have. Okay, very cognizant of time because we're going to do a wrap up afterwards. I had so many questions. I'm so sorry to all the participants. We didn't get to all your questions, but the discussion will continue. So fire round, 30 seconds to 45 seconds. Last thoughts, important takeaways. We're going to start with Lale, then Leila, then Solomon, and then I'll wrap up afterwards. So Lale, any final thoughts you have for the group?
So final thought, I think initially when we had talked about our takeaway was supposed to be what can organizations do to improve the diversity in their organizations? And my response to that is to increase diversity, you need to focus on inclusion. And, if diversity in the workplace is about representation, inclusion is more about respecting and valuing those differences. And, an inclusive environment is one where people can be themselves. We've already, Solomon, you've talked about this, where if they feel they belong, where their voices are heard, and where they have access to opportunities. I think both Leila and Solomon have talked about all of these, and and diversity. But I think, in a city like Toronto, diversity is a fact. I mean, there's no reason why our organizations should not be representative of the broader diversity in society. But the problem is that diversity alone doesn't drive the inclusion, and you have to be very deliberate about the inclusion. And so that's what I think organizations need to focus on. And when you are deliberate about it, that actually diversity becomes an outcome of the inclusion.
Fantastic. I think this is a great takeaway. Yeah, Leila, over to you.
I think diversity is not only good for business, it's just the right thing to do. So I think, we all have to accept that and move forward. And I think It's all about organizations talking to their people, collecting feedback, and checking their culture on a regular basis. What is actually happening within their closed doors? What are their people about? What are their experiences? Gather that feedback through surveys, informal surveys, formal surveys, anonymous surveys, any which way you can do it, and try and track what is changing in your organization. And if things aren't changing in the way that they should change to promote growth and other things, then go back to the drawing board and think of the types of tools and resources you're making available to your people, and think of how you can supplement them or complement them, and kind of learn from your peers in the industry. Talk to people, don't be shy to put your hand up and to have these conversations, even though sometimes they can be difficult, challenging, or awkward. Like, they're necessary to have.
Brilliant. No, I think that's very, very true. Solomon, over to you for the last few thoughts, and then I'll do a quick wrap up.
And I guess the last thing I would say is just to, any students or community members who are thinking about practicing law or thinking about Bay Street down the line. I know it can always be complex when you're spending a lot of time talking about diversity and inclusion, because we are talking about so much that is going wrong and so many of the bad experiences that folks have had. But I hope that one of the takeaways that you have from today as well is that it's a pretty dynamic time as well. There is a buy-in, there is a realization that that while there's a ton of work to be done, that there's a bunch of good work that is being done. And that if this is where you envision yourself, you can be part of something that's quite exciting, and will result in the profession really looking and acting and behaving in the best way that it could, in its best self. So
I love that, Solomon. Brilliant. I'm a perpetual optimist, so I completely agree that this time that we're living in is super exciting. Like, for Leila will know, and the markets are hot, so we're constantly looking for talent. But you, the talent, the lawyers, the participants listening to this, you bring such incredible diverse views, and you need to have that diversity respected. And it's not that you need to demand it, but you need to make that aware. And this is a perfect opportunity to do so. Firms need you. Organizations need you, and we need you because of your diversity. So just in a wrap up, I don't know how I can wrap up everything because we had so much incredible stuff we talked about today. But I'm going to go back to the first point that I made, which is the first three things that Solomon, Lale, and Leila talked about, which is really that when you're a law firm or an organization looking at this, there are three critical components you have to take into consideration, with lots and lots of details between there. And some of those details were, the bystander intervention, programming. But the critical point is looking at pipeline and retention. Bring the diversity in, keep the diversity there. Then understanding that once you've brought them into your organization or firm, there are biases, there are issues that exist. Mitigate exclusionary issues and biases, and increase inclusive activity. Lauren said in the commentary, when you don't intentionally include, you unintentionally exclude, which is exactly true. And finally, when you've done that, maintain an environment that's open and willing to allow people to raise their voices, bring their diverse thoughts forward, and have them addressed with your colleagues. And those three things are not easy. They're not meant to be. It's meant to be, this profession is long-standing, and it's not going to change tomorrow. But it's our goals to continue to mitigate these areas, bring in the diversity, respect and increase it in our firms, and make it so that it can flourish. That's brilliant. Thank you so much, everybody, for joining us. Lale, Leila, Solomon, thank you so much for your brilliant views. Just in conclusion, I want to note that the next panel that's going to be beginning is Balancing the Bench, a conversation about advocacy on EDI and racial justice. The moderator is the incredible Honorable George Strathy, Chief Justice of Ontario. Thank you, everyone. Have a wonderful Saturday and weekend.
Thank you.
Thank you.
Thanks.
A link lawyer amplifies the voices of the unheard. That's something that's, I think, really close to my heart, and it's been something that's been a part of both of my academic endeavors and also in my personal life. My mom, she's an immigrant here, and English is not her first language. Seeing her struggles and seeing how she couldn't really get the legal advice that she needed when she needed it, and how that delayed her getting justice or getting justice at all, it's troublesome. It's amazing to be, part of a community that's going to be ever growing. We're only going up from here, I think, and striving for meaningful change as a collective and through our individual paths.
Welcome back. I hope that you all enjoyed the breakout sessions. Now we have a fantastic judicial panel that's going to be moderated by our Chief Justice, George R. Strathi, by way of an incredibly brief introduction because his bio is incredibly long. He is a super accomplished person. Our Chief Justice currently serves as the Chief Justice of Ontario and President of the Court of Appeal. The Court of Appeal hears some 1,000 appeals and over 1,000 motions each year. Before his current appointment, Chief Justice Strathi served as a judge of the Superior Court of Justice in the Toronto region from 2007 to 2013, where he presided over civil, class action, and criminal matters. The Chief is an exceptional leader. This conference was his idea. He is remarkably generous with his time and has used his office to build capacity amongst lawyers from equity-seeking groups. Despite the stigma associated with the disability of mental health, in his keynote address, the Chief shared his personal experience with the stigma of mental health in his family. And he has set the tone for a court that recognizes that the promise of equity and justice in Canada cannot be achieved without justice, fair treatment, and prosperity for all peoples. If you haven't read it yet, I strongly recommend that you read the Chief's speech for the opening of the courts of Ontario for 2020. Enough from me. Over to you, Chief.
Thank you. Thank you, Sean, and good afternoon, everyone. This overall program is called Legal Voices, Diverse Ideas, and Inclusive Futures. The panel that I have the privilege to chair this afternoon is made up of judges who will be the legal voices you'll be hearing this afternoon. As you will find, they have diverse ideas and they have had extraordinary pasts and no doubt are looking forward to an equally extraordinary future. The title of our particular program is Balancing the Bench, and we are going to interpret that and respond to that challenge in different ways, as you'll hear from the individual speakers. Like Sean, my introduction is going to be brief. The speakers' bios are in your materials. I would encourage you to read them. They really are, from my point of view, a dream team of jurists bringing very interesting and different backgrounds, a great deal of experience, and as you will soon find out, some extraordinary wisdom to their roles. Without going in any particular order, I'll welcome them. My former colleague on the Court of Appeal, Justice Harry Laforme. My present colleague, Justice Michael Tulloch. A long-standing colleague on the Superior Court, Justice Todd Ducharme. Another member of the Superior Court, more recently appointed, Sean Nakatsuru. And the most recent appointment, Laurie Ann Thomas, a judge of the Ontario Court of Justice. The ground rules for this panel are simple. I'm going to ask each of the panelists a different question in order. They will have 5 minutes to respond. And after we've gone through all those initial questions, I'll ask them each a follow-up question, and they'll have 3 minutes to respond. At the end of that, there will be time, I believe, for questions from the audience, and you're more than welcome to submit your questions. I have to play, unfortunately, a little bit of a role of policeman or perhaps hockey timekeeper, and it's Court of Appeal rules, and we do have time limits. I'll apologize in advance to the panelists and to the audience if I have to intervene, but it's for the benefit of all. So let me start then with Justice Nakatsuru. The entire subject, it could be an entire subject to talk about the importance of increasing diversity on the bench, or as balancing the bench, as our title is. Why is it important to have more diversity on the bench, to balance the bench?
Thank you, Chief Justice. So first of all, let me say it's a real pleasure to be invited to speak on this panel with such esteemed colleagues as we have here. what a diverse bunch of judges, right? So I'm not going to say anything that's likely going to be new to you, but let me give you two reasons why diversity is important to be on the bench. So first, diversity will bring differing perspectives to the bench. The act of judging itself requires common sense assessment of evidence and the exercise of judgment when applying the law. So where does that common sense come from? Well, at its core, common sense and judgment comes from our own lived experience. So if that lived experience is a monochromatic, uniform, same from judge to judge, then that creates room for misunderstanding, mistakes to be made when you're assessing the evidence, and the law becomes predictable and rigid. Certainty in law is good, stagnification is not. So a little bit of disclosure about my background. I grew up on a farm in southern Alberta. My father was a Japanese Canadian who suffered discrimination and dislocation in the war. My mother was a first generation immigrant from Japan. So, what Ms. Sidhu just said on her video just before our panel started really does strike a chord in me, because when I was growing up, I can certainly tell you, I never would have thought I'd be on this panel with all these esteemed colleagues. So having judges of a diverse background does improve the very act of judging. Secondly, it's good for the community. The justice system really is a service industry, and it shows the community, when we have a diverse bench, that the justice system is inclusive. It shows the community that the justice system is fair because it reflects the people who appear before it. And it shows the community that the justice system doesn't simply tolerate difference, it celebrates it. So in that way as well, diversity on the bench is extremely important. So balancing the bench. Balance conjures up in my mind images of equilibrium and harmony. How do we achieve that balance? Well, I'm not a big proponent of quotas or proportional representation. I think that's unnecessary and unwise, even if it could be practically achieved. But if the process of evaluating and selecting judges becomes one that takes identity and background seriously, then I think we can achieve that balance. So let me end by saying this. I'm a huge optimist. I think great strides have been made in getting to that balance. More work needs to be done, of course. But if we actually reach a point, hopefully soon, where we achieve that balance on the bench, then, while of course, we must always remain vigilant about ensuring we don't lose that balance, I do think and hope that we will be able to reach, at least substantially, that state of harmony. Thank you, Chief Justice.
Thanks very much, Sean, for sharing that wisdom and also your personal experience with us. That is very helpful and very interesting. So let me move to our most recent judicial appointee, Justice Lori-Ann Thomas. And to use the expression that Justice Nakatsuru used, perhaps you could tell us how your life experience, your cultural background affects the way in which you've been approaching your judicial role.
Thank you very much, Chief Justice Strathian. And like Justice Nakasuru, I have to say, I wouldn't have seen myself here, and I'm so honored to be here. So thank you for everyone and for inviting me. I preside in the Ontario Court of Justice in downtown Toronto. We, at the Ontario Court of Justice, we are usually the first, and we are usually the last step for anyone entering the criminal justice system. So the people that come before our court, especially in downtown Toronto, experience homelessness, addiction issues, mental health concerns, abuse, and systemic racism. And so it would seem that we have nothing in common with they would have nothing in common with the judiciary, which is seen as the height of privilege in the justice system. However, their experiences are not so foreign to my own. I am biracial. My mother's Polish and white. My father is Black and Caribbean. My peers were biracial, Black, or they assimilated to the Black Canadian or Caribbean culture. I myself left home when I was 17 and was temporarily on social assistance. And I worked for many years before resuming my education to become a criminal defense lawyer. So you can see that it's important to outline who I am to understand how my background affects how I perform my judicial duties. And I have some familiarity with those who I serve in the public. But it may feel counterintuitive to have a judge's background inform their ability to judge matters impartially. But this is not a new concept. And so in addition to the cases that Justice Jamal mentioned earlier today, there's the 1997 case from the Supreme Court of Canada, Regina versus RDS, which confirmed that judges will be informed by their experiences when making decisions, provided that's based on evidence and not stereotypes. And in outlining the fallacy of judicial neutrality, and yet the importance of impartiality, the Supreme Court quoted a book from 1921, so 100 years ago, where it recognized that judges are no different than other mortals. It stated that all their lives, that forces which they cannot recognize and cannot name have been tugging at them. Inherent instincts, traditional beliefs, acquired convictions. And it's in this mental background that every problem finds its setting. So while we try to see things as objectively as we please, nonetheless, we can never see them with any eyes except our own. And so the Supreme Court recognized that the judges cannot be divorced from their life experience when judging. And if some such transformation were to occur, it would deny the society the benefit of those experiences outlined by Justice Jamal and just now Justice Nakasuru. So how does this affect my life experience? How does it affect me judging? Well, I have the ability to appreciate and strive to understand the public I serve, the judicial empathy that was referenced earlier today. I have a freedom to make those sensitive but essential inquiries about issues affecting those that come before me on topics such as race and mental health, housing, addiction, and et cetera. What that could mean is something like asking for a cultural assessment report for Black offenders, like noted in Morris and Anderson from the Nova Scotia Court of Appeal, but also asking the background of the accused, which is very important in these days of Zoom or telephone where I can't see them, just to find out if they are part of a population that's overrepresented in incarceration. And even asking someone if they were ever a subject of the child welfare system. These answers permit me to execute my duties and render a fair decision. Even just something like understanding terminology that participants may use that is not part of the Queen's language helps me understand how I can relate the information of the court to them, speaking in plain words to make sure they understand what's occurring. And some of this was informed by my culture, or my socioeconomic background, or domestic situation, or just simply being a defense lawyer. But we heard Justice Jamal speak about the importance of diversity of experience in a collegial judge setting, such as in the Court of Appeal or the Supreme Court of Canada. But at the trial level, we really benefit from the diversity of our colleagues, not only through their decisions, but also through our out-of-court discussions about their lived experiences. So while I will give you an example with permission, one of my—
Can I just step in for a second and say, we may have to leave some of that for your follow-up question, because
not a problem at all.
So I'll come back to you. I'm sorry about that.
No worries.
Thank you. So we move from one of Ontario's newest judges to one of Ontario's most senior judges, now looking back on a distinguished past from the perspective of retirement. And can I ask you, I still call you Justice Laforme, Justice Laforme, can I ask you, from your new perspective, do you have any insights about the way judges can and should approach the issues we've been talking about? We're not hearing you.
I hope that doesn't go against my time. Okay.
No.
Thank you, Chief Justice, and thanks everyone for allowing me to participate in this. I'm delighted to be here once again for Ryerson. The one thing I would say is that Justice Thomas probably that may be her first appreciation of how you defer to the Chief Justice. But in any case, the first thing I want to say before I even get into the question is simply this: to all the students, the law students that are listening in or participating in this, the young lawyers that are participating in this, the academics in law that are participating in this, think about the judiciary as part of your objectives, as part of your aspirations of what you do, because it is a tremendous calling. It's worth every effort. It'll by then certainly be open to you more than it is now. And your voice is necessary. So really, as soon as you can, consider that as an option. Now to the question. First, any lawyers and academics that are appointed to the bench at this time who are Indigenous or members of a racialized group in our society, and especially those that are of a visible race, you'll likely be among the first in your community to achieve the level of public service. Expect that you'll be viewed and scrutinized differently and perhaps even more harshly than your colleagues will be. Also, it may be your community itself that criticizes you the most or scrutinizes you even more harsh than others. I remember starting out and my people in my community didn't think I was a real lawyer. They thought it was all because of, the system making an allowance and I was a token person. Go with it, and then what you do is that gives you an opportunity to teach as a young lawyer or as a young member of the judiciary, and take that as an opportunity to teach. Think about it whenever you write your decisions or make your decisions, that you do so in a very learned and respectful way, and take it as an opportunity that you can teach through that judgment. The second thing, when you're asked to serve, as has been alluded to, and as I've said many, many times, don't forget who you are. I'll use Justice Nakatsuro as an example. Be an Asian who is a judge and not a judge who is Asian. And by that, I mean, don't forget where you came from. Let that in your life's experiences, as has been said over and over again, and it's most critical, let that define who you are and your decision-making. Let it inform it. Third, you'll likely find it lonely, because as I indicated, you're probably going to be the first and among the first of your group to get there. The community will be curious about what it is you do, and at times they may be critical. Once again, take this as a chance, as I say, to educate, but about many things, especially about the system of justice. that they, the community that you represent, lives in, how the justice system impacts them, and how they can respond to it. Again, it's an opportunity to educate. Fourth, it will be very important to appreciate that you will not simply be the face of the bench of Indigenous people or Black people or whichever race your face represents. Rather, you'll find you'll be the face of most of those groups who will recently have been excluded from participating in these critically important decision-making roles. Visit with them, like bar associations, meetings, law societies. Get involved in what their concerns are and what they are talking about. But be careful, and this is important. This will be new, since the inclusion of you on the bench will likely be viewed as long overdue. Expected demands on you and your time will be enormous, and at the same time, you'll find it's well worth doing and your time. Thank you, Chief Justice.
Thanks very much, Justice Laforme. I'll now turn to Justice Todd Ducharme. Justice Ducharme, you've been a judge for 17 years now. The famous Gladue case was decided 22 years ago. And that decision was meant to address and to assist sentencing judges in addressing the issue of over-incarceration of Indigenous people in the jails and penitentiaries across the country. But since that time, as we know, rates of Indigenous incarceration have been increasing. Why haven't the results been better in that regard? And what can be done about it? How would we address it in the right way?
Thank you, Chief Justice, and I want to thank the organizers of the conference for inviting me to this panel. Before discussing how Gladue's failed, I think it's important to discuss what's very important about the case. In it, the Supreme Court was interpreting Section 718.2 sub E of the Criminal Code, which directs judges to consider all available sanctions other than imprisonment that are reasonable in the circumstances, with particular attention to the circumstances of Aboriginal offenders. Now, on the basis of that rather slender read, they said three very important things. They reiterated what they had said earlier in Williams, that there is widespread bias against Aboriginal people in Canada. There is evidence this widespread racism has translated into systemic discrimination in the criminal justice system. They talked about the problem of the drastic overrepresentation of Aboriginal peoples within the Canadian prison population and the criminal justice system. They said it had a peculiarly devastating impact upon Canada's Aboriginal peoples. And they emphasized the limits of incarceration, saying Aboriginal offenders are more adversely affected by incarceration, less likely to be rehabilitated thereby because internment is culturally inappropriate, and that discrimination towards them is so often rampant in penal institutions. Now, all three of these are incredibly important points that are still being argued about today, but the important point is that the Supreme Court more than 22 years ago expressed these views so powerfully and so clearly. Now, these facts are still not generally understood by Canadians. I would say the majority of Canadian judges and lawyers do not pay sufficient attention to them. But if you're a critic of our criminal justice system, then Gladue really is your starting point. Now, in Gladue, the court set out three broad goals for the courts. One, they were to pay particular attention to the circumstances of Aboriginal offenders, and that was to consider the unique systemic or background factors which have played a part in bringing the offender before the court. Two, the courts were to reduce the over-incarceration of Aboriginal people. We were directed to explore reasonable alternatives to incarceration in the case of all Aboriginal offenders. And three, we're to try to develop a more culturally appropriate approach to sentencing. The court referred to the understanding of sentencing held by these offenders in their communities and observed that most traditional Aboriginal conceptions of sentencing place a primary emphasis upon the ideals of restorative justice. Now, how have we done? Well, in terms of considering the unique circumstances of Indigenous people, on a micro level, no doubt, this has made a difference in the lives of some Indigenous offenders, victims in their communities. But there are significant practical limitations here. In many busy courts, time is a luxury, and consider the time a judge will have when dealing with sentencing. 2, defense lawyers in the Crown may not be raising Gladue in the proper way. Too often, as was done in the case of Gladue, they might simply say, oh yes, and she's Cree, and would ask you to take that and Gladue into consideration. There's the issue of whether or not a Gladue report is available. Thanks to Aboriginal Legal Services of Toronto, the situation is much better in Ontario than elsewhere in Canada, but funding is inadequate at both the provincial and federal levels. And defense lawyers have to try and fill this void, and if they don't, judges have to be more demanding about getting the information required or be prepared to take judicial notice of relevant facts. Now, in terms of reducing the over-incarceration of Aboriginal persons, we've failed abysmally. The rate for Indigenous males is 8 times that of non-Indigenous males and 12.5 times for Indigenous females than non-Indigenous females. Now, there's many reasons for this. Judges have not paid enough attention to Gladue or have failed to understand its forceful call for change. There's not enough time and resources to properly conduct a Gladue sentencing. There's been an improper focus on the circumstances of an Indigenous person and demanding some tight nexus between their background and their involvement in the crime. And this is very significant, an overuse of the limit in Gladue that in cases of particularly violent and serious offenses, the imprisonment of Indigenous people will be close to or the same as non-Indigenous offenders. And similarly, there's an overuse of the observation in Gladue that the section of the Criminal Code does not require an automatic reduction of sentence. Thank you, Chief.
Thank you very much, Justice Ducharme. And that takes me to our final panelist for his opening remarks, Justice Michael Tulloch. Justice Tulloch, as you know, of course, the audience may not know, but the National Judicial Institute is responsible for the education of both federally and provincially appointed judges. And the Judicial Institute speaks frequently about the need for judges to obtain or acquire cultural competence and also to become familiar with the social context of cases. Would you tell our audience a little bit about what those terms, cultural competence and social context, mean to you and why they're important for judges?
Okay, great. Thank you, Chief Justice Straffi. And I too want to thank the organizers for this very excellent conference. And it's certainly an honor to be on this panel with my esteemed colleagues, including my former colleague and neighbor, Justice Laforme. Now, as human beings, we're all influenced by our experiences, backgrounds, social interactions, and the contextual environment in which we live and operate. All of these factors impact the way we think, views we hold, as well as the perspectives that we may hold of others. Our personal experiences and circumstances in most cases inform our views and sometimes value systems. The law and the legal framework within which we as Canadians operate depends on lawyers and judges who understand the social and cultural dynamics of the society in which we live. So as lawyers and judges, we all operate within a social context where systemic discrimination and inequality negatively affect many people and communities. Public confidence in the administration of justice requires everyone who operates within the system to be seen as operating fairly and in the public's interest. And I think this point was reiterated this morning by Justice Jamal in his speech. Now, cultural competence is the learned skill that bridges the tension between a lawyer's duty and professional obligation to protect the public's interest and access to justice, while at the same time recognizing that Ontario is a pluralistic and culturally diverse society, and that at times different values and perspectives will collide. Now, according to the Law Society of Ontario's definition, cultural competency is the capacity to communicate and interact effectively, respectfully, and comfortably with people of differing cultures. Cultural competence is required to communicate effectively across many social differences and enables the lawyer to communicate effectively and accurately with a client to establish and maintain the foundation of trust and respect on which their fiduciary relationship depends. Now, each person's experiences of the person's culture shape the person's values, ways of organizing and understanding information, and norms of social behavior. Now, for a lawyer, this is significant because it shapes how the lawyer assesses credibility, organizes facts, and makes judgments about what a client or witness may say or do or see. Now, judges have a similar obligation. According to the guidelines for Judicial Advisory Committee candidates for federal judicial appointment, judges must demonstrate, in addition to their professional competence and experience, a number of personal attributes, including knowledge of social issues, an awareness of changes in social values, humility, fairness, empathy, tolerance, consideration, as well as respect for others. Lawyers and judges have a professional obligation and responsibility to ensure that they're culturally competent. And this means that we must educate ourselves so that we are attuned to the social and cultural dynamics of a change in society and values that we may not necessarily be familiar with or that were not a part of our foundational education. Failing to do so will impact the public's confidence in the administration of justice. Now, a clear example of this occurred a few years ago in Alberta. And I want to give the audience a content warning, as this example highlights some very disturbing commentary during a sexual assault trial. Now, in 2014, Justice Robin Camp was a provincial court judge presiding over a sexual assault criminal trial. During the course of the testimony of an alleged sexual assault victim, Justice Camp asked her why she couldn't just keep her knees together or sink her bottom into the bathroom sink to avoid being sexually assaulted. Throughout the trial, he also referred to the complainant as the accused. He criticized her for not screaming while the alleged sexual assault took place and suggested she wanted to have sex. He also asked her why she didn't skew her pelvis to avoid penetration. Last but certainly not least, he said to the complainant that sex and pain sometimes go together and that that's not necessarily a bad thing. Now, the judge later acquitted the accused, and in acquitting him, he told the accused the following: I want you to tell your friends, your male friends, that they have to be far more gentle with women. They have to be far more patient. And they have to be very careful to protect themselves. They have to be very careful. Now, the decision was appealed and was overturned by the Alberta Court of Appeal, which ordered a new trial. Now, in their decision, the court pointed out that the judge's reasons gave rise to doubts about the trial judge's understanding of the law governing sexual assaults, and in particular, the meaning of consent and restrictions on evidence of the complainant's sexual activity, and that the judge may have used sexual stereotypes and stereotypical myths which have long since been discredited. Now, sometime after this decision, Justice Camp was elevated, strangely enough, to the Federal Court of Canada. Sometime after his appointment to the federal court, 4 law professors filed a complaint with the Canadian Judicial Council, and the complaint resulted in a hearing and an ultimate decision to remove Justice Camp. Now, in their decision, and I point you to paragraph 24 of the Canadian Judicial Council decision, they stated the judge's misconduct was manifestly serious and it reflected a sustained pattern of beliefs of a particularly deplorable kind, regardless of whether he was conscious or not of it. One of the consequences of the judge's misconduct in the trial is that it adds to the public's perception that the justice system is fueled by systemic bias, and it therefore courts the risk that in other sexual assault cases, unpopular decisions will be unfairly viewed as animated by that bias rather than by the application of legal principles and sound reasoning and analysis. Now,
Justice Tulloch, I'm sorry to remind you about the time. You're over your 5 minutes and now well into your additional submission. So I'll say give you another minute to wind up, but it's going to cut down on your final time.
Right. Okay. My final point is this. This is but one example of the results of cultural incompetence and the potential effects that it has on the public's perception of the justice system. And from that vantage point where we sit today, I'm sure a lot of us are appalled at the comments of Justice Camp in that trial. But unfortunately, his comments reflect a similar narrow perspective held by some judges and lawyers of that era. And, you know, basically, to end this, I would say that cultural competence is critically important for all of us as judges. And you're not going to be culturally competent unless you are in tune with the social changes of the society in which we live. And this is underpinned by having an appreciation for social context. And I can point to two cases recently from our court, Regina versus Morris, which is a case in which we heavily relied on social context evidence to come to our final decision. Another case last week that came out was the case of Restool. It's a case involving with Indigenous treaty land claims. And that's a case where the court relied on evidence, social context evidence of the Anishinaabe culture and understanding of governance and contractual relationships. So these are critically important for us to not only understand, but utilize and implement within our decision-making process in order for us to be better judges and in order for us to have a fair and just judicial system that reflects the public's confidence in the administration of justice.
Thank you very much. So let me go back then to ask a few follow-up questions. And I'll start again with Justice Nakatsuru. You spoke about the importance of diversity on the bench. What do you think about the importance of diversity in the bar? And what is accomplished? What is the inherent value of diversity in the bar from your perspective?
Well, thank you, Chief Justice. The similar reasons about importance about the importance of diversity in the bar is very similar to what I said in response to the first question. But let me point to something specific. Having a diverse bar is important because that's the pool that we select our judges from. So the deeper the pool, the greater the opportunity to have diverse judges on the bench. So let me just echo what Justice Laforme said. I really do encourage all of you who are listening at some point to make an application to the bench, because you know it's very, very hard to get appointed because there's so few judges, and I think every one of us feels very privileged when we do get appointed. But you know, if you have such a really diverse, deep pool of diverse candidates, it makes the choices of those who appoint judges both easier and harder. It's easier to appoint a diverse judge if you have a large number of candidates to choose from. And it makes their job harder because when they don't choose a qualified and competent, diverse candidate, then they need to be pushed to explain why that is the case. And it's far too easy to say, well, not enough people put their names forward. So don't make it so easy for them to avoid that hard question sometimes. So that's why I think diversity in the bar is really important when it comes to sort of the selection of judges.
Thanks very much. So back to Justice Thomas. Justice Thomas, I cut you a little bit off in mid-stride earlier. If there's anything you wanted to add on the issue of cultural background and how your cultural background affects your judging, but also wanted to ask you about the issue of cultural context evidence and how one goes about introducing evidence of cultural background or cultural context.
Okay, well, I'm going to start my timer first. I'm going to just focus on the more follow-up question, and I just want to say it's really essential that counsel familiarize themselves with the client's cultural or familiar or what have you background. It will likely start with more than one in-depth interview with their client, and likely the counsel will have to consult other family members or friends. But it also may mean speaking, as you heard Justice Tulloch talk about, is informing yourself. It may mean speaking to culturally relevant community supports, workers, or organizations. This is where the efforts by Councillor Morris really came in handy to really give some latitude in terms of bringing up this evidence to explain a person's background and to allow the court to make to understand the fulsome picture of the person before them. So it's really about doing your homework, and that will help you determine how to present that information to the court, whether it be through letters, affidavits, or viva voce evidence. Still got 2 more minutes. So I just also want to be clear. You don't want to be paternalistic. This isn't a situation where you're trying to save somebody. It's really about providing the court real information about the person that's before them. And so this isn't about you saying, I'm coming as the white knight to save this poor person who had a difficult background. It's about allowing the court to know who they're dealing with. So whether you share their cultural background or not, and particularly if you do share the same cultural background, you want to be careful about making evidentiary shortcuts without a direction from the judge. As I said earlier, the Supreme Court noted in RDS that evidence is the evidence is the basis for any decision. So don't just say, as you heard Justice Deschamps say, this person is Cree, so you have to decide these issues. Give a little bit more background. You may not be able to get a fulsome GLADU report, but you could provide some input into how their connection or their disconnection from their community has affected them. And that will help the court understand who they're dealing with.
Thanks very much. So back to Justice Laforme. You, Justice Laforme, and several others have spoken about the need to encourage members of diverse racialized communities to consider a career in the bench. And my question is, how do you respond to people who suggest that the judicial appointment process shouldn't consider someone's identity or background, but should only focus on competence, and say that we should be basing appointments purely on competence and ignoring the person's background or identity? What is your response to that kind of comment?
Competence is sort of the new term that's used to replace merit. And I remember in my day, that was the big thing that was always criticized when, and we're talking a long time ago now, when the whole issue of an Indigenous appointment to the bench and was an issue. And now we're talking about it in terms of competence. And part of the problem with that is, regardless of the pool, the size of the pool, Sean, is it's a question of getting through that screening process and the applications that are there. And those, in my view, are mostly subjective questions. And when you talk about lived experience, the people that are assessing those applications and the people for that and talking about what amounts to competence is their life experience, their lived experience informs them about what that means, competence. And I think, quite frankly, the application itself is way too onerous for issues such as diversity, because I don't think that any person sitting down and assessing those applications, or even 2 or 3 people, are going to appreciate what kind of practice these people come from and what they do in their practices and what it is. I mean, I would ask pretty much anybody here on this panel if they know which lawyer is competent in the area of representing First Nations in issues of Indigenous law. And to be able to assess whether or not that person is competent, you just simply can't know the answer. You must know the answer to that question to be able to decide it. I think that whole issue has evolved, but it hasn't evolved for the better. I do think that it's still objective. It's based upon urban-centric lawyering. It's based upon urban-centric practices, and the applications themselves are made with that in mind. My experience was and is that questions like competence and merit are code words that have been used in applications and by others, the public, quite often, and bar associations, to exclude people, not to be inclusive. It seems to me if competence was to include the need for diversity, for example, and the lived experiences of diverse candidates, then that'd be a good start. Now, I want to emphasize that it takes more than that. But in my view, that's a pretty good start, and that would be including that as a factor of competence, if it has to be there at all.
Thank you. Justice Deschamps, I'm going to ask you a question that actually comes largely from the audience relating to the issue of GLADU. And the question is this: is following the directions of GLADU enough to reduce Indigenous and racialized over-incarceration? Or does there need to be a systemic overhaul? And put another way, are we making a mistake by asking lawyers and judges to deal with these issues? And should we simply turn the whole system upside down and start to build from the ground up? Can't hear you, Justice Laforme. Sorry, Justice Deschamps.
Since it worked for Justice Thomas, I'm going to turn my timer on too. I think I'm a huge fan of GLADU, if that isn't already obvious. And I think what you need to do as a starting point is that people need to push back on some of the problems that I identified in my earlier comments. And I think most important here is the restriction for particularly violent and serious offenses in GLADU. In GLADU, the court said there were serious offenses and some offenders for which and for whom separation, denunciation, and deterrence are fundamentally relevant. Now, too often courts cite this and shut down the need for any sort of GLADU analysis. And if this continues, we will never reduce over-incarceration of Indigenous people. You have to push back on this, and there are 2 principal ways of doing that. The first is to emphasize, as Harry Laforme wrote in Kakekagamic, GLADU analysis must be performed in all cases involving an Indigenous offender, regardless of the seriousness of the offense. And at several points in GLADU, the Supreme Court of Canada made that point. The second pushback is an argument that I've not seen made, but I think has merit. Where the offense is serious or the offender has a bad criminal record, the defense should argue that the restorative view of justice in the community, which GLADU is so concerned about, would not require the same lengthy sentence of incarceration that the Canadian legal system would. Now, this would be most straightforward where the offense is committed in a small Indigenous community. And I can say this having sat through the North, where you're flying into the community and it's a homogenous group of Indigenous people. But that's not often the case. Imagine you're acting for a Métis offender from St. Boniface, Manitoba. He's in a court in downtown Toronto. What view of restorative justice do you consider? Is it the view of the justice from the community the offender's from, or should it be a view taken from the Indigenous community in Toronto? And who's to tell the court what these various perspectives are? Now, I don't know the answers to these questions, but I think this is one aspect of GLADU that really has to be developed. And as far as whether it's a mistake to ask lawyers and judges to address these issues, I'm an optimist. The fact that we haven't actualized GLADU fully doesn't mean that we can't in the future. We can do better. We must do better. And practically speaking, it will remain judges who determine the sentences imposed on Indigenous persons, aided by the submissions and evidence led by counsel. And by necessity, they must remain involved. That doesn't mean that you can't have Indigenous groups and community groups also making attempts to improve the system. But I can say, as a former defense lawyer like Justice Tulloch, Justice Nakatsura, and Justice Thomas, I recognize that advocating for the criminal convicted is a goal that's not particularly politically attractive. Thanks.
Thank you. I'll come to Justice Tulloch in a moment, but I just wanted to make one personal observation about diversity on the bench, and I use diversity in the all-encompassing sense of including not only members of racialized communities, but LGBTQ2+ and disabled judges. And I will have a question about disabled judges in a moment. But what I want to say is that the diversity enriches the bench. It not only serves the public, but it enriches the existing members of the bench by exposing them to new views, new perspectives, new experiences. And I can say personally in my now almost 14 years on the bench that I myself, through colleagues, including colleagues like Justice Tulloch and Justice Laforme, and colleagues like Justice Ducharme on the Superior Court, they have enriched my knowledge and my experience and given me a different perspective on the communities that we as judges are serving. So I want to come back then to Justice Tulloch, and I'm going to put to you something that Justice Nakatsuru said at the outset. He said that he's hugely optimistic about the system and that we have indeed made great strides in the area of diversity on the bench. How do you feel about it, Justice Tulloch, after your years of experience, both as a trial defense lawyer and as a judge? Are you optimistic about what the future holds for us?
I am absolutely optimistic. I can tell you that when I go back to my law school days, there were only 3 Black students in a class at Osgoode of 300 students. There may have been 1 or 2 Indigenous students and not very many other racialized students. And when I go back to Osgoode Hall Law School now, it's a whole different world from what it was then. And these are the pools from which we draw lawyers who become judges. When I was appointed 18 years ago now on the Superior Court, there weren't a lot of diversity on the Superior Court. And now there's a large, well, although it's not a significant amount, there's still a significantly larger numbers than when I first started. And I think that is now being reflected in the law. Because as Justice Nakatsuru stated earlier, a lot of us as judges, we make our decisions based on our lived experiences. And as you've stated, Justice Strathy, based on our interactions with each other as colleagues, which informs our perspective. So yes, I am very hopeful. And I can give you a concrete example, right? And Justice Thomas talked about the RDS case out of Nova Scotia. And the case that went up to the Supreme Court of Canada back in 1997. And that was a case where a Black judge took judicial notice of the social context of systemic racism and its interactions of the day between the police and young Black men. And both the Court of Queen's Bench as well as the Court of Appeal of Nova Scotia pretty much castigated that judge. And that's why, they appealed it to the Supreme Court. And, fast track 30 or 20, 25 years. We have Anderson that just came out of the Court of Appeal of Nova Scotia a couple of weeks ago, which is a case that has embraced, diversity and social context issues within the Nova Scotian community. And that, in my view, is a reflection of a marked difference in judicial approach that is now happening across the country, and certainly in places like Nova Scotia and Ontario.
Thank you. I'd like to see whether I've got several questions from the audience, and I would tell the panelists to put their fingers on the buzzers if they want to answer one of the questions, but we don't have buzzers. So if you're interested in this question, put your hand up. And the question, I'm just going to get it here for a moment. The question is, how can we increase the number of disabled judges specifically? What disability-based stigma exists to being elevated to the bench? Anybody want to take that? I'm content to do it if I don't see a hand up in 1, 2, 3, 4, 5 seconds. So let me respond then to that question. It's a very, very good question. And I think the truth, it's a two-sided thing. I think we have to advocate for lawyers with disabilities on the one hand, and we have to encourage lawyers with disabilities to apply to the bench on the other hand. But what we surely have to do is do a better job in our courthouses of making courthouses accessible to those with disabilities, including not just ambulatory disabilities, but disabilities in relation to sight, in disabilities in relation to audio. We are only now in the Court of Appeal for Ontario, the province's highest court, acquiring a fully accessible courtroom, both for the public and for the judiciary. And it's a significant expenditure of capital, obviously, but until we're able to equip courtrooms properly for judges, advocates, and members of the public with disabilities, there are going to be physical and other barriers to appointments. So it will take that kind of impetus. I'm going to come back to another question, and I'm going to ask Justice Thomas to speak to it. And that is, a question has been asked, could one of the panelists speak to the need for cultural competency, specifically in the Crown system? And what more would they wish to see from Crown prosecutors appearing before them in their role of ministers of justice or government policy makers? Justice Thomas, were you prepared to pick up that question?
Yes, so I think as a recently former defense lawyer, I can tell you that I appreciate the responsibility and that the Crown's office has. So when a Crown is looking at an individual case, whether it be the victim, the complainant, or the accused person, they really should understand the circumstances of that person. And again, just like the bar, like the judiciary, there isn't the same kind of representation. So the education component is so necessary, more so in the Crown's office, I think, than even the defense bar, just because of the responsibility and their powerful duties to decide how cases proceed. So I think, if anything, that's probably where the education, along with judicial education, is so necessary on cultural competency.
Justice Laforme, did you want to add to that?
Yeah, if I could, and it goes to what Todd was talking about and Gladue. One of the things that I think is really, really important is for Indigenous people from the northern communities to want to be Crown prosecutors, that want to be judges on the provincial court, for example, because I think a large part of what's happening with the overrepresentation of Indigenous people in our prisons comes from the fact that nobody really knows or has alternatives to prison, which is a big part of what GLUDU talks about. What are the alternatives to prison? Well, there aren't any, but it seems to me that if you have Crown prosecutors who come from those communities, for example, and you have judges that come from those communities, they will appreciate what GLUDU really talks about. And I think that could make a contribution towards reducing the number of over-incarceration. Okay.
Thank you very much. I know, Justice Tulloch, you have your hand up. I've got the signal from our organizers that I'm getting the hook now. I do want to thank the panel. You're a wonderful group of colleagues. It's been just a great personal experience and privilege to work with you. Thank you for all your contributions.
Thank you so much for this incredible panel right before our closing. I want to thank Chief Justice Strathy, Justices Tulloch, Laforum, Ducharme, Nakatsuru, and Thomas. So many things came out of this incredible panel, but to highlight just a few, I have to say when I was a budding law student and then became a lawyer, struggling with accepting consistently that judges were human beings and they weren't perfectly objective and able to distance. And to hear all of you speak with such humility about the fact that judges not only bring their own lived experiences, perceptions, and biases to the work, but that greatly informs the ability to make a fair decision. And in order to have more fair decisions, we cannot underestimate the importance of judges who represent different communities and understandings that will give a more fulsome picture to the facts that are put before them as a trier of fact, right? It was powerful to hear you as judges talk about what it looked like for judges that represent a diversity that was unseen in our judiciary, to bring forward not only issues that their communities face and their lived experience taught them, but to prioritize the issues of other groups that have been underrepresented. And it was powerful to me to hear you say that that is also an extraordinary demand for the people that are doing so much of this equity and diversity work in every part of the legal sector. I can tell you the demands on people that are carrying the work are often people that were underrepresented and are doing all of the work over and over again in addition to their day jobs. And so to think about the demands on the time of our judges being enormous. I think the last thing that struck me so much is the question of whether or not, even if you change the players, is the system one that requires a complete systemic overhaul. I remember many years ago, we changed something in a university I worked in, and a student said, yeah, you changed a little thing, but it's kind of like having a better meal in a residential school. You haven't changed the system, but our lunch is better. And so I always think about what it looks like to commit to that systemic change. And I think what we've seen today in our panels about reimagining what new normal is and talking about the vaccine and vaccine apartheid and thinking about mental health and challenges. And now to hear the deans of law schools talk about what we're doing in the legal sector as we train our students to be different lawyers, to be lawyers who adapt to new realities. I think what we have to ask is, does the systemic change happen first in the judiciary, or is the judiciary the last sort of symptom of a society that needs a much bigger systemic overhaul? So thank you for all of your words, all of your wisdom, and we're so grateful to have had you here today. We're going to now move to the last session, our closing plenary. I couldn't be more excited, especially to follow these incredible justices who have graced us with their presence today. The last is a dynamic roundtable with all the deans of several Canadian law schools as we reimagine legal education with an EDI lens, a thing that is nearest and dearest to my heart. Hosting this powerhouse session of people is none other than my co-MC, Sean Richard. So I'll let you take it away, Sean.
Thanks, Tony. Welcome to the final and very important panel because it returns us to the roots of this conference. Today, we have the deans of nearly all of Ontario's law schools. So in no particular order, I have Eula Hughes from Bora-Laskin Faculty of Law, Donna Young from Lincoln Alexander School of Law, Mary Condon, the Osgoode Hall Law School, Mark Walters, Queen's Law, Yuta Brunei University, Toronto Faculty of Law, Erica Chamberlain, Western Law, and Reem Badi, Windsor Law. Welcome, all of you deans. This is great. So, you're all remarkably accomplished in the interest of time. I'm directing everyone to view their bios for more information about their many accomplishments, because we want to get through to these questions and hopefully have some questions at the end. All right, so here's the structure for our panel. First, the deans will make brief preliminary remarks about EDI and their respective law schools. Then, in the second part, I'm going to pose a few questions to foster what I trust will be an important discussion amongst all of you. And finally, we'll have a Q&A, some of the questions that the participants bring forward. So why don't we start with Dean Boddy? Please provide your opening remarks.
Sure, thank you very much. And thank you to Ryerson for hosting this wonderful event and for including us as part of this panel. So I'll start my remarks from who I am and where I'm situated. And I'm the first and only tenured Palestinian law professor in Canada, and so the first Palestinian law dean in Canadian history. And I'll just start with the observation that I know is controversial to some, but that representation matters. And if I didn't think that it mattered, I wouldn't have taken up office. And I was so grateful for the outpouring of support that I received from across the academy and across the profession when my appointment was first announced. I was actually stunned by it, really, to be fully honest. And for me, this outpouring of support really signaled that diversity was a statement of possibility for a lot of people.
This is not good.
But as has been, I think, already stated in some of the panels and certainly in the judicial panel before us, the question is, what does representation and what does EDI more broadly stand for? Is it an indicator that the collective is ready for inclusive, transformative change across the institution? Or is it, as Ronaldo Walcott, I think, argued earlier today, a way of slowing down change by pointing to a few different bodies without really changing systemic structures? And I don't know the answer to that question. All I can say is that I feel a deep responsibility and commitment to advance Windsor Law's social justice goals. But none of us can succeed alone. As deans, we have to lead from behind. And if representation is going to be part of a larger transformative institutional change package, it has to be part of other commitments like changes in conditions and terms of employment. These things have been discussed. Ensuring an inclusive curriculum, we're going to talk about that in just a minute. And I'll just close by saying, if we don't take on these structural changes, at the same time that we bring people into the institution, we risk actually inflicting some serious harm on those who we invite in and promise that things have changed.
Thank you for those remarks, Dean Boddy. Dean Chamberlain, why don't you take over from here?
Sure, thanks. And thanks very much to Dean Donna Young for inviting us all here for this panel. I'm looking forward to our conversation today. I want to pick up on Chief Justice Strathy's comments actually toward the end of the last session and say a few words about how law schools deal with issues related to disability, because I don't think those often get the attention they deserve. Students with disabilities make us think about our physical space as well as some more profound questions, I think, about our curriculum. In terms of physical space, at Western Law, we've struggled with the fact that we're housed in a relatively outdated building with multiple elevation changes and a lot of circuitous routes around the building. And this makes the building very difficult to navigate for students who have mobility limitations or visual impairments. It interferes with their independence at the law school and makes them feel unwelcome. And it's equally problematic for members of the public who come into our building, including clients at our legal aid clinics and those who come to use the law library. Those issues themselves aren't all that complicated, but they do require some commitment from our universities to invest the funds to make all of our buildings more accessible. What's more complicated, I think, are questions dealing with students who have mental illness or learning disabilities. Some of these we deal with through accommodations, and I think that most of us are relatively familiar with those processes. But what about thinking about our curriculum itself? To give an example, I think that most law schools have some kind of mooting requirement prior to graduation on the premise that any competent lawyer should be able to give oral arguments before a court. So what do we do when we have students now with severe anxiety, for example, for whom mooting is an incredibly difficult experience? We could excuse them from that requirement or find a different way for them to complete it. But maybe we need to start asking ourselves why this is a requirement at all, or if it's something that's, outdated given the many different careers that our students pursue following graduation. Ask whether it truly is still a critical competency for everyone who graduates from law school. And I think that's a question for law schools and the profession to ask. Our accreditation requirements, our licensing processes are predicated on a set of baseline competencies that tend to assume that our graduates will go out, and hang up their own shingle, which I think is outdated and inaccurate and maybe unduly limiting for some people. So that's my opening remarks, and I look forward to our conversation.
Thank you, Dean Chamberlain. Dean Brunet.
Yes, thank you. I also want to start by thanking Dean Young and Ryerson for organizing this really important event, and I'm very glad to be part of it. And I want to take a slightly bigger picture approach and begin with the proposition that as academic institutions, we strive for excellence. And that quite simply means that EDI is central to our mission, and it therefore needs to be part of everything we do, because excellence and diversity go together, because excellence thrives when we bring together different perspectives, lived experiences, and identities. But it's not actually just about making law schools as imaginative, creative, and productive places as they can be. After all, the core of faculty's missions is to teach lawyers and leaders for a changing and challenging world. And so one key dimension of that mission, it seems to me, is to enable our students to think critically and from different vantage points about the role that law and lawyers play in shaping society, including in dismantling systems of institutionalized racism. As lawyers, law teachers, and law faculties, we have a distinctive role and a distinctive responsibility to understand the challenges and to hear other viewpoints, even as, or maybe actually especially because they are unfamiliar and quite possibly uncomfortable. That also, I think, makes our students better lawyers. So how does one allow for all of that to happen? I think we'll talk about this as we go along, but to return to my starting point, it seems to me that it means that EDI has to really animate all aspects of our work, from recruitment and then support of a diverse student body to a curriculum that enables that critical thinking from different vantage points, to engaging faculty, students, and staff in EDI, perhaps the biggest challenge to really do that in a sweeping way, and also recruiting faculty with diverse backgrounds and approaches. Now, at U of T Law, we're working hard on all of those things. It's a work in progress, but I think actually that that's a good thing, because there isn't really an endpoint to this work.
Thank you very much for those comments, Dean Brunet. Dean Walters, you're up next.
So thank you, Sean and Tony and Donna, for having us on this panel. It's a real privilege to be part of this important day. First, I'll just echo everything that my colleagues have just said. As I've been thinking about this topic, I've realized now that I'm approaching the halfway point in my first, and I hope it's my only term as dean, just over 2 years, and EDI has been a dominant feature of my time as dean. However, it's not a new topic. It's an old topic in many ways. As a law student here at Queen's in the late 1980s, the entire place was gripped with intense debates about what we would now call EDI, but we didn't have that acronym then. The acronym doesn't change anything, or maybe it does, I don't know. But I think back to the work of my professors, Sheila McIntyre, Kathy Leahy, and the like, who were groundbreaking scholars in the area of feminism and the law, sexual orientation in the law. I think of my fellow students, Trish Montour, a Mohawk woman who became a wonderful legal academic, was extremely critical of our legal education from an Indigenous perspective. And these debates produced change at the time and in subsequent years, small, maybe incremental steps, but in the long run, meaningful steps for change. So EDI isn't new, or is it? I mean, there has been a shift, I think, maybe a paradigmatic shift in public discourse over these issues just in the last little while. And you know, as a concrete example, I started my deanship going into a building that was called Sir John A. Macdonald Hall. And I didn't think we'd ever get that name off, and I didn't know whether it needed to be removed. Within 8 months, it was clear that was the right decision to make. And the interim changes in public discussions were pretty phenomenal during that year, 2019, 2020, with the Black Lives Matters protest, et cetera. So a pretty significant change in public discourse. And I think as law schools, we're all just coming to grips with the full implications of what those changes to that public discourse surrounding these issues means for legal education. So I'm just grateful to be part of this important day. So thanks.
Thank you for those remarks, Dean Walters. Dean Condon.
Well, thank you very much, Sean. And again, you know, my thanks also to Dean Young and to the Lincoln Alexander School of Law for convening the day today and this particular panel as well, where we can all share our perspectives on EDI issues. And again, of course, some of the comments that I would make, I think, have already been made by a couple of my fellow deans. When I think about EDI, you know, I do think that it's important to pay attention to the fact that as a label, it has, you know, really a significant number of different component parts, some of which have been alluded to by my colleagues. You know, so one component is reckoning with the injustices that have been imposed on Indigenous people in Canada and the efforts to resurface what an Indigenous approach to law and legal norms might look like. And I know there were earlier panels today that talked about that very compellingly. And then there are obviously other ways in which the legal system has been implicated in systems of systemic racism as they have affected Black people in Canada and other people of color. Dean Chamberlain just talked about issues facing people with disabilities, which is again an emerging area. I think that that legal education needs to pay close attention to. We've got inequalities based on sexuality, LGBTQ2S people who have been treated unequally through the legal system. So, you know, so there's a range of different meanings for EDI that I think as legal educators we need to be grappling with on all different fronts. And as Dean Bernays said earlier, I think we need to be grappling with those through a range of different cross-cutting activities in our respective law schools. You know, Osgood's recently developed a new strategic plan in which we have identified a number of focus areas, at least two of which I think engage some of the questions that we're speaking about in this panel and earlier today, one being questions of advancing reconciliation and justice, and the other being issues related to student access and success. And so, you know, so these issues play out with respect, as was said earlier, to diversity in faculty hiring. They play out very significantly with respect to changing curriculum. And I know I won't say too much about that because I know we're coming on to a specific discussion about that in a few minutes. But on questions of student access and success, you know, I think it is important for us to acknowledge that, especially with respect to equity-seeking students, there could be barriers to success that they face both within law school and legal education, but also as they confront joining the profession. And so, I think it is important, and certainly it's something we are at the moment thinking about at Osgoode is gathering more data among or about our students in terms of really trying to understand what are those barriers to success that equity-seeking students face and trying to overcome them. I mean, it's obvious that one of those is going to be financial challenges, but I think there are other issues related to the way in which we prepare our students to leave our law school and join the profession that I think we can address collectively. I also think, just in closing, that one of the biggest challenges that certainly I'm thinking about at Osgoode is what is an appropriate infrastructure that will allow us to really advance along all of those issues at the same time. Is it a case of identifying a single person at the school who is responsible for advancing a number of EDI initiatives, or is this a collective responsibility across colleagues, across our staff? And I'm sure we all share the experience that many of our staff are extremely committed to these issues as well on behalf of students. So, so I think that's certainly one thing I'd be very interested in others' comments on is how that infrastructure can be embedded within an environment to make sure that progress is made on a number of fronts as soon as possible. Thank you.
Thank you, Dean Condon. Dean Young, you're up next.
Thank you, Sean. So as the host of this really wonderful conference, the Lincoln Alexander School of Law has already had ample opportunity to show our stance on EDI. And so I'm going to take this moment to welcome and thank my fellow deans. And I would like to say something that was really made clear to me over the last year and a half. And that is that the law deans of Ontario and elsewhere in Canada are really exceptional. They are an exceptional group of thinkers and scholars and administrators, and they are profoundly professors at their core, and they advocate for their students in the and they're committed members of the legal profession and the academic community. And so instead of kind of reiterating some of the things that have already been said about Lincoln Alexander, I want to highlight some of what I just heard my colleagues say. And there are words in this, and it has so much meaning, and it shows what their commitment and their deep thought about EDI has been. They've been talking about responsibility and commitment, a critical lens. They've talked about outdated concepts and the centrality of the law school's mission, old topics of discussion, groundbreaking, meaningful steps for change, the importance of public discourse and reconciliation. They're talking about critiquing legal norms and how the law is implicated in systems of discrimination and oppression. They've talked about access and student success and a collective responsibility. And so one of the things, I'm not going to say much more, but I just want to say that this panel discussion is super important. It's important for the legal community. It's important for the communities that we represent. And I'm just absolutely delighted that this group of really distinguished speakers, along with our other distinguished speakers, have taken the time on a Saturday to talk about all of this. Our weekends are all precious, and I just want to thank you all for joining in this conversation.
Thank you, Dean Young. And Dean Hughes, certainly not least, though you are last in the opening remarks.
In the North, we're used to being last and sometimes forgotten, so that's okay. Good afternoon. Thank you very much, Donna and the Lincoln Alexander's Faculty of Law for organizing this event, and thank you for the opportunity to participate. And it's really a pleasure to be here. I'm speaking to you from the traditional and treaty territory of the Fort William First Nation, a signatory to the Robinson Superior Treaty of 1850. And we're all learning a lot about the Robinson treaties lately, reading Ristoul. The Lincoln Alexander Faculty of Law is the first law school in Ontario to follow in the footsteps of the Boralaskin Faculty of Law to offer an integrated practice curriculum. Welcome to the club. We do hope that this is a growing option for students. We sometimes talk about the articling crisis in Ontario as if that had been affecting all law graduates in the same way. And instead, we really know that it has been affecting racialized students, mature graduates with disabilities, equity-seeking groups generally far more than anyone else. Articling really has operated as a discriminatory barrier to entry to the profession. And alternatives to articling can operate to create more equal access. The integrated practice curriculum also shortens the path and moderates the financial burden of legal education, as our graduates don't have to wait another year before becoming licensed. And this matters, in my view, because wealth inequality is another significant barrier to entry. For me, the biggest lesson of the integrated practice curriculum when we're thinking about EDI in legal education is that it's just not enough to welcome diverse students and faculty as long as they fit themselves into the existing mold. In a public lecture at Dalhousie University in 2018, Angela Davis said this much better than I can, so permit me a quote if you would. She said, "To create a sense of belonging among the oppressed requires creating a world worth belonging to." Should Black people want to be included in a society that remains just as racist as it was before they were invited to join? Should Muslims want to be included in a society that remains Islamophobic? Should women be invited into a world that remains as sexist and misogynist as before? Should disabled people be embraced by a society that continues to perpetuate its ableist practices? I think if we read law school in all the places where Dr. Davis speaks about the world and society, we get a good sense of the collective challenge that we as law deans face. The important step, to my mind, is allowing ourselves to be transformed by diversity. That is never an easy process, and it really is challenging, and I think, Donna, you will agree, it really is challenging to do things differently. But it is also tremendously enriching, and it is necessary. Thanks, Sean.
All right, well, I'm going to lead off with a question inspired by your response about the environment of law, specifically law schools. And here's the question. Are law schools a safe space for persons living with disabilities, racialized students, female students, and racialized and or female faculty?
Well, I'll get us started, Sean, if I may.
Please.
So I think making law school a safe space, right? A space where students are and feel safe is a really important objective. And students are completely right to advocate for that. And there's lots of empirical learning theory that shows that you can't learn if you're not feeling safe. Also, many of the threats to student safety are really material. They're about housing, they're about food insecurity, they're about family violence, they're about those kinds of challenges. So sometimes when we talk about safe spaces, what we're talking about is really a subset of ways in which people are unsafe, right? Being made unsafe through speech in particular. And when we're talking about that subset, I think we have to acknowledge that law schools are collective spaces. And so it's important that we don't make some kind of grand claim about law school being a safe space, in the narrow sense that we can't keep speech out that may make people feel unsafe, right? And still, it matters, I think, that we talk about how creating a learning environment that feels safe might inform legal pedagogy, and that we talk to students about how hate speech, discriminatory speech, affects the safety or the feeling of unsafeness of other students, right? So let's not overclaim what we are doing as law schools, but let's commit ourselves to striving for that as something that is worth aiming for.
Dean Young.
Thank you. I just wanted to register my complete agreement with that. It was, and I think it is undoubtedly the case that law schools can be both safe spaces for some students and not others. And in all of, in explaining this question in the way that Dean Hughes explained it, I think it's really important to understand what having a safe space means. But I'd like to also talk about how, and we've seen kind of vestiges of this in some of the earlier panel discussions, about how the term safe space has been used politically by people, both liberals and conservatives, right, to kind of denigrate student activism and to essentially minimize some significant critiques about higher education. And so we know that students, the critics, label student activists as those who are abandoning a robust debate about free expression, and they're anti-free expression, and they're demanding things that is, that shouldn't be abandoned in a higher education. But students are essentially saying that there has been a historical failure to root out systems of oppression within higher education. So, for example, white supremacy and systemic racism on campuses. And so we have to kind of take back that label, safe space, just as we have to take back critical race theory to say that it is not what the critics are saying. All of our students require safe spaces in order to learn, and we're not going to get be forced in a position which is not really the position, and that is, no one is really arguing that people must be silenced at all costs against all academic freedom. It is that a learning environment must be safe, both physically and intellectually, in order to be able to vigorously debate issues and to talk about really difficult subject areas, especially when we see that those subject areas permeate different areas of the law. And so we need collectively to provide those spaces to our students, all of our students.
How do you create those spaces?
Would you like me to, is that for me, Sean, or is that for others?
That's for anyone who wants to engage.
I'll start if that's okay, but I know that my fellow deans have other things to say. It kind of goes back to experience, right? And I was a law student way back, it's actually my 30th reunion right now, from my graduation from Osgoode Hall, where, by the way, Lincoln Alexander was the speaker, the invited speaker. But anyway, and at the time, my experience was not reflected in the curriculum or on the faculty or, in the student body. And it didn't always feel comfortable or safe or conducive to a really important, kind of an appropriate learning environment. And so I think that law schools can do a lot to change things, both very materially. So Dean Chamberlain talked about the physical environment actually getting in the way of the ability to educate all students, right? So there's that. We can also talk about the curriculum and evaluating the curriculum very critically to make sure that we are really talking about excellence, which is what Dean Brunet talked about. You have, in order to achieve excellence in education, in order to commit ourselves to it, we have to diversify our curriculum. So I think that there are lots of different ways of creating that safe space without making that term a bad term, right? Let's talk about what it really means and not what the critics are telling us it means.
Dean Condon, I see you have your hand up.
Well, thank you very much. And I was just sort of inspired really by some of Donna's comments to join in this conversation. And certainly, as she just said, I think it's important to think about that issue as it plays out both inside the classroom and outside the classroom. So, with respect to inside the classroom, I certainly know that, all of our colleagues, to varying degrees, are becoming more and more attentive to the way that they set up issues that are being discussed, in the classroom, whether it's sort of in, issues of racism as they play out in the criminal procedure context, or it's issues of whether different areas of law make space for discussing questions of disability and how they may, and how particular doctrines may impact people with disabilities. So, so I certainly think that what's interesting about the safe space discussion in the classroom is how it connects to, the fabric of legal discourse, which is, indeed Donna made this point earlier today, is about, disputes and talking about how there are sort of two sides to issues and how you then make sure that in the context of that kind of advancement of the adversarial method, that you maintain an approach that allows students to actually debate, but also contribute from their lived experience. Outside the classroom, I certainly think that we've all probably understood the importance of giving support, both tangible and intangible, to various student organizations that are organized around equity-seeking goals. So whether it's the Muslim Law Students Association or the Black Law Students Association, the Indigenous Students Association, I think there are very material and very basic things that a law school can do. And I think I'm quite sure we all do it to foster the opportunity for groups of students to, find those spaces where they can they can feel that their own particular ways of looking at law and ways of being law students and thinking about their connection to the legal profession can be fostered and can be explored.
I want to take us to an area that has already been mentioned briefly in remarks, and that is curriculum. And so let's start with this general question. Is curriculum changing in response to EDI issues? If so, how is it?
Well, I might just, again, I don't want to monopolize the floor, so I'll be really quick. But I think it is absolutely the case. I think there's no doubt that curriculum is changing. Again, when you think about Call to Action 28, and the recommendation to law schools that all students be exposed to Indigenous ways of thinking about law. I think we have all, and again, I don't want to speak to my fellow deans, for my fellow deans, but I think we've all responded to that. In particular ways. At Osgood, we've responded to it by making it a mandatory requirement that all graduates have taken at least a 3-credit course that exposes them to Indigenous perspectives on law. Certainly the very productive relationship that we have with our Black Law Students Association at Osgood was a very important spark to introducing an anti-Black racism module in our first-year ethical lawyering course. And, we're delighted that we have now hired a new faculty member who has taken on the task of designing that module and thinking carefully about how it is being introduced into the first-year curriculum. So there are other initiatives that I'm sure my fellow panel members can speak to, but I certainly think that curriculum is responding. I think the issue for faculty members as a whole is, that it's happening at different paces in different subject areas, and making sure that it happens in all subject areas, I think, is the challenge that we're grappling with.
Yeah, I'll jump in just to add, agree with everything that Mary has just said. We've had a mandatory access to justice course at Windsor Law for about 25 years. And what really strikes me about that course, having been one of the people who taught it at the very beginning, is how the meaning of access to justice has changed and transformed over the years. I think less and less we're talking about it simply as access to legal institutions, and more taking a critical approach to doctrinal law, to questions of legal procedure, thinking about how these structures impact different groups and different communities, and thinking more about the impact of law more broadly. And so it's not just about the new courses that we've introduced, it's also about how we approach longstanding and existing courses rather, that I think has been quite evident and important over the last at least 5 years.
Does anyone else want to comment on this? Otherwise, I'd really like to zero in on something that Dean Condon mentioned at the end of her remarks about EDI and all areas of curriculum is a particular challenge that you're dealing with. Can we hear some remarks about that challenge and other challenges facing law schools or grappling with curriculum and EDI?
Mm-hmm. And maybe I can start on this. I mean, I think that is probably one of the biggest challenges. It is, I think it may be aided by the kinds of things that others have talked about, for example, introducing a course that responds to the TRC call for action. Or so in our case, for example, we initially tried to respond to the call by integrating Indigenous perspectives, or calling on colleagues to integrate Indigenous perspectives into all courses. And that has gone relatively well, but it is challenging because not everybody necessarily feels comfortable. So there's a sort of oftentimes mixed in, I'm not really well placed to do this. And so, but my sense is that it's a kind of an interactive process. The more it's modeled, the more, for example, so our plan now is we're currently talking about the introduction of a mandatory course, but that's not meant to indicate that having Indigenous perspectives in other courses is no longer an issue. It's meant to provide an anchor and provide resources and so on. So I think that's really key. Other challenges that I would mention, so I think lack of confidence in terms of competence among colleagues is definitely one, which means that whatever we want to do in the curriculum with respect to EDI needs to be supported with other initiatives that engage faculty and staff and students and kind of make the boat rise, if you will. But I guess let me just put a couple of other challenges out there on the table, and others can pick up the ball if they like. So, I mean, obviously there are challenges from the outside. I think today we already heard about the benchers and kind of resistance to critical race theory in the curriculum. And then there is one that came up earlier already in the panel, that of course there will be some who say, I'm not going to be told by anybody how I will teach my course because of academic freedom. So these are all, I think, complex issues that I think we're making progress on, but that we're not quite there yet.
Mm-hmm.
Dean Chamberlain, I saw you had your hand up.
Yeah, thanks. I think this is a really exciting issue, actually, the idea of embedding EDI questions across our curriculum. And I think that's what, to be honest, makes me excited as a teacher and as, a scholar too. And I think we have now, we have colleagues who are, I think, interested in and deeply committed to embedding these questions in the courses they teach in different ways, right? It may not be the same for everyone, and different issues come up in different classes, So I've been teaching torts for 16 years, and a couple of weeks ago, we were looking at the defense of legal authority and the idea that, law enforcement are allowed to commit acts that would normally be battery or false imprisonment or trespass to property. And in the 16 years that I've been teaching that, it's changed dramatically, right? So the cases that we look at, we look at a lot of the same cases, but they've taken on a very different light, given quite radically, I think now, given the issues that we're aware of in terms of racial profiling by police and excessive force. And so, it makes the old law exciting again, I think, for us as instructors, and it means that we keep learning from our students too. And so I think that's something that's actually really exciting about the curriculum right now.
Dean Walters.
Yeah, just very quickly, in terms of incorporating Indigenous issues into the curriculum, I think one of the challenges that we've all confronted in one way or another is the importance of linking what we do with local Indigenous communities and ensuring that what we're doing is not disconnected from the very communities who we purport to be, in a sense, hoping to serve in some way. And so that's just it's a very important but complex challenge, because these are often communities that are struggling themselves. They don't have the resources to participate in law school courses twice a week or whatever. And yet having them involved in the conversation about how we teach their traditions is really extremely important.
Dean Hughes, and then I do want to get to one of the Q&A questions, one or two if I can.
Sure. Just very briefly, I think one of the drivers of curricular innovation is also that a significant change in the way courts are approaching these issues. So whether a professor thinks that this is the right thing to do or the wrong thing to do, that is a ship in many ways that has sailed, because when the Supreme Court of Canada starts talking about racialization as a significant issue, we're going to have to respond to that. And I think that's an interesting development, because in the transition between the last panel to this one, I think Tony asked the question about, is this something that should originate in the judiciary, or is it something that originates in the law schools? And I think in some ways what we're really seeing is that this is a highly dynamic interaction where a lot of drivers are operating towards pushing us all collectively towards taking EDI as a perspective much more seriously in everything we do.
One of the questions that actually seems to be recurring is one that I already had on my list, and that is, all right, so you're dealing with trying to integrate EDI into curriculum, and you've talked about the challenges. One of those challenges was discomfort. What do you do when it's not discomfort? But the challenge is a professor who says, I'm not doing it because I don't want to, on the basis of academic freedom. How do you balance that individual academic freedom with institutional desire to address issues of EDI?
Sean, one of the things we often talk about with the students is that that's the place of law, right? The place of law is to sort out when we don't agree and to sort that out in a good way. When we talk about Anishinaabe legal orders, we talk about really the meaning of law being living a good life together communally, right? And so that includes a way of understanding that we need to resolve our differences. And so, I think we look to the law to help us do that. So we know that collegial governance provides a forum for negotiating between individual academic freedom and course descriptions that senates approve and that we embed as part of a curriculum. So I think we do have those mechanisms, and it's also in itself a lesson in the working of the law that we find these mechanisms.
Dean Walters.
Yeah, I would just follow up on Eula's point. That is precisely, I think, how to deal with it through the mechanisms of governance that we have in place, and then recognizing that it should never be a simple binary between academic freedom and EDI. That academic freedom isn't an isolated and absolute thing. It comes with responsibilities, and I don't know about other places. We have a collective agreement that identifies both academic freedom and academic responsibilities, and they need to be integrated together. And if there were a faculty member who just said academic freedom means I can ignore EDI, then we'd have a real problem, because they wouldn't be doing their job as a law professor anymore. It's just not possible to separate these issues out from the law. They're just embedded in what we do and how we teach. And there will be contested approaches and different approaches about how to deal with these issues, and that's to be expected. But I think viewing this more as a holistic, and rather than as something set up as an opposition between different perspectives is the important thing, I think.
Final chance for anyone who'd like to comment on this issue.
I'd maybe just say briefly that, it's when we do this through collegial governance, when we express our kind of collective aspirations and our collective values through collegial governance, that's the most powerful way to do it, right? Rather than having a dean or some kind of university staff person tell people what they have to do. I think it means a lot more when it's coming from the entire academic community.
Great. So our time, sorry, Dean Condon. Would you like to make the last remark?
Just very quickly that, from my own personal experience, I haven't encountered, sort of active resistance in this way, particularly what I think is often a more frequently encountered issue is the one that was raised earlier, that people say, well, I'm not sure, that I know how to teach this well. And so I would just offer that, one of the things that one of my colleagues has done really beautifully for us at Osgood is collect a range of materials that can be used as resources. And just offered two colleagues sort of separated by different areas of law. So, and again, it's just really by way of offering support to people to get started on the exercise of making sure that you can incorporate these sorts of materials into your course outline. Sorry for the delay.
It's okay. I think it was a great point to end on. We've seen the theme of competence generally in EDI issues as being a barrier, not just for professors, but for legal professionals, whether they be lawyers or paralegals, for judges. We heard that on the judicial panel as well. It seems that it's something that we're all grappling with in order to enhance access to justice generally for the people who we serve. Thank you so much, Deans, for your time today and for openly sharing your successes, your struggles, and where there can be further growth. I look forward to hopefully another panel. Maybe in a couple of years, you'll come back and talk about how things are progressing, specifically in the area of persons living with disabilities. I think that is an area that is ignored generally, and is a place where we can do much better. So I'm going to pass it over now to our conference chair, the Honorable Chile Ebo Suji, to provide some closing reflections.
Thank you. Thank you very, very much. Many years ago, when I was studying in Montreal, there was a certain TV jingle that used to go on this local CTV. And the musician was Luba, the Canadian singer, and this song was "Nowhere Else Would I Rather Be Than in Montreal." Now, this is not about being in Montreal. This is about being here on a Saturday. And nowhere else would I rather be today than here all these hours discussing this very, very important subject. It's been a fantastic conference in every sense of that term. It ended with the leadership of Ontario's academia discussing how to make EDI a reality in the legal curriculum and in law schools. It started with a phenomenal speech by Justice Jamal, and in between we had a lot of great insights, experiences shared, and ways forward. For me, and I hope we can agree to this, I mean, Sean asked that question of the deans: how do you create the safe space for diversity at the law schools? Actually, that question defines the whole thing about EDI. And the answer to it, in my view, we can all discuss this another time. And by the way, Sean, I'm sure there will be another conference on this. But the answer from my perspective would be what Dean Grimbadi, in her opening remarks, so she phrased it very elegantly, but I think it was the point about the exploration of possibilities. I mean, she used a better, a more elegant phrase to put it, but that's really what EDI is about. It's about pursuit of what is possible to make society look like itself, to reflect society in itself in the different ways that matter. And it is about possibilities. There was a discussion about 70 years ago, in 1970, was there one woman in the law school or two? Now, imagine now that kind of question. Something happened to make the law school population what it is, to make the law school leadership such that most of the deans are women leaders, so that we now have also somebody who is not white on the bench of the Supreme Court of Canada. It is all about possibility. When people put their minds to something that's important, they do find a way of doing it. It's about leadership and commitment to doing that which is important to be done. Where there's a will, there is always a way. It may take a little longer, but it eventually gets done. Nelson Mandela was the one who said, it always seems impossible until it is done. And that is, in my view, the story of EDI. Now, it's been a fantastic conference, and we've seen a lot of fine heads on screen, but I think it's important for us to acknowledge those who put this thing together, who made this great thing happen. We didn't see their faces on screen, but at least we can mention their names. Charmaine, who was the team leader who organized the thing. Reka, Julia, Dana, Daniel, Eden, Anthony, Nick, and Terrence came from Bespoke Audio Visual. Without them, I don't need to overstate the proposition. This would not have happened, and we owe them that much great of gratitude for making it happen. And I thank them, and I thank all of you, fantastic panelists, speakers, for being with us today. Again, as I say, this is the second in the series, and I'm sure there will be more to come. Thank you, and I'll hand the microphone back to the MCs of the conference, Sean and Tony. It's a great pleasure doing this. Thank you.
Thank you so much, Chile, for your leadership and your vision and what you've brought to our school. Before we sign off and let you go, we want to thank two groups, the advisory committee and the organizing committee. This takes literally just a massive amount of people and commitment. And I will reiterate, Chile was so beautiful to name all of the people, but were it not for Charmaine McKenzie and Rika Sarasavan, we would not be here today. Chile, can you mute for a second? There you go. We'd like to thank also our Legal Voices conference sponsors, PLG, Lenkinski, Carr, and Richard, and the amazing Richard MC, I will say, McCarthy Tétrault, Blake's, Osler, Manulife, and TD. We're very grateful for the sponsorship. It helped us to make this come together. And just thank all of you for joining us today. We recognize it's a Saturday. It's a Saturday in November. It is cold. It is dark. Folks are tired. We are working very long hours. And we're very grateful that people made this such a priority. We hope to see you very soon. We want folks to know that recordings of all the sessions today will be available within the next few weeks. So if you had to miss one or duck out, you'll be able to watch it and share it with family and friends over the holidays. And in the meantime, we leave you with a very short video featuring our students about what it means to be a Link lawyer. And we're just so grateful to have had this opportunity. Thank you.
I don't want to be just another lawyer. I want to be a Link lawyer.
One who advocates for inclusivity,
Amplifies the voices of the unheard.
Innovates the legal profession.
Breaks down barriers.
And expands the reach of justice.
One who advocates for a better world.